The committee met in executive session earlier today, but we don't know what was said.
The committee will come to order, and counsel will call the first witness.
Mr. John W. Dean III.
Stand up and raise your right hand. Do you swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, so help me God.
Now, you are accompanied by counsel, and I would ask, your name is John W. Dean III.
That is correct.
I would ask counsel to identify themselves to the record. You may be seated.
Mr. Chairman, my name is Charles N. Schaffer. I'm from Rockville, Maryland. I'm one of Mr. Dean's counsel.
Mr. Chairman, I am Robert C. McCandless of Washington, D.C., and I, too, am one of Mr. Dean's counsels.
I would like for the members of the committee and the witness and counsel of the witness to pay strict attention to what I shall say. Mr. Dean appears before the committee and has appeared previously before the staff of the committee in obedience to subpoena from the committee. Mr. Dean at all times has claimed that he is privileged against testifying by the self-incrimination clause of the Fifth Amendment on the ground that any testimony he might give to the committee concerning the matters the committee is authorized to investigate might incriminate him. And therefore he appears involuntarily. The committee has unanimously requested, in times past, requested His Honor Judge John Sirica, Chief Judge of the United States District Court for the District of Columbia, to enter an order of immunity for the witness under the provisions of sections of 6002 and 6005 of the Title 18 United States Code. The committee, pursuant to those statutes, gave 10 days' notice to the Attorney General of his application to Judge Sirica, and at the instance of the Attorney General, Judge Sirica delayed entering an order until more than 20 days thereafter had expired. He then entered an order of immunity under the statutes. And Mr. Dean is now informed of that fact and has previously been informed of that fact, and that he is testifying under this order of immunity granted in the instance of the committee. And he appears here involuntarily as a witness pursuant to this order, and he has heretofore been ordered by the committee to answer the questions, and he has all the testimony he's previously given to the committee staff, and all of the testimony which he may give to this committee is given by him on the basis of the order of immunity. Is that correct?
That is correct, Mr. Chairman.
Now, if there's no objection on the part of any member of the committee, the chairman will find his statement to be the facts on behalf of the committee.
Mr. Chairman, I might say, just for the completion of the record in that respect, it's also my understanding that in addition to appearing in response to subpoena, and after having claimed his constitutional privileges, after the attachment of use immunity, as the chairman has just indicated, that counsel for Mr. Dean at a previous executive session of this committee made certain other requests, particularly that the witness waived no rights, that he was appearing involuntarily and pursuant to subpoena, that he filed an application to be excused from testifying because of the fear of prejudicial effect on the possibility of his subsequent trial, and that he requested that coverage of the hearings be either an executive session or limited in accordance with the rules of this committee. I hope it's appropriate to say, Mr. Chairman, that those matters were taken into account by this committee as a whole in executive session, and the requests were denied. I think that the record ought to indicate that further for Mr. Dean's, for the completion of Mr. Dean's situation.
I want to thank you and say I concur in your view.
We appreciate that, Mr. Vice Chairman, and I would like, out of an abundance of caution, so that there be no waiver, for me to again call to the attention of the committee here and now before the public session the content of my letter to the chairman dated June 18, 1973, which I asked you to rule again on the assertions contained therein and that it be made a part of this public record.
That letter will be printed in the body of the record. I'm requested by members of the committee sitting on the left here that you and Mr. Dean swap places because
I'm going to leave the chair, Mr. Chairman, and sit back.
Because the reporters sort of obstructs their view.
Mr. Chairman.
Mr. Chairman, I'd like for the reporter to move a little back so I can see the witness.
Well, I was going to try to move the witness over here. Yes.
Mr. Chairman, we have one additional matter we'd like to call to the attention of the chair. First of all, the subpoena issued under your rules does subpoena all documents. So we conclude that all material supplied, other than his oral testimony, all exhibits and other documents are under the same subpoena and must be and are being brought forward in that manner. Also, we bring to your attention again Title 18, the U.S. Code, Section 798, Disclosure of Classified Information, and Section C, saying nothing in this section shall prohibit the furnishing upon lawful demand of information to any regularly constituted committee of the Senate or House of Representatives of the United States of America. We raise that, Mr. Chairman, because, as you are very well aware, and other members of the committee, under a ruling by the Honorable John J. Sirica, this committee came into possession of certain documents which Mr. Schaffer and I, as counsel to Mr. Dean, have not even seen ourselves. They're in your possession. If Mr. Dean is to be asked questions on those documents, he does not have a copy in his possession. The committee would have to furnish such a copy to him for him to be able to refresh his recollection. And we just wanted to make sure that this section of the criminal code and your rules pointed out how they dovetail as to disclosure of secret and classified information.
Well, we will rule on that at the proper time. I'm hoping that I'm expecting rather perhaps questions on those documents which were furnished to the committee by Judge Sirica at the request of the committee. The questions on that will probably not come up today, and we'll handle that in due season.
Thank you very much, Mr. Chairman.
I'd state myself that from my study of the subject, I think that information or material cannot be classified allegedly in the interest of national security unless it should not be disclosed to an unauthorized person because it relates to either to national defense or to our foreign relations with other nations. I'm of the opinion from my study that there is no authority under that statute to classify any matter merely because it relates to domestic intelligence or internal security. That's a matter, though, that the committee will rule on later when, if it becomes necessary.
Let me say something.
It's also our understanding, and I hope it's correct, that any doctrines of executive privilege or attorney-client privilege have already been taken care of by your committee.
Mr. Chairman,
Yes, I think
might I say a word in that respect, and on the point raised by Mr. McCandless, which I think is important to raise in connection with the protection of his client's rights. It is my understanding, and Mr. Dash, the chief counsel for the committee, can correct me if I'm in error. It's my understanding that on last Monday, there was transmitted to the witness with copies to the committee and its staff a letter from Mr. Leonard Garment, the counsel for the White House, or a counsel for the White House, indicating that the White House would not claim executive privilege as to this witness's testimony, nor would it claim the privilege of attorney-client. And as I recall as well, that on matters of the use of documents nominally classified, that they would leave it to the discretion of the committee to decide how that should be handled.
That is correct, Senator Baker. It initially was an oral statement given to me by Mr. Garment, counsel for the president, and he followed it up with a letter to Mr. Dean, copied to our committee, in which he put in writing that he was authorized by the president to do as you just stated.
And the committee in executive session on this past Monday, I believe by unanimous vote, I'm sure by unanimous vote, authorized the chairman to act on behalf of the committee in the matter of the handling of these classified matters. Thank you, sir.
Certainly let the record show, as Mr. McCandless states, that the documents also, any documents that the witness produces are produced in obedience to a subpoena due case taken.
Yes. Mr. Dean, you have a statement you wish to present to the committee?
That's correct, Mr. Dash, but before I commence reading the rather lengthy statement, I would just like to make a couple of comments. First of all, Mr. Chairman, Mr. Vice Chairman, and members of the committee, I sincerely wish I could say it's my pleasure to be here today, but I think you can understand why it's not.
Mr. Dean, could you please take the microphone and put it closer to you so we could all hear
Certainly.
it?
It's a very difficult thing for me to testify about other people. It's far more easy for me to explain my own involvement in this matter. The fact that I was involved in obstruction of justice, the fact that I assisted another in perjured testimony, the fact that I made personal use of funds that were in my custody. It's far easier to talk about these things myself than to talk about what others did. Some of these people I'll be referring to are friends. Some are men I greatly admire and respect. And particularly with reference to the President of the United States, I'd like to say this. It is my honest belief that while the President was involved, that he did not realize or appreciate at any time the implications of his involvement. And I think that when the facts come out, I hope the President is forgiven. Pursuant to the request of the committee, I will commence with a general description of the atmosphere that existed in the White House prior to June 1972. To one who was in the White House and became somewhat familiar with its inner workings, the Watergate matter was an inevitable outgrowth of a climate of excessive concern over the political impact of demonstrators, excessive concern over leaks, an insatiable appetite for political intelligence, all coupled with a do-it-yourself White House staff, regardless of the law. However, the fact that many of these elements of this climate culminated with the creation of a covert intelligence operation as part of the President's re-election committee was not by conscious design, rather an accident of fate. These, of course, are my conclusions, but I believe they are well-founded in fact. This committee, however, is not interested in my conclusions. Rather, it's interested in the facts as I know them. Rather than my characterizing the climate and attitudes, I shall, as requested, present the facts which themselves evidence some of the precursors of the Watergate incident. It was not until I joined the White House staff in early July of 1970 that I fully realized the strong feelings that the President and his staff had towards anti-war demonstrators and demonstrators in general. But even before my joining the White House staff, I was partially aware of this presidential concern, and a concern that in turn permeated much of the White House. During my tenure at the Justice Department as an Associate Deputy Attorney General, I was involved in representing the government in discussions with demonstration leaders regarding the terms of demonstration permits for activities in the capital city. While I was not the decision maker in this capacity, I was in close proximity to the decision-making process and thus realized that the White House, principally Mr. Ehrlichman, often made or cleared the final decisions regarding demonstration activity. It was also because of my proximity to those involved with demonstrations at the Department of Justice that I became aware that the White House was continually seeking intelligence information about demonstration leaders and their supporters that would either discredit them personally or indicate that the demonstration was in fact sponsored by some foreign enemy. There were also White House requests for information regarding ties between major political figures, specifically members of the United States Senate, who opposed the president's war policies, and demonstration leaders. I also recall that the information regarding demonstrators, or rather the lack of information showing connections between demonstration leaders and foreign governments or major political figures, was often reported to a disbelieving and complaining White House staff that felt the entire system for gathering such intelligence was worthless. As I shall elaborate shortly, this attitude towards intelligence gathering capabilities of the government regarding demonstrations prevailed through my tenure in the Justice Department and at the White House. And I was hearing complaints from the President personally as late as March 12th of this year. It was when I joined the White House staff in July of 1970 that I became fully aware of the extent of concern at the White House regarding demonstrations and intelligence information relating to demonstrators. It was approximately 1 month after I arrived at the White House that I was informed about a project that had been going on before I arrived to restructure the government's intelligence gathering capacities vis-a-vis demonstrators and domestic radicals. The revised domestic intelligence plan was submitted in a document form to the President for his approval. The committee has in its possession a copy of that document and certain related memoranda pursuant to the order of Judge Sirica. After I was told of the presidentially approved plan that called for bugging, burglarizing, mail covers and the like, I was instructed by Mr. Haldeman to see what I could do to get the plan implemented. I thought the plan was totally uncalled for and unjustified. I talked with Mr. Mitchell about the plan. He said he knew there was great concern or desire at the White House to see that the plan was implemented, but he agreed fully with FBI Director Hoover, who opposed the plan, with one exception. Mitchell thought that an interagency evaluation committee might be useful because it was not good to have the FBI standing alone without the information of other intelligence agencies, and the sharing of information is always good and avoids duplication. After my conversation with Mitchell, I wrote a memorandum requesting that the evaluation committee be established and the restraints could be removed later. I told Mr. Haldeman that the only way to proceed was one step at a time, and this could be an important first step. He agreed. The Interagency Evaluation Committee, the IEC as it was referred to, was created, as I recall, in early 1971. I requested Mr. Jack Caulfield, who had been assigned to my office, to serve as the White House liaison to the IEC. And when Mr. Caulfield left the White House, Mr. David Wilson of my staff served as liaison. I'm unaware of the IEC ever having engaged in any illegal activities or assignments, and certainly no such assignment was ever requested by my office. The reports of the IEC, or summaries of the reports, were forwarded to Haldeman and sometimes Ehrlichman. In addition to the intelligence reports from the IEC, my office also received regular intelligence reports regarding demonstrators and radical groups from the FBI and on some occasions from the CIA. A member of my staff would review the material to determine if it should be forwarded to Mr. Haldeman, that is, for bringing to the President's attention, or sent to another member of the staff who might have an interest in the contents of the report. Mr. Chairman, from time to time I'm going to skip parts of the statement in an effort to make sure that I can move as quickly as possible and get the statement completed within the time the committee has requested, so I will...
I believe it'd be well to read the whole statement since you thought it was important enough to write it.
I'll honor the chairman's wish. For example, Len Garment would be sent information regarding Indian uprisings, Mr. Kissinger or General Haig information regarding travels of anti-war groups to Hanoi. Also, prior to and during a demonstration, my office would prepare summary reports for the President of the anticipated size of the demonstration, any information about the leaders of the demonstration, and during the demonstration, a description of the activities of the demonstrators and the government's handling or anticipated handling of the demonstration. Contrary to the policy that existed before I came to the White House, I sought to keep the White House out of these tactical decisions regarding the demonstrations. I felt these were decisions for the Department of Justice and the police. I felt my job was to merely keep the White House informed as to what might happen or was happening. My own desires in this matter were sometimes superseded when Mr. Ehrlichman or Mr. Haldeman did not like the way a particular demonstration was being handled. Sometimes they so instructed me to inform the Justice Department or Chief Wilson of the Metropolitan Police, and sometimes Mr. Ehrlichman himself would so inform the Justice Department or Chief Wilson. As soon as a potential demonstration was in the wind, I began receiving calls from Mr. Larry Higbee, Mr. Haldeman's principal staff assistant, requesting intelligence reports. I also received frequent complaints regarding the quality of the available information, despite the fact that I felt the White House had the best information available to the government. I became directly and personally aware of the President's own interest in my reports regarding demonstrations when he called me during a demonstration of the Vietnam Veterans Against the War, which occurred on the mall in front of the Capitol. This was the occasion in May 1971, and I believe that's the date, when the government first sought to enjoin the demonstrations and later back down. The President called me for a first-hand report during the demonstration and expressed his concern that I keep him abreast of what was occurring. Accordingly, we prepared hourly status reports and sent them to the President. I was made aware of the President's strong feelings about even the smallest of demonstrations during the late winter of 1971, when the President happened to look out the window of the residence of the White House and saw a lone man with a large 10-foot sign stretched out in front of Lafayette Park. Mr. Higbee called me to his office to tell me that the President's displeasure with the sign in the park, and told me that Mr. Haldeman had said that the sign had to come down. When I came out of Mr. Higbee's office, I ran into Dwight Chapin, who said he was going to get some thugs to remove the man from Lafayette Park. He said it would take him a few hours to get them, but they could do the job. I told him I didn't believe that was necessary, and
The audience are here by the consent of the committee, and I'm going to request the audience to refrain from giving expression of their feelings by laughter or otherwise. And I hope the audience will restrain themselves in that respect.
I told him I didn't believe that was necessary. I then called the Secret Service and met with Mr. Lewis Sims. Mr. Sims said that he felt that the park police could work it out. I went out with Mr. Sims, surveyed the situation, and Mr. Sims talked with the park police. Within 30 minutes, the man had been convinced that he should move to the back of Lafayette Park. There, the sign was out of sight of the White House. I reported back to Mr. Haldeman, and after a personal look-see, he was delighted, and I told Mr. Chapin to call the troops off. I also recalled the first time I ever traveled with the President was on a trip in 1971 to the Football Hall of Fame and on to Iowa to open a dam. After arriving at the Akron-Canton Airport, I noticed there was virtually no hostile demonstrator in sight of the President. Later, when the President arrived at the motel he was spending the night in Akron, I was a few paces behind him as he walked into the lobby. Across the street were chanting Viet Cong flag-waving demonstrators. The President, after seeing the demonstrators, told the Secret Service agent beside him, in some rather blunt synonyms, to get the demonstrators out of there. The word was passed, but the demonstrators could not be moved, much to the distress of the advance men who were responsible for the President's trip. It was after observing that incident that I talked with several individuals in charge of advancing presidential visits, and that I learned A major part of any presidential trip advance operation was ensuring that demonstrators were unseen and unheard by the president. In early February of 1972, I learned that any means, legal or illegal, were authorized by Mr. Haldeman to deal with demonstrators when the president was traveling or appearing someplace. I would like to add that when I learned of the illegal means that were being employed, I advised that such tactics not be employed in the future, and if demonstrations occurred, they occurred. I stated earlier that there was a continuing dissatisfaction with the available intelligence reports. The most frequent critic was Mr. Haldeman, but the President himself discussed this with me in early March of this year as a part of the planned counteroffensive for dealing with the Senate Watergate investigation. The President wanted to show that his opponents had employed demonstrators against him during his re-election campaign. However, with each demonstration that the President was confronted with and each incident that occurred during the campaign, my office had sought to determine if it had in fact been instigated by political opponents of the President, Senator McGovern, the Democratic Party, or whomever. We never found a scintilla of viable evidence indicating that these demonstrators were part of a master plan, nor that they were funded by Democratic political funds, nor that they had any direct connection with the McGovern campaign. This was explained to Mr. Haldeman, but the President believed that the opposite was, in fact, true. I have submitted to the committee, Exhibit Number 1, the text of the President's memorandum to me on this subject. On February 16, 1973, almost a month prior to this direct request from the President, I had, at Mr. Haldeman's request, received all the available intelligence on the demonstrations the President had been subjected to during the 1972 campaign. This intelligence did not evidence what the President was looking for, but I turned it over to Mr. William Baruti, telling him that the President wanted a speech as part of a counteroffensive to the Watergate inquiry. Several weeks later, Mr. Baruti reported that he too agreed that the information wasn't there for such a speech. While there were other things which occurred that evidenced the concern about demonstrators, I believe that the foregoing gives this committee a good sampling of the degree of concern. The committee has asked me about concern over leaks. I believe that most anyone who worked at the White House during the past 4 years can attest to the concern that prevailed regarding leaks, any and all leaks. This was a matter of frequent discussion among staff members, and in some instances, leaks were investigated by Mr. Haldeman's office or Mr. Ehrlichman. I have submitted to the committee, Exhibit Number 2, some documents evidencing the types of investigations that were made. I began to understand the high degree of concern after I got to know Mr. Jack Caulfield, who'd been assigned to my staff. I would guess that I'd been at the White House almost a year before Mr. Caulfield told me that he had been directed by Mr. Ehrlichman to wiretap a newsman's telephone in pursuit of a leak. Mr. Caulfield told me that the wiretap was on for only a short period of time because he believed that the FBI had subsequently taken over. He told me that he had been directed to perform the wiretap when Mr. Hoover was unwilling, but Mr. Ehrlichman wished to proceed. The wiretap was undertaken, as I recall, in late 1969 or early 1970. Caulfield told me it was performed by Mr. Ulasewicz, Mr. John Reagan, and himself. He later repeated the story to me, telling me that it had been a rather harrowing experience when he was holding a ladder in a back alley of Georgetown while also trying to keep a lookout as another member of the group was working on the top of the ladder. He also told me that he'd received what he referred to as the pair numbers from Mr. John Davies, who was then on the White House staff and who had previously been employed or associated with the telephone company before joining the White House staff. I do not know what information, if any, they obtained, nor do I know any other details other than what I have related above. I have no idea if the reason for the wiretap was related to national security, but I believe that Mr. Caulfield told me that it was indeed Mr. Joseph Kraft's telephone that was tapped. While there was always a present concern about leaks, that concern took a quantum jump when the New York Times began publishing the Pentagon Papers in June of 1971. After the initial legal skirmishes to enjoin publication of the papers had died down, the White House concern about the problem of leaks had heightened. To the best of my recollection, and I've been unable to confirm this through White House records, it was in late June or early July that Jack Caulfield came to me to tell me that Mr. Colson had called him in at Ehrlichman's direction and instructed him to burglarize the Brookings Institution in an effort to determine if they had certain leaked documents. What prompted Mr. Caulfield to come to me was that he thought the matter was most unwise and that his instructions from Mr. Colson were insane. He informed me that Mr. Ulatzowitz had cased the Brookings Institute and that Mr. Ulatzowitz had made a friendly contact with one of the security men in the building, but that the security system at the Brookings building was extremely tight and it would be very difficult to break in. Caulfield told me that he had so informed Colson, but that Colson had instructed him to pursue the matter, and if necessary, he should plant a firebomb in the building and retrieve the documents during the commotion that would ensue. Caulfield said that Colson's entire argument for burglarizing the Brookings was based on a publication he had obtained indicating that the Brookings was planning for the fall of 1971 a study of Vietnam based on documents of a current nature, and the fact that a consultant who had formerly been with the National Security Council worked there. Caulfield convinced me that Colson was intent on proceeding by one means or another, so I advised Caulfield that he should do nothing further and that I would immediately fly to California and tell Ehrlichman that this entire thing was insane. I flew to California on a military aircraft courier flight that was going to San Clemente. I sat with Mr. Robert Mardian on the flight, who told me he was also going to see the President about a highly important matter that he could not discuss with me, a matter which I will refer to later. When I arrived in California, I arranged to see Ehrlichman and told him that the burglary of the Brookings Institute was insane and to persuade him, probably impossible. He said okay, and he called Mr. Colson to call it off, and I called Mr. Caulfield to tell him it was called off. It was not until almost a year or more later that I learned the reason for Mr. Mardian's trip to see the President. Mr. Mardian later told me in a social conversation that he'd gone to see the President to get instructions regarding the disposition of wiretap logs that related to newsmen and White House staffers who were suspected of leaking. These logs had been in the possession of Mr. William Sullivan, an assistant director of the FBI, and were, per Mr. Mardian's instructions from the President, given to Mr. Ehrlichman. I had occasion to raise this question about these logs with Ehrlichman during the fall of 1972. I did not tell him that I had been told by Mardian that he had them. About February, let me go back here. After I had told Mr. Ehrlichman, or asked the question about the logs, he had flatly denied to me that he had the logs at that time. And it was about February 22nd or 23rd of this year when Time magazine notified the White House it was going to print a story that the White House had undertaken wiretaps of newsmen and White House staffers, and a request was being asked for that I further got into the matter. The White House press office notified me of this inquiry. I called Mr. Mark Feld at the FBI to ask him first what the facts were, and secondly, how such a story could leak. Mr. Felt told me that it was true, that Mr. Sullivan knew all the facts, and that he had no idea how it had leaked. I then called Mr. Sullivan and requested that he drop by my office, which he did. He explained that after much haggling, the wiretaps were installed, but as I recall, Mr. Sullivan said they did not have the blessings of the director. Mr. Sullivan explained to me all but one set of the logs had been destroyed, and all the internal FBI records relating to the wiretaps, except one set, have been destroyed, and all the material had been delivered to Mr. Mardian. After Mr. Sullivan departed, I called Mr. Mitchell, who told me he also had an inquiry from Time magazine and denied to Time magazine any knowledge of the matter. I did not press him further as to what he did know. I then called Mr. Ehrlichman and told him about the forthcoming story in Time magazine. I told him of my conversations with Felt, Sullivan, and Mitchell. I also told him I knew he had the logs because Mr. Martin had told me. This time he admitted they were in his safe. I asked him how Mr. Ziegler should handle it. He said Mr. Ziegler should flatly deny it, period. I thanked him, I called Mr. Ziegler, and so advised him. Turning now to the so-called plumbers unit that was created to deal with leaks. I first heard of the plumbers unit in late July of 1971. I do not recall ever being actually advised in advance that such a unit was being created in the White House, but I stumbled into it unknowingly when Mr. Eagle Krogh happened to mention it to me. I was not involved in its establishment. I only know that Mr. Krogh and Mr. David Young were running it under Mr. Ehrlichman's direction. Shortly after Mr. Krogh told me about his unit, he told me that they were operating out of a super secure location in the basement of the executive office building. He invited me down to see the unit, which I did, and he showed me the sensor system and the scrambler phone. I never discussed with Mr. Krogh or Mr. Young what they were doing or how they were doing it. It was through Jack Caulfield that I learned that Mr. Gordon Liddy was working with Mr. Krogh. I did not know Liddy personally, although I may have met him. All I knew about Mr. Liddy was that what Mr. Caulfield had told me, and was to the effect that Mr. Gene Recides of the Treasury Department and Mr. Liddy had had a falling out, and Krogh had waded into the middle of the dispute by hiring Liddy and bringing him into the White House. I did not realize that Mr. Howard Hunt worked most of the time while he was at the White House in the plumbers unit until after June 17th of 1972. I had seen Hunt on many occasions in Colson's office and finally asked Mr. Colson who he was. He told me he was doing some consultant work for him and then introduced me. That was the only time I've ever talked with Mr. Hunt. I am not aware of what success the plumbers unit had in its dealing with leaks. I recall on one occasion, after Jack Anderson had printed the documents from a National Security Council meeting, asking Bud Krogh if they'd figured out who'd leaked the information to Mr. Anderson. He told me yes, but he couldn't disclose the name of the individual. As I have indicated, the June 1971 publication of the Pentagon's papers caused general consternation at the White House over the leak problem. On June 29, 1971, the President brought the subject of leaks up in a cabinet meeting as part of a White House orchestrated effort to curtail all leaks. As a part of that effort, Mr. Haldeman instructed Mr. Fred Malek, Mr. Larry Higbee, Gordon Strawn, and myself to develop a follow-up strategy for dealing with leaks. Malek and I never took the project very seriously, but Strawn and Higbee continued to push. I have submitted to the committee Exhibit Number 3, memorandum outlining the project that finally developed, in which Mr. Malek was to take charge and Mr. Haldeman was to be brought in as the Lord High Executioner when a leak was uncovered. The committee will note from the documents which I have submitted that the project was to complement and not complete with the plumbers unit. To the best of my knowledge, this project never uncovered the source of a single leak. I shall turn now, pursuant to the committee's request, from leaks to the matter of political intelligence, with the hope that my voice will hold up through this entire statement. The pre-election White House thrived on political gossip and political intelligence. I knew of the type of information they sought even before I joined the White House staff. During the summer of 1969, while I was working at the Justice Department, the then Deputy Attorney General, Richard Kleindienst, called me into his office and told me that the White House wanted some very important information. Mr. Kleindienst instructed me to call Mr. DeLoach, then Deputy Director of the FBI, and to obtain from him information regarding the foreign travels of Mary Jo Kopechne. I was told that Mr. DeLoach would be expecting a call from me, and once I had the information in hand, I was to give it to Jack Caulfield at the White House. The incident stuck in my mind because it was of the rather sensitive nature of the information being obtained from the FBI, and the fact that I was made a courier of the information. To this day, I can only speculate that I was asked to convey the information so that others could deny that they had done so should the matter become known. It was not until I joined the White House staff and Caulfield was placed on my staff that I learned that Caulfield was assigned to develop political intelligence on Senator Edward Kennedy. Mr. Caulfield told me that within some 6 hours of the accident at Chappaquiddick on July 18, 1969, he had a friend named Tony on the scene who remained on the scene conducting a private investigation of the matter and reporting pertinent information back to him. It was not until this spring that I knew or could remember Tony's full name, Anthony Ulasewicz. Caulfield told me that Mr. Ulasewicz posed as a newspaper reporter and always asked the most embarrassing questions at any press gatherings relating to the Chappaquiddick incident. Caulfield also informed me that his instructions were to continue surveillance on Senator Kennedy, and he was doing so on a selective basis. I was told by Caulfield that although he had been assigned to my staff, that he would continue to perform various intelligence gathering functions assigned to him by Mr. Ehrlichman and Mr. Haldeman. I only recall once becoming involved in Mr. Caulfield's activities related to Senator Kennedy. That occurred in the fall of 1971 when I received a call from Larry Higbee, who later, later these calls were followed up by Mr. Strawn, who told me that Haldeman wanted 24-hour surveillance of Senator Kennedy and regular reports on his activities. I passed this on to Caulfield and we discussed it. He told me that he thought that this was most unwise because it would require several men and could also uncover his activities in that Senator Kennedy was bound to realize he was under surveillance, and given the fact that it could be easily misinterpreted as someone who was planning an attack on his life, and the police or the FBI might be called in to investigate. I agreed fully with Caulfield, and after some initial resistance, I convinced Higbee that it was a bad idea to have the day-in, day-out surveillance concept, and it was called off. Instead, Caulfield was to keep a general overview of Senator Kennedy's activity and pursue special investigations of activities that might be of interest. Caulfield seldom informed me of his findings, but occasionally he would bring matters to my attention. For example, Caulfield was instructed to investigate Senator Kennedy's visit to Honolulu in August of 1971. I have submitted to the committee, Exhibit Number 4, a copy of his report, which he passed on to me to see, along with several follow-up memorandum relating to the visit. Political intelligence often came from unexpected sources. For example, during this last spring of 1972, a top man at the Secret Service brought me information regarding Senator McGovern. I asked Mr. Colson if he were interested. He was very interested and had the information published. The persons on the White House staff who were most interested in political intelligence were Ehrlichman, Haldeman, and Colson. As the re-election campaign drew closer, I would have to say that it was principally Colson and sometimes Haldeman who sought information from my office that had political implications to it. While I've been unable to make a complete review of my office files to document the many types of inquiries, I do have some documents that evidence a fair sampling of the types of requests that were frequently made of me and how they were handled by my office. The documents are extremely sensitive and could be injurious to innocent people whose names are mentioned in them. Accordingly, I have submitted them for the committee's use, Exhibit Number 5, and I'm prepared to answer any questions the committee may have regarding these documents. In addition to the rather wide-ranging types of inquiries evidenced by the documents I have just referred to, in addition to the extensive efforts to obtain politically embarrassing information on Senator Kennedy, there were also frequent efforts to obtain politically embarrassing information on Mr. Lawrence O'Brien, the Democratic National Committee Chairman, Senator Muskie, and Senator McGovern. While the involvement of my office in seeking such information was peripheral, I have submitted to the committee, Exhibits Number 6, 7, and 8, records and documents which show the efforts of the White House to politically embarrass these individuals. Again, because of the very sensitive nature of the information contained in these documents and the problems that the information might unfairly cause those individuals, I shall not discuss the documents further, other than to point out to the committee that the interest in Mr. Larry O'Brien dates back, from my records, to the time I first joined the White House staff in July of 1970, while the interest in Senators Muskie and McGovern developed as the re-election campaign developed. I would now like to turn to a political intelligence and security plan that was designed for the campaign, but ultimately rejected. While Caulfield was a member of my staff, the use of Mr. Ulasewicz slowly diminished, in that I had no need for such investigative work and only requested Caulfield to obtain investigative information when someone else on the staff requested it. While I did try to find assignments for Caulfield that related to the work of the counsel's office, it was difficult in that he was not a lawyer. Mr. Caulfield was aware of the situation, and in the spring of 1971 he came to me and told me he was thinking of leaving the White House staff to establish an investigative security consulting corporation. He felt that there was a need and a market for such an activity, and what he described as a Republican Intertel. The Intertel firm being a long-established firm that's been in existence for a number of years working in the field. He told me that he felt that he should get started as soon as possible so that he could have a going concern by campaign time, and that his firm could provide investigative security assistance to the campaign. We casually discussed this on several occasions. The basic and initial concept he had developed was an operation that could be funded by contracts with corporations. Mr. Caulfield's firm would provide services for these corporations, but would also provide free services to the 1972 re-election campaign. I recall telling Caulfield that I could not help him in the intelligence field because I did not have any expertise in the area, but I advised him that he should work with a lawyer in developing the concept he had just outlined to me, because it was fraught with legal problems. For example, I told him that corporations are prohibited under federal law from making direct or indirect campaign contributions. Shortly after these conversations, Caulfield informed me that he had formed a group to develop a plan to submit to Mr. Ehrlichman, Mr. Haldeman, and Mr. Mitchell. The planning group intended to become the principal officers of the corporation once it commenced its activity. Caulfield and the group spent several months developing their plans, and in early August or September of 1971, Caulfield brought me a memorandum entitled Operation Sandwedge and told me that he was seeking a meeting with Mr. Ehrlichman to discuss the matter and requested that I assist him in getting a meeting with Mr. Mitchell. I do not know if Mr. Caulfield met with Mr. Ehrlichman. If he did, I was not present and have no knowledge of the meeting. I read the memorandum and found it to be a privately operated extension of the types of things that Caulfield had been performing for Mr. Ehrlichman. I returned the memorandum to Caulfield and told him I would raise it with Mitchell. To the best of my recollection, Operation Sandwich envisioned the creation of a corporation called Security Consulting Group, Incorporated, which was to have offices in Washington, Chicago, and New York. It was to have an overt and a covert capacity. The covert capacity would have operated out of New York, presumably under the aegis of Mr. Ulasewicz. It was to be separate and apart from the other operations in Washington and Chicago. The principal activity of the Security Consulting Group was to provide private security for all phases of the campaign, but the New York covert operation would have the capacity to provide bagged men, to carry money, and engage in electronic surveillance if called upon to do so. Although I returned the copy of the Operation Sandwich memorandum given to me by Mr. Caulfield, I did find in my records a copy of a proposed budget, which reflects some of the items I've just mentioned. I also found a number of memorandum relating to the campaign security aspects of the plan. I have submitted these documents to the committee, Exhibit number 9. I did discuss Operation Sandwedge with Mr. Mitchell. I recall that he was not interested at all. He told me that he thought that Jack Caulfield was a fine person, but he felt that the principal problems would relate to security and the problems that demonstrators might cause to the campaign. Mr. Mitchell said he wanted a lawyer to handle any such operation and asked me to think about candidates. I told him that Jack Caulfield had requested an opportunity to discuss his plan with him. I told him that I told Jack I would convey the message. Mitchell did not wish to discuss the proposal, so I kept putting Caulfield off, and when he raised it with me, because I liked Jack, I did not want to hurt his feelings, I continued to keep putting him off. I also recall that Ehrlichman raised Operation Sandwich with me. I do not know if this was a result of his meeting with Caulfield or Caulfield sending him a copy of the memorandum. Ehrlichman told me that he would like to keep Tony Ulasewicz around during the campaign, but he did not think much of Mr. Caulfield's proposed grand plan. Ehrlichman told me that Mitchell knew about Tony Ulasewicz and that Mitchell and Jack Caulfield should talk about Tony's future. Meanwhile, Caulfield kept requesting an answer on his plans. He had his heart set on the proposal. He had spent long hours preparing it, and I knew he was going to be very disappointed to learn that it had been shot down. Every few weeks, Mr. Caulfield would send me an item or two to prompt my attention and to prompt me to take action. I have submitted to the committee, in Exhibit Number 9, the types of items he would send. I would just file them and do nothing, as I decided that the best course of action to save Jack's feelings was to let the matter die a natural death through no action. Indeed, that happened. By November 1971, Mr. Caulfield realized that his plan was dead, and he abandoned the idea. Realizing this, he told me he would like to work for Mr. Mitchell during the campaign as an aide-de-camp and requested that I assist him in getting an appointment with Mr. Mitchell. I arranged for him to meet Mr. Mitchell on November 24, 1971. Pursuant to Mr. Caulfield's request, I was not present during the entire meeting, but Jack later said that Mr. Mitchell had requested that he do some investigative work on the McCloskey campaign. Apparently, Caulfield convinced Mr. Mitchell that some greatly reduced version of Operation Sandwich might be of value, or he was seeking to show Mitchell what he could do. At any rate, Caulfield continued to call his intelligence gathering operation Operation Sandwich. I have submitted to the committee, Exhibit Number 10, copies of the investigative report Mr. Caulfield prepared for Mr. Mitchell on the McCloskey, New Hampshire campaign, and I hasten to add that, to the best of my knowledge, Caulfield employed no illegal procedures in gathering this information. Pursuant to the request of Ehrlichman that Mitchell determine whether continued funding should be provided for Mr. Ulasewicz, Mitchell asked me what Ulasewicz had been doing. I told him I did not know, but I would have Caulfield prepare a summary of the activities. On January 12, 1972, I informed Mitchell that Caulfield had prepared such a list and suggested he meet with him. I refer the committee to Exhibit Number 11. I would also note at this point that there is no list accompanying that exhibit because while I initially thought I did have a list, I have searched my records that are available and I have no such list other than the possibility there might be a list in my files that remain at the White House. I do not recall how this matter was resolved, but I believe some arrangement was made to compensate Mr. Ulasewicz, but to my knowledge, he was not used in any manner other than that to which I shall refer later in my statement. Mr. Caulfield and Mr. Kalmbach would know about the arrangements that had been made. I shall now turn to my knowledge of how an intelligence unit was established at the Re-Election Committee. To the best of my recollection, it was the spring of 1971 that Mr. Haldeman discussed with me what my office should do during the forthcoming campaign year. He told me that we should take maximum advantage of the president's incumbency, and the focus of everyone in the White House should be on re-electing the president. It was decided that the principal area of concern for my office should be keeping the White House in compliance with the election laws and improving our intelligence regarding demonstrations. I was also told that I should provide legal assistance in establishing the Re-Election Committee and ensuring that they had their own capacity to deal with the potential threats of demonstrations during the campaign, and particularly the convention. I advised Haldeman that Jack Caulfield was developing a security plan and that he wanted to discuss his plan with Mr. Mitchell and Mr. Ehrlichman. I also told him I would seek to get the Interagency Evaluation Committee working on the potential for demonstrations during the campaign, and subsequently called Mr. Bernie Wells, the head of the IEC, to my office and told him of the concern of the White House for good intelligence during the coming campaign. During the months that followed, I devoted most of my time to regular office functions, keeping abreast of the new campaign legislation and familiarizing myself with existing election laws, the Hatch Act, and related laws. It was not until after the proposed Operation Sandwich had been shelved and Magruder had left the White House to form the re-election committee that I began receiving calls from Strawn and Magruder that I was expected to suggest a lawyer to head up the demonstration intelligence operation at the re-election committee and to serve also as general counsel. On several occasions, Magruder told me that he would like to have Mr. Fred Fielding, my principal assistant, for this job. Fielding and I discussed it, but rejected it for several reasons. First, Fielding was aware of the fact that I was considering leaving the White House at that time. I was actually interviewing for jobs outside the government, and he knew that I would recommend that he succeed me as counsel. Secondly, if I stayed, I would need his assistance during the coming months. I might add parenthetically, as I look back, if I had accepted the job I was interviewing for at that time, I would not be sitting here today. After I informed Magruder that Mr. Fielding was not available, he requested that I suggest someone else because he was desperately in need of an in-house lawyer. Accordingly, I next went to Mr. Krogh and asked him if David Young might be available and interested. Krogh told me that Young was very much involved in the declassification project and could not be spared. The reason Young had occurred to me is that I had spent several days traveling with him in mid-October, interviewing prospective candidates for nomination to the Supreme Court. I might add that during those days of traveling around the country together, he never told me what the Plumbers Unit was doing or had done. But I felt that Mr. Young was a bright and extremely capable lawyer and would make an excellent general counsel and could handle the security and demonstration problems of the campaign. During my conversation with Mr. Krogh about Young, he suggested Mr. Gordon Liddy might be available, in that he had just about completed his work. Krogh spoke very highly of Liddy's legal ability and said that his FBI Treasury Department background in law enforcement would qualify him to handle a demonstration intelligence and security operation for the re-election committee. I did not know Mr. Liddy, but I respected Krogh's judgment, both as to his judgment of other lawyers and his knowledge of law enforcement. Bud had dealt with the demonstration problem for the White House before I joined the staff. I asked Mr. Krogh to find out if Mr. Liddy was interested. Several days later, Krogh informed me that Liddy was interested and asked me to come to his office, Krogh's office, and meet Liddy and describe the job. I did this. I told Liddy that the primary responsibility for the job was to serve as the lawyer for the re-election committee, but among the responsibilities of the general counsel would be keeping abreast of the potential of demonstrations that might affect the campaign. Liddy said he was interested. Krogh said that he would first have to clear this with Ehrlichman. I advised them that Mr. Mitchell and Mr. Magruder would be making the decisions on filling the post, and if Krogh got the okay from Ehrlichman, I would set up a meeting for Liddy to be interviewed by Mr. Mitchell. When Mr. Krogh gave me the okay from Ehrlichman, I called Mr. Mitchell, and I told him that Krogh, with Ehrlichman's approval, had suggested Gordon Liddy for the general counsel post. And I arranged for Liddy to meet Mitchell on November 24th, 1971, after Mr. Caulfield met with Mr. Mitchell. I attended the meeting with Mitchell and Liddy, and I have submitted to the committee, exhibit number 12, a copy of an agenda Mr. Liddy prepared for the interview session. While I cannot recall every detail that was discussed, I do recall that it was a very general job-type interview. Mitchell realized that Liddy was not familiar with the election laws and asked if I would assist him in any way I could in getting himself familiar with those laws. I agreed. There was virtually no discussion of intelligence plans other than that Liddy would draw up some sort of plans. Most of the conversation centered around title and compensation. Mr. Mitchell agreed that Liddy would be titled general counsel. I do not recall the rate of his compensation. I also recall that Liddy asked Mr. Mitchell when he would actually join the campaign, but Mitchell said he did not know. After this meeting, Mitchell called me to say that he wanted Magruder to interview Liddy because Magruder would be the man working most with him. I so advised Liddy, and on December 8, 1971, Magruder requested I bring Liddy over to his office for an interview. The interview in Magruder's office on December 8th was brief and non-substantive. Magruder told Liddy that he had a host of legal problems that needed attention immediately, and pointed to a stack of papers that I assumed contained the problems that he was concerned about. There was a brief discussion of Liddy's responsibilities for demonstrations vis-a-vis the campaign, and Liddy said that after he got acclimated to the committee's problems and needs, he would draw up a plan. Magruder requested that Liddy come to work as soon as possible, which I believe was the following Monday. After Liddy was hired at the Re-Election Committee, I informed my staff, principally Mr. Fred Field and Mr. David Wilson, that they should assist Liddy in becoming familiar with the election laws. I made my election law file available to Liddy and believed that he used them, and he had periodic contact with my staff and myself on election law matters. I can recall that I had several discussions with Liddy about his responsibilities with the committee, the Re-Election Committee, in complying with the election laws. He told me that he had more work than there were hours in the day to complete it. I urged him to get volunteer lawyers to assist him and suggested several names of lawyers who might assist him. I can also recall that several weeks after Liddy left the White House, he was asked to turn in his White House pass. Liddy came to me and asked me to intervene in his behalf so he might retain his pass and avoid the cumbersome procedures of clearance every time that he wished to enter the White House. I thought that my office would have a good deal of contact with Liddy, so I requested that he permitted to keep his pass. This request was turned down, however, because they had decided to provide a fixed number of passes for people at the Re-Election Committee, and Magruder would decide who got the passes. I so informed Liddy and never heard any more about the matter. The next time I recall meeting Mr. Liddy, I might insert before this that I did have a brief occasion to see him in early January, I believe about the 9th through the 14th or 15th, when he attended a general conference in San Diego on the entire scope of the convention and the security problems that were going to confront the convention in San Diego. It was after that, the next time I recall meeting Liddy was at a meeting in Mitchell's office in January 27 of 1972. Magruder called my office to set up the meeting, and only after I called Magruder to ask why he wanted me to attend the meeting did I learn that Liddy was going to present his intelligence plan. I met Magruder and Liddy at Mitchell's office. Liddy had a series of charts or diagrams which he placed on an easel, and the presentation by Liddy began. I did not fully understand everything Mr. Liddy was recommending at that time because some of the concepts were mind-boggling and the charts were in code names, but I shall attempt to reconstruct the high points that I remember as best I can. established at the Re-election Committee. To the best of my recollection, it was the spring of 1971 that Mr. Haldeman discussed with me what my office should do during the forthcoming campaign year. He told me that we should take maximum advantage of the president's incumbency, and the focus of everyone in the White House should be on re-electing the president. It was decided that the principal area of concern for my office should be keeping the White House in compliance with the election laws and improving our intelligence regarding demonstrations. I was also told that I should provide legal assistance in establishing the Re-election Committee and ensuring that they had their own capacity to deal with the potential threats of demonstrations during the campaign, and particularly the convention. I advised Haldeman that Jack Caulfield was developing a security plan and that he wanted to discuss his plan with Mr. Mitchell and Mr. Ehrlichman. I also told him I would seek to get the Interagency Evaluation Committee working on the potential for demonstrations during the campaign, and subsequently called Mr. Bernie Wells, the head of the IEC, to my office and told him of the concern of the White House for good intelligence during the coming campaign. During the months that followed, I devoted most of my time to regular office functions, keeping abreast of the new campaign legislation and familiarizing myself with existing election laws, the Hatch Act, and related laws. It was not until after the proposed Operation Sandwich had been shelved and Magruder had left the White House to form the Re-election Committee that I began receiving calls from Strawn and Magruder that I was expected to suggest a lawyer to head up the demonstration intelligence operation at the Re-election Committee and to serve also as general counsel. On several occasions, Magruder told me that he would like to have Mr. Fred Fielding, my principal assistant, for this job. Fielding and I discussed it, but rejected it for several reasons. First, Fielding was aware of the fact that I was considering leaving the White House at that time. I was actually interviewing for jobs outside the government, and he knew that I would recommend that he succeed me as counsel. Secondly, if I stayed, I would need his assistance during the coming months. I might add, parenthetically, as I look back, if I had accepted the job I was interviewing for at that time, I would not be sitting here today. After I informed Magruder that Mr. Fielding was not available, he requested that I suggest someone else because he was desperately in need of an in-house lawyer. Accordingly, I next went to Mr. Krogh and asked him if David Young might be available and interested. Krogh told me that Young was very much involved in the declassification project and could not be spared. The reason Young had occurred to me is that I had spent several days traveling with him in mid-October, interviewing prospective candidates for nomination to the Supreme Court. I might add that during those days of traveling around the country together, he never told me what the Plumbers Unit was doing or had done. But I felt that Mr. Young was a bright and extremely capable lawyer and would make an excellent general counsel and could handle the security and demonstration problems of the campaign. During my conversation with Mr. Krogh about Young, he suggested Mr. Gordon Liddy might be available and that he had just about completed his work. Krogh spoke very highly of Liddy's legal ability and said that his FBI Treasury Department background in law enforcement would qualify him to handle a demonstration intelligence and security operation for the Re-election Committee. I did not know Mr. Liddy, but I respected Krogh's judgment, both as to his judgment of other lawyers and his knowledge of law enforcement. Bud had dealt with the demonstration problem for the White House before I joined the staff. I asked Mr. Krogh to find out if Mr. Liddy was interested. Several days later, Krogh informed me that Liddy was interested and asked me to come to his office, Krogh's office, and meet Liddy and describe the job. I did this. I told Liddy that the primary responsibility for the job was to serve as the lawyer for the Re-election Committee, but among the responsibilities of the general counsel would be keeping abreast of the potential of demonstrations that might affect the campaign. Liddy said he was interested. Krogh said that he would first have to clear this with Ehrlichman. I advised them that Mr. Mitchell and Mr. Magruder would be making the decisions on filling the post, and if Krogh got the okay from Ehrlichman, I would set up a meeting for Liddy to be interviewed by Mr. Mitchell. When Mr. Krogh gave me the okay from Ehrlichman, I called Mr. Mitchell, and I told him that Krogh, with Ehrlichman's approval, had suggested Gordon Liddy for the general counsel post. And I arranged for Liddy to meet Mitchell on November 24th, 1971, after Mr. Caulfield met with Mr. Mitchell. I attended the meeting with Mitchell and Liddy, and I have submitted to the committee, Exhibit number 12, a copy of an agenda Mr. Liddy prepared for the interview session. While I cannot recall every detail that was discussed, I do recall that it was a very general job-type interview. Mitchell realized that Liddy was not familiar with the election laws and asked if I would assist him in any way I could in getting himself familiar with those laws. I agreed. There was virtually no discussion of intelligence plans other than that Liddy would draw up some sort of plans. Most of the conversation centered around title and compensation. Mr. Mitchell agreed that Liddy would be titled General Counsel. I do not recall the rate of his compensation. I also recall that Liddy asked Mr. Mitchell when he would actually join the campaign, but Mitchell said he did not know. After this meeting, Mitchell called me to say that he wanted Magruder to interview Liddy because Magruder would be the man working most with him. I so advised Liddy, and on December 8, 1971, Magruder requested I bring Liddy over to his office for an interview. The interview in Magruder's office on December 8th was brief and non-substantive. Magruder told Liddy that he had a host of legal problems that needed attention immediately, and pointed to a stack of papers that I assumed contained the problems that he was concerned about. There was a brief discussion of Liddy's responsibilities for demonstrations vis-a-vis the campaign, and Liddy said that after he got acclimated to the committee's problems and needs, he would draw up a plan. Magruder requested that Liddy come to work as soon as possible, which I believe was the following Monday. After Liddy was hired at the re-election committee, I informed my staff, principally Mr. Fred Field and Mr. David Wilson, that they should assist Liddy in becoming familiar with the election laws. I made my election law file available to Liddy and believed that he used them, and he had periodic contact with my staff and myself on election law matters. I can recall that I had several discussions with Liddy about his responsibilities with the committee, the re-election committee, in complying with the election laws. He told me that he had more work than there were hours in the day to complete it. I urged him to get volunteer lawyers to assist him and suggested several names of lawyers who might assist him. I can also recall that several weeks after Liddy left the White House, he was asked to turn in his White House pass. Liddy came to me and asked me to intervene in his behalf so he might retain his pass and avoid the cumbersome procedures of clearance every time that he wished to enter the White House. I thought that my office would have a good deal of contact with Liddy, so I requested that he permitted to keep his pass. This request was turned down, however, because they had decided to provide a fixed number of passes for people at the re-election committee, and Magruder would decide who got the passes. I so informed Liddy and never heard any more about the matter. The next time I recall meeting Mr. Liddy, I might insert before this that I did have a brief occasion to see him in early January, I believe about the 9th through the 14th or 15th, when he attended a general conference in San Diego on the entire scope of the convention and the security problems that were going to confront the convention in San Diego. It was after that, the next time I recall meeting Liddy was at a meeting in Mitchell's office in January 27 of 1972. Magruder called my office to set up the meeting, and only after I called Magruder to ask why he wanted me to attend the meeting did I learn that Liddy was going to present his intelligence plan. I met Magruder and Liddy at Mitchell's office. Liddy had a series of charts or diagrams which he placed on an easel, and the presentation by Liddy began. I did not fully understand everything Mr. Liddy was recommending at that time because some of the concepts were mind-boggling and the charts were in code names, but I shall attempt to reconstruct the high points that I remember as best I can. Liddy was, in effect, making a sales pitch. He said that the operation he had developed would be totally removed from the campaign and carried out by professionals. Plans called for mugging squads, kidnapping teams, prostitutes to compromise the opposition, and electronic surveillance. He explained that the mugging squad could, for example, rough up demonstrators that were causing problems. The kidnapping teams could remove demonstration leaders and take them below the Mexican border and thereby diminish their ability the ability of the demonstrators to cause problems at the San Diego convention. The prostitutes could be used at the Democratic convention to get information as well as compromise persons involved. I recall Liddy saying that the girls would be high class and the best in the business. When discussing the electronic surveillance, he said that he had consulted with one of the best authorities in the country, and his plan envisioned far more than bugging and tapping of telephones. He said that under his plan, communications between ground facilities and aircraft could also be intercepted. I might also add at this point, he also gave an elaborate description of intercepting various microwaves that traveled around the country through various communication facilities, and I cannot explain to the committee what that was, because to this day I don't understand it. Each major aspect of his proposal was on a chart, with one chart showing the interrelations with the others. Each operation was given a code name. I have no recollection of these code names. With regard to surveillance, I do not recall if this was necessarily limited to electronic surveillance. He suggested several potential targets. I cannot recall for certain if it was during this meeting or a second meeting in early February that he suggested the potential targets. The targets that I recall he suggested were Mr. Larry O'Brien, the Democratic headquarters, and the Fontainebleau Hotel during the Democratic convention. Mr. Liddy concluded his presentation by saying that the plan would cost approximately $1 million. I do not recall Magruder's reaction during the presentation of the plan because he was seated beside me, but I do recall Mitchell's reaction to the Mission Impossible plan. He was amazed. At one point I gave him a look of bewilderment and he winked. Knowing Mitchell, I did not think that he would throw Liddy out of the office or tell him that he was out of his mind. Rather, he did what I expected. When the presentation was completed, he took a few long puffs on his pipe and told Liddy that the plan he had developed was not quite what he had in mind and the cost was out of the question. He suggested to Liddy that he go back and revise his plan, keeping in mind that he was most interested in the demonstration problem. I remained in Mitchell's office for a brief moment after the meeting ended, as the charts were being taken off the easel and disassembled, and Mitchell indicated to me that Mr. Liddy's proposal was out of the question. I then joined Magruder and Liddy, and as we left the office, I told Liddy to destroy the charts. Mr. Liddy said that he would revise the plan and submit a new proposal. At that point, I thought the plan was dead, because I doubted if Mitchell would reconsider the matter. I rode back to my office with Liddy and Magruder, but there was no further discussion of the plan. The next time I became aware of any discussions of such plans occurred, I believe, on February 4th, 1972. Magruder had scheduled another meeting in Mr. Mitchell's office on a revised intelligence plan. I arrived at the meeting very late, and when I came in, Liddy was presenting a scaled-down version of his earlier plan. I listened for a few minutes and decided I had to inject myself into the discussions. Mr. Mitchell, I felt, was being put on the spot. The only polite way I thought I could end the discussion was to inject that these discussions could not go on in the office of the Attorney General of the United States, and the meeting should terminate immediately. At this point, the meeting ended. I do not know to this day who kept pushing for these plans, whether Liddy was pushing, or whether Magruder was pushing, or whether someone was pushing Magruder. I do not know. I do know, in hindsight, that I should not have been as polite as I was in merely suggesting that Liddy destroy the charts after the first meeting. Rather, I should have said, forget the plan completely. After I ended the second meeting, I told Liddy that I would never again discuss this matter with him. I told him that if any such plan were approved, I did not want to know. One thing was certain in my mind: while someone wanted this operation, I did not want any part of it, nor would I have any part of it. After this second meeting in Mitchell's office, I sought a meeting with Mr. Haldeman to tell him what was occurring, but it took me several days to get to see him. I recall that Mr. Higbee got me into Mr. Haldeman's office when another appointment had been canceled or postponed. I told Haldeman what had been presented by Liddy and told him that I felt it was incredible, unnecessary, and unwise. I told him that no one in the White House should have anything to do with this. I said that The re-election committee will need an ability to deal with demonstrations, but it did not need bugging, mugging, prostitutes, and kidnappers. Haldeman agreed and told me that I should have no further dealings on the matter. I assumed the Liddy plan was dead and it would never be approved. I recall Liddy coming into my office in late February or early March on a matter related to election laws. He started to tell me that he could not get his plan approved, and I reminded him I would not discuss it with him. He stopped talking about it, and we went on with our business. I have thought back over the sequence of events and tried to determine if I in any way encouraged Mr. Liddy and his intelligence plans. I am certain of this. I did not encourage him to develop illegal techniques because I was unaware he was developing such plans. Between the meeting in Mitchell's office on February 4th, 1972, and June 19th of 1972, I had no knowledge of what had become of Liddy's proposal. I did receive a memorandum from Magruder on March 26, 1972, that indicated that Liddy was doing some investigative work for Magruder, but nothing that appeared illegal. Let me explain. During the first week of March 1972, Larry Higbee, Haldeman's assistant, called me to request for Haldeman any information that Caulfield could come up with regarding the funding of the Democratic Convention in Miami. On March 15, 1972, I forwarded a newspaper article that Caulfield had discovered on the subject. Later that day, Magruder brought to me a copy of a memorandum from Liddy to Mitchell regarding an investigation Liddy had conducted using Howard Hunt in Florida. I called Higbee, and he said that Magruder had already given him a copy. I told Higbee that I did not see anything illegal by the Democrats based on the information in the memorandum. I made a notation on the bottom of the memorandum from Mr. Liddy, but I did nothing further and heard nothing further from Higbee on the subject. I have submitted to the committee, Exhibit number 13, the document I've just referred to. I shall now turn to the events following the Watergate incident of June 17, 1972, and begin by telling the committee how I first learned of the incident. I would skip the first part here of explaining how I ended up out of the country by a decision that was made in late May and returned on the 18th of June from the Far East. I returned from my 4-day trip to the Far East on the morning of June 18th. When I landed in San Francisco, after 20 hours of flying, I called my assistant, Fred Fielding, to check in and tell him I was going to spend an additional day in San Francisco to get some sleep before I returned to Washington, and accordingly, I would not be in my office until Tuesday. It was at this time that I first learned from Mr. Fielding of the break-in at the DNC headquarters. Mr. Fielding told me that he thought that I should return home immediately as there might be a problem, and that he would fill me in when I got home. I recall that at first I resisted, but Mr. Fielding, who was not explicit at that time, told me I should come back so he could fill me in. Accordingly, I flew back to Washington and arrived on Sunday evening. I had a brief conversation with Mr. Fielding, and he informed me that he had learned from Jack Caulfield that Mr. McCord from the Re-Election Committee was among those arrested in the Democratic National Committee headquarters on Saturday, and also that one of the Cubans that had been arrested had a check that was made out by Howard Hunt to some country club. I recall that my immediate reaction was that Chuck Colson was probably involved. I was truly exhausted at this point, so I told Mr. Fielding I couldn't do anything at that time, and I went to bed without doing anything. On Monday morning, June 19th, I arrived in my office about 9:15, my normal arrival time at the office. While reading the news accounts of the incident, I received a call from Jack Caulfield, who repeated what Mr. Fielding had told me on Sunday evening. Mr. Caulfield informed me that he had received the information from Mr. Boggs of the Secret Service. I next received a call from Mr. Magruder, and as best I can recall, Magruder said something to the effect that this might create some problems, and I should look into it. He also stated that this was all Liddy's fault, and he volunteered a few harsh epithets regarding Mr. Liddy. I also recall that Magruder mentioning something about how the committee was going to handle the matter publicly, but I cannot remember specifically what he stated regarding this. I told Magruder I just arrived back in the country and I did not know any of the facts surrounding the incident, but would look into it. I next received a call from Ehrlichman, who instructed me to find out what I could and report back to him. I advised Ehrlichman of my call from Magruder and told him I probably should talk to Liddy. He agreed. I recall that Ehrlichman told me to find out what Colson's involvement was in the matter, and also suggested I speak with Mr. Kleindienst to see what the Justice Department knew about it. I told him I would report back to him after I talked with Liddy. I next received a call from Gordon Strawn, who said he wanted to meet with me. I informed him that I would not be able to meet with him until early in the afternoon. He said he would drop by my office after lunch. I next talked with Chuck Colson on the phone. I asked him what he knew about the incident, and he vehemently protested that he knew nothing and had no involvement in the matter whatsoever. Colson advised me that Ehrlichman had spoken with him earlier regarding Mr. Hunt, or earlier during that weekend, and Colson said that we should get together with Ehrlichman as soon as possible. I recall asking Colson if Hunt still worked for him, and again he became very defensive and stated that he was merely on his payroll as a consultant because Ehrlichman had so requested. He asked me to determine if Hunt was still on his payroll, and I said I would check. Colson also expressed concern over the content of Hunt's safe. Several weeks later, probably 4 or 5, I learned from Paul O'Brien, who was representing the re-election committee, that he had learned from Mr. Hunt's attorney, William Bittman, that Hunt and Colson spoke on the telephone over the weekend of June 17th, 18th, and that Hunt had told Colson to get the materials out of Hunt's office safe. Mr. Hugh Sloan called me to tell me he was worried. At that time, I knew of no reason why Mr. Sloan should be worried, so I told him not to worry. He told me that he would like to meet with me, and I told him that I was trying to find out what had happened and requested we meet in a few days. I do not recall the precise date we did meet. I next contacted Liddy and asked him to meet with me. He said he would come to my office. As he came into the office, I was on my way out. I suggested we take a walk. It was shortly before noon, and we walked down 17th Street towards the Corcoran Gallery. I will try to reconstruct the conversation to the best of my memory. While I cannot recall every detail, I do indeed recall the major items we discussed. Mr. Liddy told me that the men who had been arrested in the DNC were his men, and he expressed concern about them. I asked him why he had men in the DNC, and he told me that Magruder had pushed him into doing it. He told me that he had not wanted to do it, but Magruder had complained about the fact that they were not getting good information from a bug they had placed in the DNC sometime earlier. He then explained something about the steel structure of the Watergate office building that was inhibiting transmission of the bug, and that they had gone into the building to correct this problem. He said that he had reported to Magruder that during the earlier entry of the DNC, they had seen documents, which I believe he told me were either government documents or classified documents, and Magruder told him to make copies of those documents. Liddy was very apologetic for the fact that they had been caught and that Mr. McCord was involved. He told me that he had used McCord only because Magruder had cut his budget so badly. I asked him why one of the men had a check from Mr. Howard Hunt, and he told me that these men were friends of Hunt, and Hunt had put him in touch with them. I do not recall Liddy discussing any further involvement of Hunt, other than Hunt's putting him in touch with the Cubans. I asked him if anyone from the White House was involved, and he told me no. As the conversation ended, he again expressed his apology and his concern about the men in jail. I told him I couldn't help, and he said he understood. He also told me that he was a soldier and would never talk. He said that if anyone wished to shoot him on the street, he was ready. As we parted, I said I'd be unable to discuss this with him further, and he said he understood, and I returned to my office. After returning to my office, I arranged a meeting with Ehrlichman in his office for mid-afternoon. Gordon Strawn came to my office shortly after I had met with Liddy, and Strawn told me that he had been instructed by Haldeman to go through all of Mr. Haldeman's files over the weekend and remove and destroy damaging materials. He told me that the materials included such matters as memorandum from the Re-election Committee, documents relating to wiretap information from the DNC, notes of meetings with Haldeman, and documents which reflected that Haldeman had instructed Magruder to transfer his intelligence gathering from Senator Muskie to Senator McGovern. Strawn told me his files were completely clean. I spoke with Mr. Kleindienst, and he told me that both the FBI and the D.C. Metropolitan Police were investigating, and he assumed that the FBI would take full jurisdiction of the case shortly. He also alluded to his encounter with Liddy at Burning Tree Country Club, but he did not explain this in full until I later met with him. I do not have a record of when I met with Mr. Kleindienst, but it was either on Monday the 19th or the next day. I will describe that meeting shortly. I met with Ehrlichman in mid-afternoon and reported in full my conversation with Liddy. I also told Ehrlichman about the earlier meetings I had attended in Mitchell's office in late January and early February, and my subsequent conversation with Mr. Haldeman. He told me he wanted to meet later with Colson and told me to attend. Ehrlichman also requested I keep him advised and find out from the Justice Department what was going on. I did not mention my conversation with Strawn because I assumed that Ehrlichman was aware of this from Haldeman himself. Later that afternoon, I attended a second meeting in Ehrlichman's office with Colson. I recall Ehrlichman asking where Hunt was. I said I had no idea, and Colson made a similar statement. At that point, before the meeting had started, Ehrlichman instructed me to call Liddy, to tell him to tell Hunt to get out of the country. I did this without even thinking. Shortly after I made the call, however, I realized that no one in the White House should give such an instruction and raised the matter. A brief discussion ensued between Ehrlichman and myself. As a result, as I recall, Ehrlichman said that he did not think Hunt was a fugitive from justice, so why not? I said that I did not think it was very wise. At this point, Colson chimed in that he also thought it unwise, and Ehrlichman agreed. I immediately called Liddy again to retract the request, but he informed me that he had already passed the message and it might be too late to retract. Following this brief telephone skirmish regarding Hunt's traveling plans, the meeting turned to Hunt's status at the White House. I had learned from Fred Fielding, who I had asked to check on it, that Hunt had not drawn a check from his White House consultantship since late March of 1972. But as far as I knew, the records indicated that Hunt was still a White House consultant to Colson. After discussions of this by Colson, who at this point was disowning Hunt as a member of his staff, Ehrlichman called Bruce Curlie and requested he bring Hunt's personnel records up to Ehrlichman's office. Before Curlie arrived, Colson raised the matter of Hunt's safe. Colson, without getting specific, said it was imperative that someone get the contents of Hunt's safe. Colson suggested, and Ehrlichman concurred, that I take custody of the contents of the safe. When Curlie arrived, he was quizzed by Ehrlichman and Colson on Hunt's status at the White House. Colson was arguing that Hunt should have been removed from the White House as of March 31, 1972. Curlie's records, however, did not so indicate. I have submitted to the committee, Exhibit 13A, memoranda that Colson forwarded to me on June 19th, presenting his argument. This was later resolved between Colson and Curlie pursuant to Colson's argument. I always had assumed that this required some alteration of the records, but I did not know this for a fact. Following this discussion, Ehrlichman asked Curlie where Hunt's office was located and how the contents of his safe could be removed. Curlie explained that he would have to have GSA open the safe. Colson said it must be done immediately, and Ehrlichman instructed Curlie to have me present when the safe was opened and that I should receive the contents of the safe. Curlie said he would call me when he had made the arrangements, and he left the office. Ehrlichman told me to report to him on the contents of Hunt's safe, and the meeting ended. Curlie called my office after I had departed. He talked with Fred Fielding and asked him to come with him to open Hunt's safe. I do not recall mentioning this to Fielding before I departed, and I do not know what Curli told Fielding, but Curli was aware from the earlier meeting with Ehrlichman that I was to receive the contents of the safe. After departing the office, I believe I went to Mr. Mitchell's apartment. I do not recall who asked me to come to Mitchell's apartment, and it may have been the evening of the 20th rather than the 19th. I recall that when I arrived, Mitchell, Mardian, and Magruder were there, and I gather had been discussing matters before I arrived. I recall listening, but I can only recall discussions on how to handle the matter from a public relations standpoint. I have no other recollection of the meeting. It was on June 20th or 21st that Gordon Strawn and Richard Howard came to my office. Strawn informed me that Haldeman had authorized an expenditure by Colson of some funds, but the entire amount had not been expended, and he was turning over the remainder to me to hold. I told Strawn that I would hold the funds and would be accountable for them. I placed the cash, $15,200, in my safe. I informed Mr. Fielding of my office of the fact that the cash was in my safe and where it had come from. I felt I should inform Fielding because I wanted someone to know why the money was in my safe if anything should happen to me. The cash remained in my safe untouched until October 12, 1972, when I removed a packet of bills amounting to $4,850 and placed my personal check for that amount with the remaining cash. I removed the $4,850 after I had failed to make arrangements to pay for the anticipated expense of my wedding and my honeymoon. I subsequently expended the cash over a several-month period of time as my honeymoon was cut short and the full amount I had anticipated was not necessary. Thus, I used part of the cash for normal daily expenditures. At one point, after I had withdrawn the cash, I returned part of it to the safe and subsequently took it out again when I was later making another attempt after the election to go on a honeymoon. At no time when I was making personal use of part of these funds did I plan or believe that I would not have to account for the entire amount at some point in time. However, as I shall state later, there was great pressure long before October to use any and all available cash to pay for the silence of the individuals involved in the Watergate, and I decided from the outset that I did not want the money I was holding to be used for that purpose. I have never sought to hide this fact that I made personal use of this money from anyone. I informed my lawyers, I informed the government prosecutors in April, and I informed Mr. Dash at the outset of our discussions. The money is presently in a trustee account, which was established after I informed my lawyers of the fact I was holding the funds, and all the records relating to the creation of that account have been turned over to the government, and this committee as well, I believe. As I mentioned earlier in my statement, I met with the Attorney General, Richard Kleindienst, on either Monday the 19th or Tuesday the 20th. I recall that before this meeting I had been asked by Ehrlichman to talk with Kleindienst about the scope of the investigation, and I had already had my meetings with Liddy and Strawn. When I went to Kleindienst's office, I found him totally dismayed and angered that such a stupid thing could occur. He then told me that over the previous weekend, while at Burning Tree Country Club, Liddy, accompanied by Mr. Powell Moore, had sought him out. He said he was incredulous when Liddy stated that John Mitchell had instructed him, that is Liddy, to tell Kleindienst to get the men who had been arrested out of jail. He told me that Liddy was rattled and upset and wanted to talk about the entire matter, but Kleindienst told me that he cut Liddy off and told him he would not talk with him. I told Mr. Kleindienst that I did not have all the facts, but I was very concerned that this matter could lead directly to the President. I told him that I did not know if the President was involved, but I was concerned. I remember Kleindienst saying to me that he certainly hoped that the President was not involved, or that I was not involved in this, and I responded that I certainly had not been involved in any criminal activity. I told him that I had no idea that there was going to be a break-in at the Democratic National Committee headquarters, and I agreed with his continued assertion of its stupidity. I told Kleindienst, without giving him specifics, that I did not know what would happen if the investigation led into the White House, but that I suspected that the chances of re-electing the President would be severely damaged. Kleindienst called Henry Peterson and asked Peterson to come to his office. While we were waiting for Peterson, Kleindienst told me that my superiors at the White House never understood that once an investigation begins, it runs its full course. He said that he was always being asked to take care of this matter or that matter, as if by magic he could make something unpleasant go away. I said that I was well aware of that attitude, and that I'd never been able to get through to anyone at the White House, that things just didn't happen that way. When Peterson arrived at Kleindienst's office, he gave a status report of the investigation. Kleindienst then related my concern to Peterson. Peterson was troubled by the case and the implications of it. Kleindienst had to go to another meeting, so Peterson and I believe the meeting was still in Kleindienst's office, had another meeting in his office. So Peterson and I went into Kleindienst's back office and talked further. To the best of my recollection, we did not discuss specifics. Rather, it was a general discussion. I told him I had no idea where this might end, but I told him that I didn't think that the White House could withstand a wide-open investigation. The sum and substance of our conversation was that I had no idea how far this thing might go, but I had reason, without being specific, to suspect the worst. The meeting ended on that note that I hoped I was wrong. I do not recall ever reporting this meeting to Ehrlichman because he had a somewhat strained relationship with Kleindienst, and I thought that he would raise havoc, that I did not have an assurance from Kleindienst that he would take care of everything. I did report, however, that I felt that Peterson would handle the matter fairly and not pursue a wide-open inquiry into everything the White House had been doing for 4 years. I made this statement not because of anything Peterson specifically said, as much as the impression he gave me that he realized the problems of a wide-open investigation of the White House in an election year. Returning now to the contents of Mr. Hunt's safe. It was mid-morning on Tuesday, June 20th, when the GSA men brought several cartons to my office, which contained the contents of Mr. Hunt's safe. I had learned earlier that morning from Mr. Fielding that the boxes had been secured in Curley's office overnight. Fielding also reported that they had found a handgun in the safe, which Curley had disengaged, a large briefcase containing electronic equipment, and a number of documents, some of which were classified. I told Fielding that I would like his assistance later that day in going through the material. During the afternoon of the 20th, Fielding and I began going through the cartons of Hunt's material. I remembered looking into the briefcase, which contained electronic equipment. I frankly do not know what it was it contained, but it contained loose wires, chapsticks for your lips with wires coming out of them, instruction sheets for walkie-talkies, and as I recall, there were also some antennas in there. We then began sorting the documents. The bulk of the papers were classified cables from the State Department relating to the early years of the war in Vietnam. These were separated out from the rest of the papers. The other papers, I assumed, related to Hunt's work at the White House. Also, there were personal papers. I will attempt, to the best of my recollection, to describe the papers and documents that were found in Hunt's safe. I must point out, however, that I personally did not look at all the documents or read all the documents. Rather, it was a combined effort by Fielding and myself to determine what was in Hunt's safe. First, among his personal papers were copies of his submissions for his per diem pay as a consultant, a few travel vouchers, and an envelope containing materials of a personal nature related to his wife. Among the papers that I assume related to his work at the White House were numerous memoranda to Chuck Colson regarding Hunt's assessment of the plumbers unit operation and critical of Mr. Krog's handling of the matters, a number of materials relating to Mr. Daniel Ellsberg, such as news clippings and a psychological study of Mr. Ellsberg, which apparently had been prepared by someone who'd never actually met or talked with Mr. Ellsberg. A bogus cable, that is, other cables that had been spliced together into one cable, regarding the involvement of persons in the Kennedy administration in the fall of the DM regime in Vietnam. A memorandum regarding some discussion about the bogus cable with Colson and Mr. William Lambert. Some materials relating to an investigation Hunt had conducted for Colson at Chappaquiddick. some materials relating to the Pentagon Papers, and a paperback book containing published Pentagon Papers. Upon examining the contents of the safe, I recall that Fielding and I discussed our concern about the public impact some of these documents might have if they became public, particularly in an election year. I requested that Fielding remove the politically sensitive documents from the others, which he did. The classified State Department cables were too bulky for my own safe, so I called David Young and requested that he store them for me in his office, as I assumed at that time that they would probably be returned to the State Department. I told Young, when he came to pick up the materials, that they had come from Hunt's safe and he should store them all together until I told him what to do with them. Accordingly, Mr. Young took the State Department documents to his office. The large briefcase was stored in a locked closet in my office suite, and the politically sensitive documents and Hunt's personal papers were placed in a safe in my office. The remaining materials were left in the cartons on the floor of my office. I subsequently met with Mr. Ehrlichman to inform him of the contents of Hunt's safe. I gave him a description of the electronic equipment and told him about the bogus cable, the materials relating to Ellsberg, and the other politically sensitive documents. I remember well his instructions. He told me to shred the documents and deep six the briefcase. I asked him what he meant by deep six. He leaned back in his chair and said, "You drive across the river on your way home at night, don't you?" I said, "Yes." He said, "Well, when you cross over the bridge on your way home, just toss the briefcase into the river." I felt very much on the spot, so I told him in a joking manner that I would bring the materials over to him and he could take care of them because he also crossed the river on his way home at night. He said, "No, thank you," and I left his office and returned to my office. After leaving Ehrlichman's office, I thought about what he had told me to do and was very troubled. I raised it with Fielding, and he shared my feeling that it would be an incredible action to destroy potential evidence. I think Mr. Fielding appreciated my quandary. When Ehrlichman said do something, he expected it to be done. I decided to think it over. I did take the briefcase out of my office because the closet that it was being stored in was being used by the secretaries in the office. I did not have an available safe to hold the large briefcase. I was also giving serious consideration to Ehrlichman's instructions. Accordingly, I placed the briefcase in the trunk of my car, where it remained until I returned it to the office after I'd reached the decision that I could not follow Ehrlichman's instructions. I will explain in a few minutes how I handled the material in Hunt's safe, but before doing so, I should like to continue with the sequence of events. To the best of my recollection, it was on the 20th or 21st that Colson told me in a casual conversation in the hall outside of his office about an incident he thought was painfully humorous. He told me that a member of his staff, Mr. Douglas Hallett, had an office in the same suite with Hunt, and that Hallett was talking with a wire service reporter while Hunt was in the other office. Colson said to me something to the effect, "Can you believe what a story that reporter might have had if Hunt had come walking out of his office while Hallett was being interviewed?" Colson gave me the impression that this incident had occurred on June 17th or June 19th, but I do not recall which. However, I do recall Colson telling me that it had occurred, and Colson was very concerned about his relationship with Hunt. To the best of my recollection, the FBI contacted me during the morning of June 22nd and requested an interview with Colson. I so informed Colson, and an interview was arranged for that day. Colson said that he wanted me present when he was interviewed and also wanted me to meet with me prior to the interview. He was insistent that I be present because he was concerned that the FBI report of the interview might not be accurate, and he wanted someone else to attest to his story. Colson came to my office shortly before the scheduled meeting with the FBI. He said he did not wish to get into unrelated matters and said that, again, that he had no information regarding the Watergate. I told him I presumed that the agents would only be interested in his knowledge about the Watergate and his relationship with Hunt. The agents arrived, identified themselves, and somewhat to my surprise gave Colson a warning of his rights, which he waived. I believe that the committee has access to Mr. Colson's FBI interview, which was rather brief, in that Colson imparted very little information to them. I did not inject myself in the interview at any time, but did make rough notes of the items covered. In fact, I believe this was the only interview where I made any notes at all. I made these notes because Colson had expressed his concern before the interview regarding someone later being able to attest to his story. I have submitted to the committee, exhibit number 14, the rough notes, which have also been transcribed from my own handwriting. The rough notes I hastily jotted down during the interview, and I find them very revealing in light of the statement that was made during the nomination hearings of Mr. Pat Gray for the FBI directorship, and would like to digress for a moment regarding the comment that was made during those hearings that Dean probably lied to the FBI as to whether Hunt had an office in the White House. During the interview of Mr. Colson on June 22nd, the agents asked him if Mr. Hunt had an office at the White House. Colson responded that he thought Mr. Hunt had an office in the Executive Office Building, but he did not know where it was located. The question came up about midway through the interview and was not, as I recall, pursued further at that point by the agents, other than a question to me as to whether it would be possible to get the room number. I said yes. At the end of the interview, and as the agents were departing, they asked me if they could see, not whether Mr. Hunt had, but rather whether he could see Mr. Hunt's office right then. I told them I'd have to check it out and get back to them. Those are the facts as I remember them, and Colson happened to stop by my office the day that Gray said I had probably lied. I asked Colson for his recollection of the matter, and he stated that he remembered it as I had remembered it. At that time, I had forgotten that I had made the notes during Colson's interview, which clearly reflect to me that Colson had stated during the interview that Hunt had an office in the White House. A few days after Colson's interview, I had called the agents and told them that I had the materials from Hunt's office and would get them to them shortly. I learned after Mr. Gray had made his statement during his nomination hearings that he had based the statement, or based his conclusion, on a report written by the agents some 7 months after the incident. When I talked with Gray about the matter during his nomination hearing, and he informed me that he did not feel he could retract the statement without creating more problems, I told him I did not think that the agents involved should be brought into the matter because I was sure that they had honestly reported the matter as they had remembered it. I had dealt with the agents involved on several occasions, and I felt that they had called it the way they had remembered it, so I let the matter drop and decided I would just have to take the rather unpleasant heat and live with it. Mr. Chairman, this would be a point where I could summarize in part of this statement regarding handling of the FBI interviews at the White House, and just merely state generally that they followed a very similar pattern.
If you could, that would be all right. If you could indicate for the committee the pages on which the statements are made, which you summarize, so we can have those pages printed along with,
all right, sir,
in full in the body of the record.
I'll summarize beginning at the bottom of page 63 through 66, and merely note to the committee that the handling of the FBI interviews at the White House followed the pattern that had been first established by the interview with Mr. Colson. I had cleared this procedure with Mr. Ehrlichman. He thought it was a good idea. I was there. I was there when he was present, when he was interviewed, and I think that the material is self-explanatory as to any questions the committee might have regarding those interviews. I'll now turn to my first meetings with Mr. Gray, beginning on page 66, regarding the investigation. I believe it was on June 21st that I first met with Mr. Gray in his office in late morning regarding the FBI investigation. At that meeting, he told me he fully realized the sensitive nature of the investigation that they were pursuing, and that he had placed his most trusted senior people in charge of the investigation. I told Gray I had been asked to keep informed about the investigation. Mr. Gray told me that he had been visiting a number of regional offices and would continue to do so in the future. Thus, if I needed information, I should call Mr. Mark Felt in his absence. I might note at this point that indeed Gray was frequently absent from the city during the course of the investigation, and this irritated Ehrlichman greatly when he asked me to get some information from Gray, and Gray was out of the city. On several occasions, in fact, Ehrlichman instructed me to tell Gray to return to the city and mind the store. I passed this message to Gray, but I cannot recall when or what prompted Ehrlichman to have me do so. I do recall that there, on one occasion, that related to some recently major leaked information that had come out of the FBI. During my meeting with Gray on the 21st of June, he also told me a man by the name of Mr. Bates was heading the investigation. I do not know Mr. Bates, and when I reported this back to Ehrlichman, he asked me who Bates was. I told him I did not know Bates. I can recall on several occasions Ehrlichman asking me if I thought that Gray knew what he was doing and if he had the investigation under control. I responded that he seemed to be relying on men in whom he had full trust. To the best of my recollection, it was during this June 21st meeting with Gray that he informed me that the FBI had uncovered a number of major banking transactions that had transpired in the account of one of the arrested Cubans, Mr. Barker. He informed me that they had traced a $25,000 check to a Mr. Kenneth Dahlberg and 4 checks totaling $89,000 to a bank in Mexico City. I do not recall whether I first learned about the Dahlberg check from Mr. Gray or whether I learned about it in a meeting in Mr. Mitchell's office by reason of the fact that the FBI was trying to contact Mr. Dahlberg about the matter, and Dahlberg had called Mr. Stans. At any rate, the fact that the FBI was investigating these matters was of utmost concern to Mr. Stans when he learned of it. Stans was concerned about the Dahlberg check, I was informed, because it was in fact a contribution from Mr. Dwayne Andreas, whom I did not know, but I was told was a longtime backer of Senator Hubert Humphrey. Neither Stans nor Mitchell wanted Mr. Andreas to be embarrassed by disclosure of the contribution. The concern about the Mexican money was made a little less clear to me. I was told that it was a contribution from a group of Texans who had used an intermediary in Mexico to make the contribution. Although I had not been told, I assumed at that time that they were concerned because it sounded to me as if it might have been a corporate contribution and clearly in violation of the law. Mr. Stans also explained that he had checked with Sloan to find out how this money had ended up in Mr. Barker's bank account, and Sloan reported that he had given the checks to Liddy and requested that he cash them. He said that he had no idea how Liddy had cashed them, but surmised that he had obviously used Barker to cash them. I was also told, and I do not recall specifically who told me this, that this money had absolutely nothing to do with the Watergate. It was unrelated, and it was merely a coincidence of fact that Liddy had used Barker to cash the checks, and Liddy had returned the money to Sloan. I was told that the investigation of this matter, which appeared to be connected with the Watergate but wasn't, was unfounded and would merely result in an unnecessary embarrassment to the contributors. Accordingly, Mitchell and Stans both asked me to see if there was anything the White House could do to prevent this unnecessary embarrassment. I, in turn, related these facts to both Haldeman and Ehrlichman. On June 22nd, at the request of Ehrlichman and Haldeman, I went to see Gray at his office in the early evening to discuss the Dahlberg and Mexican checks and determine how the FBI was proceeding with this matter. Mr. Gray told me that they were pursuing it by seeking to interview the persons who had drawn the checks. It was during my meeting with Mr. Gray on the 22nd that we also talked about his theories of the case as it was beginning to unfold. I remember well that he drew a diagram for me showing his theories. At that time, Mr. Gray had the following theories. It was a set-up job by a double agent. It was a CIA operation because a number of former CIA people were involved, or it was someone in the re-election committee who was responsible. Gray had also had some other theories which he discussed, but I do not recall them, but I do remember that those that I have mentioned were his principal theories. Before the meeting ended, I recall that Gray and I again had a brief discussion of the problems of the investigation into the White House. Gray expressed his awareness of the potential problems of such an investigation and also told me that if I needed any information, I should call either Mark Felt or himself. Gray also informed me that he was going to meet with the CIA to discuss their possible involvement, and he would let me know the outcome of that meeting. On June 23rd, I reported my conversation with Gray of the preceding evening to Ehrlichman and Haldeman. We discussed the Dahlberg and Mexican checks and the fact that the FBI was looking for answers regarding these checks. I had the impression that either Ehrlichman or Haldeman might have had a conversation with somebody else about this matter, but this is mere speculation on my part at that time. Within the first days of my involvement in the cover-up, a pattern had developed where I was carrying messages from Mitchell, Stans, and Mardian to Ehrlichman and Haldeman and vice versa about how each quarter was handling the cover-up and the relevant information as to what was occurring. I was also reporting to them all the information I was receiving about the case from the Justice Department and the FBI. I checked with Haldeman and Ehrlichman before I did anything. One of the few sets of early documents evidencing this working relationship with Haldeman and Ehrlichman relates to responding to Larry O'Brien's letter of June 24th to the President requesting the appointment of a special prosecutor. I have submitted these documents to the committee, Exhibit number 15. Consistent with the reporting pattern that had developed, I reported to Mitchell in a meeting also attended by Mr. Mardian and Mr. LaRue, Gray's theories of the case as he had related them to me. This meeting occurred, to the best of my recollection, on Friday afternoon, June 23rd, or Saturday morning, June 24th. During this meeting, there were wide-ranging discussions of the many problems then confronting the re-election committee, including such matters as the problem of the civil lawsuit filed by the Democratic National Committee and the problems that could cause, the problem of the Dahlberg and Mexican checks, and to the best of my recollection, this was the first time I had heard any discussion of the need for money to take care of those who were involved in the break-in of June 17th. I think also, Mr. Vice Chairman, I might omit the first paragraph here on page 71 and proceed with regard to my receipt of the reports.
Mr. Dean, that'll be entirely agreeable, and as the chairman asked you previously, if you'd note for the record that point in your statement where you resume, and we'll have an appropriate identification.
All right, I will leave out the first paragraph on page 71 and begin by summarizing and saying that to the best of my recollection, it was in early July when I called Gray to discuss the matter of receiving reports from the FBI. Gray indicated that he was going to be in his office on a Saturday, and I should come to his office and take a look at the reports in his office. I told him that I thought that it was unwise for me to be coming in and out of the Justice Department, particularly since most of the guards and people at the Justice Department knew me. Accordingly, we arranged to meet later at his apartment, and he said that he would discuss the matter with me then. I recall we took a stroll up to the side of his apartment building, sat on a bench in front of the river, and talked generally about the case, and I raised with him the matter of my receiving some of the raw FBI data regarding the investigation. Gray said that he would have to check, but wanted an assurance from me that this information was being reported to the President, and that was the principal purpose of the request. I assured him that it was being reported to the President. Even though I was not directly reporting to the President at that time, I was aware of the fact that Ehrlichman and Haldeman had daily discussions with the President, and I felt certain, because Haldeman often made notes of my reporting back about the information I was bringing to their attention, that this information was being given to the President. I do not recall when I actually received the first written information from the FBI, but I believe it was after the 21st of July when I had received a summary report that had been prepared on the investigation to that stage. I would also like to now summarize to the bottom of the page and indicate that when 72, correct. And indicate that after I did get possession of the documents, the FBI files, I found them not very meaningful, and later Mr. Marty and Mr. Parkinson and Mr. O'Brien came over to my office and read the reports, and Marty and they all reached the same conclusion, and I recall that Mardian's reaction was that the documents indicated that the investigation was too vigorous, and he was quite critical of Gray and asked me to call Gray to slow down, but I never made such a call. Summarizing the first paragraph on page 73, I'd also note that I never showed any of these reports to any persons who were interviewed by the FBI, and they were only given to Mr. Dick Moore of the White House staff when he was working on the Segretti matter for Mr. Ehrlichman and Mr. Haldeman.
John Dean has been explaining his role as White House Counsel during the post-Watergate investigations, and he will next explain a plan to involve the Central Intelligence Agency in the cover-up, and public television's coverage of the Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service.
By summarizing and saying that, to the best of my recollection, it was in early July when I called Gray to discuss the matter of receiving reports from the FBI. Gray indicated that he was going to be in his office on a Saturday and I should come to his office and take a look at the reports in his office. I told him that I thought that it was unwise for me to be coming in and out of the Justice Department, particularly since most of the guards and people of the Justice Department knew me. Accordingly, we arranged to meet later at his apartment, and he said that he would discuss the matter with me then. I recall we took a stroll up to the side of his apartment building, sat on a bench in front of the river, and talked generally about the case, and I raised with him the matter of my receiving some of the raw FBI data regarding the investigation. Gray said that he would have to check, but wanted an assurance from me that this information was being reported to the President, and that was the principal purpose of the request. I assured him that it was being reported to the President. Even though I was not directly reporting to the President at that time, I was aware of the fact that Ehrlichman and Haldeman had daily discussions with the President, and I felt certain, because Haldeman often made notes of my reporting back about the information I was bringing to their attention, that this information was being given to the President. I do not recall when I actually received the first written information from the FBI, but I believe it was after the 21st of July when I had received a summary report that had been prepared on the investigation to that stage. I would also like to now summarize to the bottom of the page and indicate that when 72, correct. And indicate that after I did get possession of the documents, the FBI files, I found them not very meaningful, and later Mr. Marty and Mr. Parkinson and Mr. O'Brien came over to my office and read the reports, and Marty and they all reached the same conclusion, and I recall that Mardian's reaction was that the documents indicated that the investigation was too vigorous, and he was quite critical of Gray and asked me to call Gray to slow down, but I never made such a call. Summarizing the first paragraph on page 73, I'd also note that I never showed any of these reports to any persons who were interviewed by the FBI, and they were only given to Mr. Dick Moore of the White House staff when he was working on the Segretti matter for Mr. Ehrlichman and Mr. Haldeman.
John Dean has been explaining his role as White House Counsel during the post-Watergate investigations, and he will next explain a plan to involve the Central Intelligence Agency in the cover-up, and public television's coverage of the Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Former White House Counsel John Dean now explains a plan to blame the Watergate on the CIA.
I'll turn now to the first dealings I had with the CIA. It was during the meeting in Mitchell's office on the 23rd or the 24th that Mardian first raised the proposition that the CIA could take care of this entire matter if they wished, in that they had funds and covert procedures for distributing funds. I was personally unaware of the workings of the CIA, but Mardian and Mitchell appeared very knowledgeable. As a result of this conversation, which was prompted by my reporting that Gray thought that the CIA might be involved, Mitchell suggested I explore with Ehrlichman and Haldeman having the White House contact the CIA for assistance. It was also argued that the individuals involved in the Watergate incident as former CIA operatives might compromise the CIA in some manner, and that the CIA should be interested in assisting. On Monday morning, June 26, I spoke with Ehrlichman regarding this suggestion. He thought it was a good idea and worth exploring. He told me to call the CIA and explore it with them. I told him that I had never dealt with anyone in the CIA and did not know Director Helms. He told me that I should not call Helms, rather General Walters. I told him I did not know Walters either. He then told me that he and Haldeman had had a little chat, as he called it, with Helms and General Walters a few days earlier about their dealings with the FBI in relationship to the investigation. He was not specific. He told me that I should deal with General Walters because he was a good friend of the White House, and the White House had put him in the deputy director position so they could have some influence over the agency. He told me I should tell General Walters that I was calling because he, Ehrlichman, had requested I follow up on the earlier meeting that they had had, and if there were any problems, General Walters should call him. After my meeting with Ehrlichman, I telephoned General Walters and told him I was calling on Ehrlichman's request on a matter relating to his previous discussions with Ehrlichman and Haldeman, and would like to have him visit with me if possible. He seemed somewhat surprised and uncertain about my call, so I told him he might like to check with Mr. Ehrlichman. He said he would get back to me later, and he did get back to me later, and we set up a meeting for about noon of that day. When General Walters came to my office, I told him again that I was meeting with him at Ehrlichman's request. I made some general comments about the Watergate case, and it was from my discussion as a result of these general comments with Walters that I became aware of the fact that Ehrlichman and Haldeman had discussed the Dahlberg and Mexican money. We then discussed the fact that some of the leads that the FBI were pursuing, to my understanding, were unrelated to the Watergate, but could result in persons totally uninvolved being embarrassed. I'd just like to note to counsel for the record here, some of this is different than the original pagination of my draft that might have been lost in the transcribing of it here. I also told him that I understood that the FBI had developed 3 possible theories of the case, which I explained and then asked if, in fact, any of the men arrested were persons who were working at the CIA. General Walters assured me they were not. I then told him that I had been asked to explore every possible means of dealing with this rather embarrassing and troublesome situation, because some of the men involved were looking for assistance. I asked him if there was any possible way the CIA could be of assistance in providing support for the individuals involved. General Walters told me that while it could, of course, be done, he told me that he knew the director's feelings about such a matter, and the director would only do it on a direct order from the president. He then went on to say that to do anything to compound the situation would be most unwise, and to involve the CIA would only compound the problem because it would require that the president become directly involved. While I cannot recall in detail everything General Walters told me, I do recall that his argument was most sound and very persuasive. I told him I agreed with his position fully, and I had merely been asked to explore the potential, which he very rightly stated was too great a risk. As the discussion ended, I asked him if he had any further ideas, and told him I would appreciate the benefit of his thoughts. I thanked him for his coming over and his candid answers, and he departed. Subsequent to my meeting with General Walters, I reported back to Ehrlichman that Walters had informed me that any involvement by the CIA in this matter was impossible. I recall that when I reported this to Mr. Ehrlichman, he very cynically said, "Very interesting." He told me that I should talk with Walters further and push him a little harder to see if the CIA could help out, particularly with regard to the unnecessary pursuit of investigative leads. I also recall Ehrlichman saying something to the effect that General Walters seems to have forgotten how he got where he is today. I'd like to skip the paragraph on page 77 regarding the call from Gray and turn to the last paragraph on 77. On the morning of June 28th, I arranged to meet with General Walters. I was first embarrassed about requesting the meeting because he had been most explicit and convincing to me at the first meeting. I told him that I requested the meeting at Ehrlichman's behest to further discuss the problems of the Dahlberg and Mexican checks. I told him what I knew about the matter, and that to the best of my knowledge, they were not related to the Watergate incident. I then asked him if he had any suggestions. He expressed sympathy over the situation, but said there was nothing his agency could do. He again explained the reasons similar to his earlier comments regarding the CIA involvement, and I expressed my understanding. I then asked him if he had any ideas at all, and he said that it might be possible to explain the matter as an anti-Castro activity. We had some general discussion of this, but nothing concrete emerged from the discussion. Before Walters departed, I assured him that I agreed that it would be most unwise to involve the CIA. I thanked him almost apologetically for coming by again. At no time did I push him as I had been instructed. At the conclusion of this meeting, I was totally convinced, as I had been earlier, that the CIA could not and would not be brought in to solve the problems confronting the White House and the re-election committee as a result of the Watergate incident. I subsequently informed Ehrlichman and Haldeman that unless the President directly ordered the CIA to provide support for those involved, that the CIA was not going to get involved. I told them I agreed with Walters that this would be a terrible mistake, and they both told me they agreed. I would now like to explain the transmitting of the material in Hunt's safe to the FBI. As I noted earlier, shortly after the FBI interview on the 22nd of Mr. Colson and my later instructions from Ehrlichman to Deep Six the briefcase and shred the documents, I had informed the FBI that I would forward the material found in Hunt's office. After weighing the implication of Ehrlichman's instructions to destroy the items, I decided I would not engage in any such activity myself or be pushed into it. Accordingly, I asked David Young to return the State Department cables to my office. I had already returned the briefcase from my car trunk to my office. I received several calls from the FBI requesting the material, but I had not yet figured out how to tell Ehrlichman I was not going to destroy the material. I knew I had to develop a good argument to give Ehrlichman as to why the materials should not be destroyed. On the 25th or 26th of June, I went to Ehrlichman and explained that I thought that the men who had drilled the safe had probably seen the briefcase, that the Secret Service agent who had been present had probably seen some of the material, that Mr. Curley and Mr. Fielding had seen it, and what would happen when all those people were later asked by the FBI about the contents of the safe. Then I said I felt we must turn over the materials to the FBI. With regard to the sensitive documents, I suggested they be given directly to Gray. I told Ehrlichman that, if ever under oath, I had to be able to testify, to the best of my knowledge, everything found in the safe had been turned over to the FBI. The FBI agents came to my office, I believe on the 26th or 27th of June. I gave them one box which had been packed and told them that as soon as I got the other materials packed, I would give it to them. When I got tied up in a meeting, I phoned Mr. Fielding and asked him to pack up the remainder of the material, which I believe was the State Department cables in the briefcase. He did so and turned over the material to the FBI, with the exception of the 2 envelopes which contained the political sensitive materials I described earlier. I spoke with Ehrlichman on the 28th and informed him that the material had been sent to the FBI with the exception of the politically sensitive documents. He told me that he was meeting later that day with Gray and I should bring the materials over to him at that time. I went to Ehrlichman's office just before Mr. Gray arrived. I placed the envelopes on a coffee table in his office. When Gray arrived, Ehrlichman told him that we had some materials for him that had come from Hunt's safe. Ehrlichman described it as politically sensitive, but not related to the Watergate. I told Gray that Fielding and I had gone through Hunt's documents and had turned over all of the materials to the agents except the documents in these two envelopes. I said that I did not believe that they related to the Watergate in any way, but should they leak out, they would be political dynamite in an election year. I believe at that point, Gray placed the two envelopes in his briefcase. At no time when I was present with Gray and Ehrlichman was he instructed by myself or Ehrlichman to destroy the documents. Rather, he was merely told that they must never be leaked or made public. I departed and returned to my office. The next time the fact of giving these documents to Gray came up was shortly before the criminal Watergate trial in January of this year. Fielding, Curley, and I were being interviewed by the prosecutors regarding the handling of materials in Hunt's safe to establish the evidentiary chain. At one point in the interview, I asked Henry Peterson, who was present with Mr. Earl Selbert, if I could speak with him privately. At that time, I felt I had to tell Peterson that not all the materials from Hunt's safe had gone directly to the agents. Rather, the two envelopes of material, the contents of which I could not itemize any better then than I can now, had been given directly to Gray. I told Peterson that if I were to testify, I would have to reveal this fact. Mr. Peterson suggested that the interview be terminated, which it was, and that they would get back to me, and we could contemplate it on another day. I was not called, and as not because of, I think, my knowledge, but because of other intervening events on a motion that Mr. Bittman had filed not being pursued, that Fielding and Curley testified as to the evidentiary chain at the trial. I recall that shortly after this meeting in Peterson's office, when I disclosed these facts to Peterson, I talked to Gray at a Department of Justice luncheon. After the luncheon, he came up to me and told me I must hang tight and not disclose his receipt of the documents. He also informed me that he had destroyed the documents. I told Ehrlichman about this shortly after Gray told me that he had destroyed the documents, and when Ehrlichman called me just before the President selected Gray as his nominee for director of the FBI, Ehrlichman asked me if I had any problems with Gray, and I reminded him of the destruction of the documents. He indicated that this was not a problem. It was after I commenced my informal interviews with the Watergate prosecutors in early April of this year that this subject arose again. I repeated my story as I have to this committee. They later informed me that Gray denied having ever received such documents. This was the first issue of fact that arose in my discussions with the prosecutors, so my attorney requested I take a polygraph test, which I did. Subsequently, as is now public knowledge, and not to my surprise because I believe that Mr. Gray is both an honorable and truthful man, he has admitted that he had received and destroyed the documents. I would now like to turn back again to the end of June, 1972.
The wish of the chairman, who had to go to the floor of the Senate to attend to other business, that we continue to about 12:30 and recess for lunch, if that's agreeable with you. And I would judge then you might have time to finish this sequence and recess then a little before 12:30.
I think on page 97 would be a good break.
Well, we'll see how far the witness can get then to get us to 12:25 or thereabouts.
The witness only has part one of the statement that was given him by the committee this morning.
Now, I understand there's another part that's another 150 pages or thereabouts, so we're anxious to go as long as we can, but you've been reading now for 2.5 hours almost, so another 10 minutes, I think, and then we'll break for lunch.
Fine. As I mentioned, I would like to turn back again to the end of June 72. After my meeting with General Walters and subsequent meetings with Mr. Holloman and Ehrlichman, I informed Mitchell that there could be no CIA assistance. To the best of my recollections, this occurred on the afternoon of June 28th in a meeting in Mr. Mitchell's office, and I believe that Mr. LaRue and Mr. Mardian were also present. There was a discussion of the need for support money in exchange for the silence for the men in jail, and if the CIA could not do it, they would have to find the money somewhere else. Mr. LaRue indicated that Stans had only a small amount of cash. I believe he said $70,000 or $80,000, but more would be needed. After some discussion, which I cannot recall with any specificity at this time, Mitchell asked me to get the approval of Haldeman and Ehrlichman to use Mr. Herbert Kalmbach to raise the necessary money. Before I departed the meeting, I remember that Mr. Mitchell, in an aside for my ears only, told me that the White House, in particular Ehrlichman, should be very interested and anxious to accommodate the needs of these men. He was referring to the activities that they had conducted in the past that related to the White House, such as the Ellsberg break-in. I conveyed this request to Haldeman and Ehrlichman, and they told me to proceed to contact Mr. Kalmbach. I called Mr. Kalmbach on the 28th of June and told him that Haldeman, Ehrlichman, and Mitchell had requested he come back to Washington as quickly as possible. He told me he would take the next flight. I met Kalmbach at the Mayflower on the 29th of June. When we first met in the coffee shop, but could not find sufficient privacy to talk, so we went to his room. I'd always been very open in my dealings with Mr. Kalmbach, and I knew that he had stated, after he completed his fundraising activities prior to April 7th, 1972, that he did not wish to engage in any further fundraising activities. So I told him everything I knew about the case at that time, including my concern that it might involve the President himself, but I did not know that for a fact. I also told him that Haldeman and Ehrlichman and Mitchell felt it was very important that he raise the money. I told him that per Mitchell's instructions, he should contact Fred LaRue as to the amounts needed and the timing. I knew that Kalmbach was not happy with this assignment, and he said he was undertaking it only because Mitchell, Haldeman, and Ehrlichman had so requested. I do not know if Mr. Kalmbach discussed this with any of these persons, but given the nature of the request, I did not expect it to take my word alone. I had never before given Kalmbach any instructions to raise money or ever passed on any similar instructions to him. Subsequent to our meeting, Kalmbach informed me that he was departing to raise money, but that he wanted Mr. Ulasewicz to handle any deliveries because Mr. Ulasewicz was the only man he would trust. He said he did not have his telephone number and requested that I call Jack Caulfield and request that Mr. Ulasewicz call him in California. I called Mr. Caulfield and made the request, but did not tell Mr. Caulfield the reason Kalmbach wanted to have Mr. Ulasewicz call him. Within a week or so, Kalmbach returned to Washington and requested that I meet with him in Lafayette Park, which I did. He said I could report to Haldeman and Ehrlichman that he had raised the money, and in fact, he had it in his briefcase with him. To the best of my recollections, he told me he was en route to meet Mr. Ulasewicz, but wanted me to know that the job was done. Following that meeting, and several days later, as I recall, he called me again and said that he had asked Fred LaRue to come to my office to give him the details of who was to get how much. I recall that such a meeting did occur in my office, but I was on and off the telephone while LaRue and Kalmbach were going over the figures, and I have absolutely no recollection of the details of their discussion. I know that LaRue had the figures on a sheet of paper, and that Kalmbach wrote them down in his own code on a small piece of paper, which he placed in his wallet. I have no further knowledge of how or when or to whom the deliveries were made. Mr. Kalmbach merely told me later that it had been done, and I passed this on to Ehrlichman and Haldeman. I'd like to return once again to the period of June 21st through June 30th in discussing the matter of Mr. Mitchell and Mr. Magruder remaining at the Re-Election Committee. As I have indicated, I had frequent discussions with Ehrlichman and Haldeman in which I would report back to them on information they had requested or report information I had received. It was sometime during the last 10 days of June that I recall a meeting in Mr. Haldeman's office in which they asked me for my recommendation regarding removing Mitchell and Magruder from the Re-Election Committee. This discussion preceded my contacting Kalmbach. At that time, I repeated my knowledge of the meetings which had occurred in Mr. Mitchell's office in January and February when Liddy was presenting his proposal. I told him I did not know for a fact that Mitchell had ever approved Liddy's plans, but Magruder had recently inferred to me that Mitchell was aware of the operation. I told him that I had never discussed it with Mr. Mitchell himself, and the only observation I could make was that the Watergate matter appeared to be consuming most of Mitchell's time, which might distract him from the campaign. With regard to Magruder, I repeated what Liddy had told me regarding Magruder's pushing him into doing the break-in at the Democratic National Committee. I also said that I thought there was a real chance that he could be indicted, although Mitchell and Magruder thought that the matter might be stopped at Liddy. Accordingly, I told them that I did not think I could make a recommendation regarding Mitchell, but I did recommend that Magruder be removed in a graceful manner that would not unduly jeopardize him. They thanked me. They told me they would take my recommendations under advisement. The next time I heard anything about this subject was when it was publicly announced that Mr. Mitchell was resigning. I was somewhat startled that Magruder was remaining. It was clear that Magruder was the only link back to the White House, and Magruder might not stand up if indicted. I recall Haldeman asking me if I thought Magruder would stand up if indicted, and I said no. I said I have always assumed it was a presidential decision to keep Magruder on at the re-election committee. Following this decision, Ehrlichman and Haldeman indicated a greatly increased interest in Magruder's problems. They were aware of the strategy to stop the involvement at Liddy because I had reported to them on the story that Magruder would tell, that is, that he did not know what Liddy was doing. They frequently asked me how Magruder was doing in relationship to the FBI and the grand jury investigation. I also had calls from Mr. Larry Higbee as to Magruder's status. I do not know when I first learned of Magruder's proposed testimony, but I do know that it had already been formulated when I first heard it. I informed Haldeman and Ehrlichman of this story. We discussed it, and no one was sure it would hold up. This discussion did occur before Mitchell resigned. We, of course, knew that it was a fabricated story. When I later learned that Mr. Porter would corroborate Mr. Magruder's testimony, I informed Haldeman and Ehrlichman of that. I had never heard Mr. Magruder's story in full detail until just before his grand jury appearance in mid-August 1972, when he asked me if I would be a devil's advocate and question him before he went before the grand jury. Magruder came to my office, as I recall, the day before his second grand jury appearance, and he told me that he had made the decision himself as to how he was going to handle his testimony and wanted me to ask him any and all questions I could think of. I spent about an hour or more questioning him. Shortly after I had this session with Magruder, Higbee called me to tell me that Magruder had been to see him to let Haldeman know that he was ready. Following Magruder's appearance before the grand jury, I received a call from Higbee requesting information for Haldeman as to how Magruder had done before the grand jury. I subsequently called Mr. Peterson, who said he would find out and call back. Peterson called back and said that he had made it through by the skin of his teeth. I called Haldeman and so informed him, and subsequently informed Mitchell and Magruder. I recall that Haldeman was very pleased because this, of course, meant that the investigation would not go beyond Liddy. In early September, Paul O'Brien came to my office and informed me that there was an outstanding subpoena for Magruder's diary. O'Brien said that Magruder's diary reflected the meetings in Mitchell's office in January and February with Liddy, Magruder, Dean, and Mitchell. O'Brien also informed me that there had been discussions of destroying or altering the diary, but he did not think much of that. I agreed that to alter it would be impossible because it would be discovered by the FBI laboratory. I remember talking with Magruder and asking him why he kept a diary, being somewhat facetious. I told Magruder that he should talk with Mitchell about this because he was probably going to have to turn the diary over. Long before the matter of Magruder's diary had arisen, I had talked with Mitchell about the meetings in January and February in his office. I told him that should it ever be necessary, I would testify that I knew that he had not approved anything at these meetings. It was after the matter of Magruder's diary being subpoenaed and Magruder again being recalled to testify before the grand jury that Mitchell requested that I meet with him and Magruder to discuss how Magruder should handle this matter before the grand jury. During the meeting at which this was discussed, I told Mitchell and Magruder that I had no idea what they had discussed before I arrived late at the second meeting in February. I said I recalled there was some reference to the election laws at the first meeting, and Magruder could explain my presence with Liddy at the meeting by reason of the fact of the election law discussion. Magruder liked the idea and said that that was how he would handle it. I later learned that Magruder testified that one of the meetings had been canceled, that the meeting that did occur was to introduce Liddy to Mitchell and had dealt with the election law problems. I assume that these refinements to the story were added by Magruder because they were not discussed at my meeting with Mitchell and Magruder.
Mr. Dean, that would seem to be a convenient breaking place. I notice on the next page, 91, that The heading is Appearances of White House Personnel Before the Grand Jury. So if you have no objection to it, the committee will stand in recess until 2 o'clock.
Mr. Vice Chairman, we'd simply like to announce that we are not going to be available for interview with the press until his next appearance, and I want to save them the trouble of trying to reach him.
Thank you very much.
Former White House Counsel John Dean has been telling the Watergate Committee about the cover story concocted to explain the meetings early in 1972 when the campaign intelligence plan, including the Watergate incident, was approved. His next topic will be the testimony of White House staff members before the Watergate grand jury. Public television's complete coverage of the hearings continues after station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
John Dean now continues his testimony of the activities of White House aides during the Watergate investigation.
The committee will come to order. Mr. Dean, I realize that when you have to do so much reading, it sometimes gets pretty hard on your voice. And any time that you feel like that you need a little break to sort of relieve your voice, just let me know and we'll certainly grant it to you.
I appreciate that very much, Mr. Chairman.
I expect that's so too. Yeah, that's pretty bad.
If the chairman is ready, I'll proceed. When we stopped before lunch, I was just commencing on page 91 of the appearances of the White House personnel before the grand jury. I shall now turn from the matter of Magruder's appearances before the grand jury to the appearances of members of the White House staff before the grand jury. The handling of appearances of the White House staff before the grand jury was very similar to the procedure that had been followed with regard to their interviews by the FBI. By that I mean either Mr. Fielding or myself would discuss with the individual before he went to the grand jury the likely questions he would be asked, the unrelated areas that we didn't feel it was necessary for the individual to get into. When Colson learned that he was going to be called before the grand jury, he was outraged. He felt that the press had been rather hostile towards him because of his association with Mr. Hunt, and his appearance in the courthouse before the grand jury would be most detrimental. He was very insistent that something be done about the situation and asked me to see if I could do anything to help him. I called Henry Peterson and discussed this with him and asked him if there was anything that could be done. Peterson told me he would explore it. Peterson called back and said he appreciated the problem of the White House staff people coming down to the courthouse to appear before the grand jury, and he had worked out an arrangement whereby they could come to the Department of Justice, be interviewed by the prosecutors with counsel present, and then the prosecutor would take a sworn statement without counsel present as if it were a secret grand jury room, and later the prosecutors would read the statement to the grand jury. This procedure was followed, as I recall, for Mr. Colson, Mr. Krogh, Mr. Young, Mr. Chapin, and Mr. Strawn. When Secretary Stans learned that he was being called before the grand jury, he expressed a similar outrage and requested a procedure like that which had been given members of the White House staff. I discussed this again with Peterson, but he said he didn't feel it would be possible to follow a similar procedure. Mr. Stans' outrage continued, and finally he raised it directly with Mr. Ehrlichman. Ehrlichman asked me why I couldn't do anything with Peterson about this, and I told him that Peterson had done the best he could, but there was nothing he could do about it because the grand jury wanted Stans to appear. Ehrlichman could not accept my explanation and called Peterson and was very harsh in telling Peterson that he should honor the White House request that Stans not be forced to appear at the courthouse and go before the grand jury. I was present when Ehrlichman called Peterson and felt he was wrong in doing so. I felt that Peterson had been more than accommodating, and that if he could have done it, he would, but obviously the grand jury wanted to see these people, and Peterson was not happy with the procedures that had been followed with the others. It had been merely an accommodation. Accordingly, I called Mr. Peterson and apologized for the call he had received from Ehrlichman. The only other significant matter that I can recall in connection with the grand jury appearances was in connection with Mr. Colson's grand jury appearance also. After Colson returned from his grand jury interview, he sent me a memorandum, a copy of which I have submitted to the committee, exhibit number 16, which he suggested I might wish to send on to the prosecutors. I had been present during Colson's interview with the prosecutors before his sworn statement was taken. I did not find anything significant in the memorandum that he had failed to cover during his interview. I had also received information from Magruder that he had been pressured by Colson and members of Colson's staff into authorizing the adoption of Liddy's plans on several occasions, and this information was not reflected in the memorandum that Colson had prepared. I felt that the memorandum was rather self-serving to Mr. Colson, and I was not convinced it was totally factual. The memorandum also came to my attention almost a week after Colson had sent it to me, because immediately following his appearance before the grand jury at the end of August, I had gone to San Clemente. I advised Colson that I did not know if everything in his memorandum was consistent with Magruder's testimony and thought we ought to leave well enough alone. He agreed. Accordingly, I filed the document rather than forwarding it to Mr. Silbert. It was while I was in San Clemente at the end of August that the President announced at a press conference the so-called Dean Report, which cleared everybody presently employed at the White House or in the administration from any complicity in the Watergate matter. This statement was made on August 29, 1972. I would like to recall to the committee what the White House had publicly said about this incident prior to the August 29th statement of the President. On June 19th, Ziegler reported that there was no inquiry being made by the White House into the matter. On June 20th, Ziegler stated the case is something that the President will not get into at all, despite the fact that Mr. Hunt had been publicly linked to the White House. On June 21st, Ziegler stated that Colson had assured him that he was not involved, and the White House repeated the statement that the President would not get involved. On June 23rd, the President stated that, as Ziegler had said, the White House has had no involvement whatever in this particular incident. On July 3rd, when the President was in California, he ruled out a special prosecutor and said that the FBI and other authorities will pursue the investigation thoroughly and completely. And Ziegler further reported on that date that the President would not be getting special reports on this politically sensitive case, since that would be inappropriate. Suddenly came the August 29 statement citing the Dean investigation. I had no advance knowledge that the President was going to indicate that I had investigated the matter and found no complicity on the part of anyone at the White House or anyone presently employed in the administration. I first learned of the matter when I heard it on a television news broadcast that evening after I had departed from the compound at San Clemente. I was going to walk up to the residence and listen to the press conference that day because I'd never been to a press conference on the West Coast. But at the last minute, I returned to my room and later turned on the television and heard the statement. Had I have been consulted in advance by the President, I would have strongly opposed the issuing of such a statement for several reasons, which I would have told the President. First, I was aware that Gordon Strawn had close daily liaison with Mr. Magruder and had carried information relating to wiretapped conversations into the White House and later destroyed incriminating documents at Haldeman's direction. Secondly, I had never been able to determine whether Haldeman had advance knowledge or not, and in fact, had never asked him because I didn't feel I could. Thirdly, I'd always suspected, but never been able to completely substantiate my suspicion, that Colson was far more knowledgeable than he protested. I was very aware of Mr. Colson's efforts to disassociate himself with Hunt and of Colson's continual production of documents that would disassociate himself with Hunt. Colson protested too much. Finally, I was aware of the two meetings that I had attended and had reported these to both Haldeman and Ehrlichman. I had reported to Haldeman, as I mentioned earlier, shortly after the meetings had occurred, when I told him I thought the idea was bad and incredible, and told him that I would have no connection or relationship with the matter. I reported this to Ehrlichman in June of 1972, shortly after the incident. I never understood how the Liddy plan had been approved, and Magruder had indicated to me that there had been White House pressure to get the plan moving. Accordingly, I would have been the last to say unequivocally, as the President so stated, that no one presently employed at the White House had any advance knowledge of the matter. I did believe, however, that nobody at the White House knew there was going to be a break-in of the Democratic National Committee on June 17th, because I don't believe that anyone, other than those directly involved, knew that that was going to happen on that day. I don't know if the President's statement was meant to be a very literal play on carefully chosen words, or whether he intended to give it the broad brush interpretation that it later received. However, I would have certainly counseled the President against issuing a statement, and I was very unhappy to have my name associated with the statement without being consulted whatsoever and put out in front on the issue. The issuing of the so-called Dean report was the first time I began to think about the fact that I might be being set up in case this whole thing came tumbling or crumbling down at a later time. I subsequently discussed this with other individuals, Mr. Moore, Mr. Fielding, Mr. Mitchell, and they assured me, but not unanimously, that I need not worry because they did not believe that anyone at the White House would do that to me. In early September, as the FBI and the Department of Justice investigations began winding down, the concern of the White House and the Re-Election Committee shifted to the very active investigation that was being pursued by the Democratic National Committee through its discovery proceedings in its civil lawsuit against the Re-Election Committee. The Democrats were making daily headlines with their lawsuit.
Voice is dropped, and I suggest you talk more directly into the microphone.
I will move closer, thinking I have several hours. I thought I ought to try to ease it back a little bit. On or about September 9th or 10th, I received a presidential request from both Haldeman and Colson. The President felt that the best defense to the actions being pursued by the Democrats and the charges and implications that were stemming from the lawsuits being filed by the Democrats was our own counteroffensive with our own series of lawsuits against the Democrats. I recall that Colson called me repeatedly and finally reported that he had just come from the President's office and that the President wanted action on this as quickly as humanly possible. I informed Mr. Colson that I was working on it, but I wasn't going to suggest filing any lawsuit or taking any action that was not well-founded. I had talked with Mitchell, Ken Parkinson, and Paul O'Brien about the matter, and Mr. Parkinson informed me that he was working on several potential counteractions. I requested he submit a memorandum to me as soon as possible because there was great interest at the White House in the counterattack, including the interest by the President. On September 11th, 1972, Mr. Parkinson submitted his memorandum to me, and after some additional conversations with him about the memorandum, I redrafted his documents for submission to Haldeman. I have submitted to the committee, Exhibit number 17, copies of both Mr. Parkinson's memorandum and the memorandum I submitted to Haldeman. You will note that my memorandum of September 12, 1972 to Mr. Haldeman has an initial P with a check mark in the upper right-hand corner, which indicates that the document was forwarded directly to or reviewed by the President. I later learned that the President was pleased and wanted a full follow-up on the items in the memorandum. The markings on the memorandum are Mr. Haldeman's markings. It was also about this time, late July, early September, that I learned during a meeting in Mitchell's office that Mr. Romer McPhee was having private discussions with Judge Ritchie regarding the civil suit filed by the Democrats. I believe this fact was known to Mr. Mitchell, Mr. LaRue, Paul O'Brien, and Ken Parkinson. I was not aware of the specifics, but I was told by Parkinson, and later again by McPhee, that Judge Ritchie was going to be helpful whenever he could. I subsequently talked to Mr. McPhee about this as late as March 2nd of this year, when he told me he was going to visit the judge in the judge's rose garden over the weekend to discuss an aspect of the case. On September 15th, the Justice Department announced the handing down of 7 indictments by the federal grand jury investigating the Watergate. Late that afternoon, I received a call requesting me to come to the President's Oval Office. When I arrived at the Oval Office, I found Mr. Haldeman, the President, and the President. The President asked me to sit down. Both men appeared to be in very good spirits, and my reception was warm and cordial. The President then told me that Bob, referring to Mr. Haldeman, had kept him posted on my handling of the Watergate case. The President told me I had done a good job, and he appreciated how difficult a task it had been, and the President was pleased that the case had stopped with Liddy. I responded that I could not take credit because others had done much more difficult things than I had done. As the President discussed the present status of the situation, I told him that all I'd been able to do was to contain the case and assist in keeping it out of the White House. I also told him that there was a long way to go before this matter would end, and that I certainly could make no assurances that the day would not come when this matter would not start to unravel. Early in our conversation, the President said to me that former FBI Director Hoover had told him shortly after he had assumed office in 1969 that his campaign had been bugged in 1968. The President said that at some point we should get the facts out on this and use this to counter the problems that we were encountering. The President asked me when the criminal case would come to trial and would it start before the election. I told the President I did not know. I said that the Justice Department had held off as long as possible the return of the indictments, but much would depend on which judge got the case. The President said that he certainly hoped the case would not come to trial before the election. The President then asked me about the civil cases that had been filed by the Democratic National Committee in the Common Cause case and about the countersuits that we had filed. I told him that the lawyers at the Re-Election Committee were handling these cases and they did not see the Common Cause suit as any real problem before the election because they thought that they could keep it tied up in discovery proceedings. I then told the President that the lawyers at the Re-Election Committee were very hopeful of slowing down the civil suit filed by the Democratic National Committee because they'd been making ex parte contacts with the judge handling the case. And the judge was very understanding and trying to accommodate their problems. The President was pleased to hear this and responded to the effect that, well, that's helpful. I also recall explaining to the President about the suits that the Re-Election Committee lawyers had filed against the Democrats as part of their counteroffensive. there was a brief discussion about the potential hearings before the Patman Committee. The President asked me what we were doing to deal with the hearings, and I reported that Dick Cook, who had once worked on the Patman Committee staff, was working on the problem. The President indicated that Bill Timmons should stay on top of the hearings, that we did not need the hearings before the election. The conversation then moved to the press coverage of the Watergate incident and how the press was really trying to make this into a major campaign issue. At one point in the conversation, I recall the President telling me to keep a good list of the press people giving us trouble because we will make life difficult for them after the election. The conversation then turned to the use of the Internal Revenue Service to attack our enemies. I recall telling the President that we had not made much use of this because the White House didn't have the clout to have it done, that the Internal Revenue Service was a rather democratically oriented bureaucracy, and it would be very dangerous to try any such activity. The President seemed somewhat annoyed and said that the Democratic administrations had used this tool well, and after the election we would get people in these agencies who would be responsive to the White House requirements. The conversation then turned to the President's post-election plans to replace people who were not on our team in all the agencies. It was at this point that Mr. Haldeman, I remember, started taking notes, and he also told the President that he had been developing information on which people should stay and which should go after the election. I recall that several days after my meeting with the President, I was talking with Dan Kingsley, who was in charge of developing the list for Haldeman as to the people who should be removed after the election. I told Kingsley that this matter had come up during my conversation with the President, and he said that he had wondered what had put new life into his project, as he had received several calls from Mr. Higbee about the status of his project within the last few days. The meeting ended with the President with a conversation about a book I was reading. I left the meeting with the impression that the President was well aware of what had been going on regarding the success of keeping the White House out of the Watergate scandal, and I had also expressed to him my concern that I was not confident that the cover-up could be maintained indefinitely. I would next like to turn to the White House efforts to block the Patman Committee hearings. As early as mid-August 1972, the White House learned through the Congressional Relations staff that an investigation was being conducted by the staff of the House Banking and Currency Committee under the direction of Chairman Patman into many aspects of the Watergate incident. The focus of the investigation at the outset was the funding of the Watergate incident and other possible illegal funding that may have involved banking violations. The White House concern was twofold. First, the hearings would have resulted in more adverse pre-election publicity regarding the Watergate, and secondly, they just might stumble into something that would start unraveling the cover-up. The initial dealings with the Patman Committee and the Re-Election Committee were handled by Mr. Stans and Mr. Parkinson. However, as the Patman Committee proceeded, Stans called for assistance from the White House. I was aware of the fact that the Patman investigators had had numerous conversations with Parkinson, and the investigators themselves came to the Republican National Convention to interview Mr. Stans on August 25, 1972. Upon Mr. Stans' return from the Republican Convention, he met with the investigative staff of the Patman Committee, which I believe occurred on August 30th. He was accompanied at both these interviews by Mr. Parkinson. At some point in time during these investigations, Mr. Parkinson was put in touch with Congressman Gary Brown, who was a member of the Banking and Currency Committee. To the best of my recollections, this may have resulted from discussions between members of the White House Congressional Relations staff with the Republican members of the Banking and Currency Committee to determine who would be most helpful on the committee, and Brown indicated his willingness to assist. On September 8th, Congressman Brown sent a letter to the Attorney General regarding the forthcoming appearance of Secretary Stans and others before the Patman Committee. I have submitted to the committee a copy of this letter, Exhibit Number 18, which was, in fact, drafted by Mr. Parkinson for Congressman Brown. It was my recollection that Secretary Stans was scheduled to appear before the Patman Committee for a formal testimony on September 14th. Prior to Parkinson's drafting the letter for Congressman Brown, I had been asked to discuss the matter with Henry Peterson, which I did. I told Peterson of the problem and asked him for his feelings about Stans and others appearing before the Patman Committee and what effect that might have on either the grand jury or the indicted individuals once the indictments were handed down. I recall that Peterson had very strong feelings that it could be very detrimental to the government's ability to prosecute successfully the Watergate case, but he said he would have to give some thought to responding to Congressman Brown's letter. I had several additional discussions with Peterson and later with the Attorney General when Peterson indicated he did not think he could respond before the scheduled appearance of Stans on September 14th. The Justice Department did not feel that it could write such a letter for one individual regarding the Patman hearings and was very reluctant to do so. I also had conversations with Mitchell about this and reported the matter to Haldeman and Ehrlichman. The Justice Department felt that for them to write such a letter would look like a direct effort to block the hearings, and I happened to frankly agree. Therefore, no response was sent prior to the scheduled September 14th appearance of Mr. Stans, and Mr. Parkinson himself informed the committee that Stans would not appear because he felt it would be detrimental to the pending civil and criminal investigations. It was after my September 15th meeting with the President, where this matter had been briefly and generally discussed, and as the subsequent activities of the Patman Committee became more intense, that the White House became more involved in dealing with the Patman Committee. On September 25th, Chairman Patman announced that he would hold a vote on October 3rd regarding the issuing of subpoenas to witnesses. With this announcement, the White House Congressional Relations staff began talking with members of the committee as well as the Republican leadership of the House. I recall several conversations with Mr. Timmons and Dick Cook regarding this matter, as well as conversations with Haldeman. Timmons and Cook informed me that there was a daily change in the list of potential witnesses, and the list was ever growing and beginning to reach into the White House itself. In discussing it with Haldeman, I asked him how he thought the Patman hearings might be turned off. He suggested that I might talk with Secretary Conley about the matter because Conley would know Patman as well as anybody. I called Secretary Conley and told him the reason I was calling. He said that the only thing he could think of, the only soft spot that Patman might have, was that he had received a large contribution from a Washington lobbyist, and he had heard rumors that some of these contributions may not have been reported. I discussed this matter with Bill Timmons, and we concluded that several Republicans would probably have a similar problem, so the matter was dropped. At this time, I cannot recall the name of the lobbyist whom Secretary Conley said had made the contributions to Mr. Patman. Timmons and I had also discussed that probably some of the members of the Banking and Currency Committee would have themselves potential Campaign Act violations, and that it probably would be worthwhile to check out their reporting to the Clerk of the House. I told Timmons I would look into it. On September 26th, I received a report I had requested from Mr. Parkinson after he'd had one of his associates check the reports of the members of the committee with the Clerk of the House. After I received the document from Parkinson, a copy which I have submitted to the committee, Exhibit 19, I decided it would be a cheap shot to get into anything of this nature. Accordingly, I never reviewed the document that Parkinson submitted, and I have not reviewed it to this day. While the White House had received, through its Congressional Relations staff, informal reports as to who was likely to be subpoenaed, Chairman Patman made public his list on October 2nd, 1972. The individuals for whom subpoenas were to be requested was extensive and included several people who had varying degrees of knowledge regarding the Watergate and related matters. This list, for example, included Alfred Baldwin, Jack Caulfield, persons from the Finance Committee, Sally Harmony, Fred LaRue, Clark McGregor, Mr. Magruder, Mr. Mardian, Mr. Mitchell, Robert Odle, Bart Porter, Hugh Sloan, Stans, Timmons, and myself. I have submitted to the committee a copy of the entire list, Exhibit 20. As the names on the list had continued to evolve, it became increasingly apparent that the White House did not want the hearings to be held. For example, Bill Timmons took a much greater interest in the project when he realized early on that his name was among those who would be called. I say this not because Timmons had any reason not to appear, because I know of no illegal or improper activities on Timmons' part. Rather, he had been working to prevent the hearings from occurring in the first instance through his conversations with Republican leaders and members of the committee. This indeed would have put him in an awkward position. I began receiving increasing pressure from Mitchell, Stans, and Parkinson and others to get the Justice Department to respond to the September 8th letter of Congressman Brown as a vehicle that Congressman Brown could use in persuading other Republicans not to vote in favor of the subpoenas. Congressman Brown felt, with this document in hand, he could give the Republicans and others something to hang their vote on. I had continued my conversations with Henry Peterson, and after the indictments had been returned, he said that indeed he did feel that the Justice Department should issue such a letter because of the potential implications on the breadth of the Patman hearings. The letter was sent on October 2nd, 1972. I have submitted to the committee a copy of Congressman Brown's letter and Assistant Attorney General Peterson's response, Exhibits 18 and 21. A number of people worked on getting the votes necessary to block the Patman Committee hearings. Mr. Timmons discussed the matter with the House Republican leaders, who agreed to be of assistance by making it a matter for the leadership consideration, which resulted in a direction from the leadership to members of the committee to vote against the hearings. I was informed that Congressman Brown had been working with several members of the Democratic side of the Patman Committee to assist in voting against the hearings, or as an alternative not to appear for the hearings. Timmons informed me that he also was in direct contact with one of the leaders of the Southern delegation, who was being quite helpful in persuading the Southerners on the committee not to vote for the subpoenas, or in the alternative not to appear at the meeting on October 3rd. Also, Mitchell reported to me that he had been working with some people in New York to get the New Yorkers on the committee to vote against the hearings. He told me, and I cannot recall now which members of the New York delegation he referred to, that he had assurances that they would either not show up or would vote against the hearings. I, in turn, passed this information on to Timmons, but I did not tell him the source of the information. On October 3rd, the vote was held, and the subpoenas were defeated by a vote of 20 to 15, and another sigh of relief was made at the White House that we had leaped one more hurdle in the continuing cover-up. On October 4th, however, Chairman Patman requested a GAO investigation, and I was asked by Stans what this would mean. I told him that this would be primarily between himself and GAO, but that since the GAO had no subpoena power to compel testimony, the scope of their investigation would have to have limits. He said that he felt that he could work with Elmer Statz, who was an old and good friend, and not let this matter get out of hand with GAO. On October 10th, Chairman Patman decided to proceed without subpoena power and sent letters to McGregor, Stans, Mitchell, and myself. Everybody who received such a letter declined to appear, and Patman held his hearings with empty witness chairs, and as I recall the press accounts, lectured the missing witnesses. I would now like to turn to the so-called Segretti matter. I've been informed by the committee counsel that the subject of alleged political sabotage will be taken up in subsequent hearings. However, I've been asked to explain in full the pattern of cover-up which evolved in connection with the Watergate and related matters. My explanations would be less than complete in presenting my knowledge of the subject if I were to omit the so-called Segretti matter. While the Segretti matter was not directly related to the Watergate, the cover-up of the facts surrounding Mr. Segretti's activities was consistent with other parts of the general White House cover-up which followed the Watergate incident. I will not go into extensive details at this time, but I will give the highlights of the pattern that was followed regarding the dealings of the White House with Mr. Segretti. I first heard of Mr. Segretti when Gordon Strachan called me in late June and told me that the FBI had called a friend of his by the name of Donald Segretti and requested to interview him in connection with the break-in. He had been working to prevent the hearings from occurring in the first instance through his conversations with the Republican leaders and members of the committee. This indeed would have put him in an awkward position. I began receiving increasing pressure from Mitchell, Stans, and Parkinson and others to get the Justice Department to respond to the September 8th letter of Congressman Brown as a vehicle that Congressman Brown could use in persuading other Republicans not to vote in favor of the subpoenas. Congressman Brown felt, with this document in hand, he could give the Republicans and others something to hang their vote on. I had continued my conversations with Henry Peterson, and after the indictments had been returned, he said that indeed he did feel that the Justice Department should issue such a letter because of the potential implications on the breadth of the Patman hearings. The letter was sent on October 2nd, 1972. I have submitted to the committee a copy of Congressman Brown's letter and Assistant Attorney General Peterson's response, Exhibits 18 and 21. A number of people worked on getting the votes necessary to block the Patman Committee hearings. Mr. Timmons discussed the matter with the House Republican leaders, who agreed to be of assistance by making it a matter for the leadership consideration, which resulted in a direction from the leadership to members of the committee to vote against the hearings. I was informed that Congressman Brown had been working with several members of the Democratic side of the Patman Committee to assist in voting against the hearings, or as an alternative not to appear for the hearings. Timmons informed me that he also was in direct contact with one of the leaders of the Southern delegation, who was being quite helpful in persuading the Southerners on the committee not to vote for the subpoenas, or in the alternative not to appear at the meeting on October 3rd. Also, Mitchell reported to me that he had been working with some people in New York to get the New Yorkers on the committee to vote against the hearings. He told me, and I cannot recall now which members of the New York delegation he referred to, that he had assurances that they would either not show up or would vote against the hearings. I, in turn, passed this information on to Timmons, but I did not tell him the source of the information. On October 3rd, the vote was held, and the subpoenas were defeated by a vote of 20 to 15, and another sigh of relief was made at the White House that we had leaped one more hurdle in the continuing cover-up. On October 4th, however, Chairman Patman requested a GAO investigation, and I was asked by Stans what this would mean. I told him that this would be primarily between himself and GAO, but that since the GAO had no subpoena power to compel testimony, the scope of their investigation would have to have limits. He said that he felt that he could work with Elmer Statz, who was an old and good friend, and not let this matter get out of hand with GAO. On October 10th, Chairman Patman decided to proceed without subpoena power and sent letters to McGregor, Stans, Mitchell, and myself. Everybody who received such a letter declined to appear, and Patman held his hearings with empty witness chairs, and as I recall the press accounts, lectured the missing witnesses. I would now like to turn to the so-called Segretti matter. I've been informed by the committee counsel that the subject of alleged political sabotage will be taken up in subsequent hearings. However, I've been asked to explain in full the pattern of cover-up which evolved in connection with the Watergate and related matters. My explanations would be less than complete in presenting my knowledge of the subject if I were to omit the so-called Segretti matter. While the Segretti matter was not directly related to the Watergate, the cover-up of the facts surrounding Mr. Segretti's activities was consistent with other parts of the general White House cover-up which followed the Watergate incident. I will not go into extensive details at this time, but I will give the highlights of the pattern that was followed regarding the dealings of the White House with Mr. Segretti. I first heard of Mr. Segretti when Gordon Strachan called me in late June and told me that the FBI had called a friend of his by the name of Donald Segretti and requested to interview him in connection with the break-in at the Democratic National Committee. Strachan asked me if I would meet with Segretti. I told him I would, and Strachan arranged a meeting at the Mayflower Hotel where Segretti was staying. Strachan gave me a very general description of Mr. Segretti's activities and said that he was a dirty tricks type operator who had been paid by Mr. Kalmbach. He told me that he would rather have Segretti himself tell me what he'd been doing because he, in fact, was not aware of all of Segretti's activities.
He also informed me that Mr. Chapin had been involved in hiring Segretti. I met with Segretti in the lobby of the Mayflower Hotel, at which time he gave me a very broad description of his activities and said that he had contact with a man by the name of Ed Warren, who, by having seen subsequent pictures in the paper, he assumed was Howard Hunt. I told Segretti to come to my office the next day and we would discuss the matter further. When Segretti came to my office the next morning, he told me of his relationship with Mr. Hunt and that he had only had incidental dealings with him and recalled meeting with him twice in Florida and several subsequent telephone calls. Segretti told me that Hunt had scared him and that he had really decided early on to deal with him as little as possible. Segretti then described how he had been hired and the fact that he had met with Kalmbach to arrange his compensation. He said he wanted to know whether he should mention the fact that Strawn Chapin had recruited him, and Kalmbach was paying him when he was interviewed by the FBI. I told Segretti that he should answer any and all questions asked about Hunt and his relationship with Hunt, but that he should withhold the names of Strawn, Chapin, and Kalmbach unless the FBI felt it was absolutely necessary to have the names. Segretti departed and returned to California. Several days after Segretti's FBI interview, he called me, and he told me that he thought his interview had gone very well. He said that he told the FBI everything he knew about Mr. Hunt and the fact that he had no knowledge of the Watergate incident and that the agents had not pressed him in a manner that required him to reveal the names of Strawn, Chapin, and Kalmbach. I thanked him for informing me of the results of his interview and did not hear again from him till much later. The next time I heard from Segretti was in August, during the Republican National Convention in Miami. I received a call from Mr. Chapin, who indicated that Segretti was very concerned about the fact that he was being called before a federal grand jury in Washington to investigate the Watergate. Chapin told me that Segretti was looking for guidance as to his appearance before the grand jury, and he was concerned again that he might have to reveal the names of Strawn, Chapin, and Kalmbach. I informed Chapin that it would be impossible for me to go to Washington to see Segretti, but if he wished to come to Florida en route to his scheduled grand jury appearance, I'd be happy to meet with him. After my conversation with Chapin, I called Mr. Peterson at the Department of Justice and explained the problem that was confronting Segretti. I told Peterson that to the best of my knowledge, Segretti had no involvement in the Watergate incident, but he had had dealings with Hunt in connection with some campaign activities he had been performing for the White House. I also informed Peterson that he was being paid by the President's personal attorney, Mr. Kalmbach, and that he had been recruited by Chapin and Strawn. I said that these facts, if revealed, would obviously be quite embarrassing and could cause political problems during the waning weeks of the election. Mr. Peterson said that he understood the problem and would determine what he could do. I subsequently talked to Mr. Peterson again, and he told me that he did not believe it would be necessary for the prosecutors to get into these areas when Mr. Segretti appeared before the grand jury. Segretti came to Florida a day or so before his appearance before the grand jury. To the best of my recollection, it was on a Saturday during the week I was in Miami preparing for the convention. I had a very brief meeting with Segretti, not longer than 30 minutes as I recall, in which we reviewed his potential problem. I told him I did not believe that the government was particularly interested in pursuing the names of Strawn, Chapin, and Kalmbach in connection with his activities, and I doubted if he would be asked any questions about these areas. I told him, however, that if he were asked the questions, he should answer any question and every question truthfully. And if he were asked the names who had hired him and who had paid him, that he should give the names. I told him, if pressed, he should lay out the whole ball of wax. I later learned from Segretti that the names had come out during the grand jury appearance, and I had a discussion later with Peterson also on the subject, in which he told me that Mr. Silbert had tried to avoid getting into the area, and in fact did not ask him the question which resulted in his giving the names, rather that a grand juror had asked the question, despite the fact that the prosecutors had tried to gloss over it. As a result of Segretti's appearance before the grand jury, FBI interviews were scheduled for Chapin, Strawn, and Kalmbach. I had by this time learned the full story, that in fact Haldeman, in a meeting with Kalmbach, had approved Segretti's activities and authorized Kalmbach to make payments to Segretti. In discussing this with Chapin and Strawn before their appearances or their FBI interviews, I should say, they both had great concern about revealing Mr. Haldeman's involvement. In fact, I recall that Strawn came into my office when Dick Moore was present and said that he would, if necessary, perjure himself to prevent involving Haldeman in this matter. I told Strawn that was certainly not necessary in my estimation, but he was indeed most loyal to Haldeman for taking that position. Dick Moore made a similar comment. When the agents came to interview Chapin and Strawn, they contained themselves in their questioning, and to the best of my knowledge, all the answers that Chapin and Strawn provided were truthful, although I must say, pursuant to the discussions I'd had with them prior to their interview, they did not volunteer any information that was not asked for. When I was in California in late August, I was asked by Mr. Ehrlichman to meet with Kalmbach and prepare him for his FBI interview regarding the Segretti matter. Kalmbach was very concerned that the interview could lead into other areas and had discussed this problem with Ehrlichman. Accordingly, I helped Kalmbach prepare for his FBI interview, and he later informed me that it had gone well and that they had not asked questions unrelated to the Segretti matter, and he had volunteered nothing. On October 10th, 1972, an article based on leaked FBI information reported the Segretti story for the first time publicly. Following the October 10 story, there commenced a series of stories involving Chapin, Strawn, Kalmbach, and later Haldeman. These stories created a new frenzy in the White House press office as to how to deal with the stories. On Friday the 13th, I had left Washington to go to Florida to spend several weeks on a honeymoon, but was abruptly called back to Washington on Sunday the 15th because of the cascading leaked stories regarding Segretti. When I returned, I went to the White House where a meeting was in session in the Roosevelt Room. In attendance at the meeting were Ehrlichman, Ziegler, Buchanan, Moore, and Chapin. The purpose of the meeting was to prepare Ziegler for his press briefings on the Segretti-related stories. For a reason that I cannot explain, a secretary to Mr. Chapin was present, taking notes during parts of the discussions and the hypothetical questioning and answering of Mr. Ziegler. I believe this is probably one of the rare occasions when the preparation of a Ziegler briefing was actually recorded, and I have submitted to the committee a copy of the notes recording parts of that session, which is exhibit number 22. I might also add that this session was not unlike many other sessions that had preceded it and that were to follow it in preparing Ziegler to meet with the White House press corps. It would, however, take another 200 pages to give that story. After Segretti became the subject of intense inquiry by the press, Ehrlichman suggested that I advise Segretti to go incognito, to hide from the press and avoid further stories that might result from the press interviews of him. I so advised Segretti, and he came to Washington in late October because he was very distressed about the fact that a number of the people who were issuing what he considered to be inaccurate and false stories regarding his activities. When Segretti arrived in Washington, he was met by Mr. Fielding and myself to discuss whether he should issue a press statement himself at that time. The subject was also discussed in a meeting at Mr. Chapin's office, attended by Ziegler, Ehrlichman, Chapin, and myself, and later by Fielding after he had received a draft copy of Segretti's proposed press statement. It was decided that it would be unwise for Segretti to issue the statement, so he commenced his travels around the United States once again to avoid the press. Mr. Segretti would periodically call me to tell me he was in some small town and had not seen a newspaper or television for several days and was curious to know what they were saying about him. I would give him a summary report as to the press coverage. Following the election, I was asked by Haldeman and Ehrlichman to meet with Segretti to determine the extent of the involvement that Chapin and Strawn had with him. Segretti at this time was in Palm Springs, California, where he had been spending the last weeks before the election in the desert. I arranged to meet with him on November 10th in Palm Springs and had planned to spend a week myself relaxing after the election in Palm Springs. On November 10th, I met with Segretti, and pursuant to an arrangement between Segretti and myself, I agreed to tape the interview with him, with the understanding that I felt it was privileged under the doctrine of executive privilege, and it would never be released. I have submitted the tape of that conversation between Segretti and myself to the committee pursuant to the subpoena issued for the material. My visit to Palm Springs was abruptly interrupted when I received a call on November 11th from Mr. Todd Hullen, Ehrlichman's assistant, requesting I come to Florida where Ehrlichman and Haldeman were accompanying the president to report on my interview with Mr. Segretti. Accordingly, I flew to Florida immediately and met with Haldeman and Ehrlichman on November 12th and played the taped interview I had had with Segretti for them. I recall that while I was discussing this matter with Ehrlichman and Haldeman, the president requested that Haldeman come over to see him. I was surprised on this occasion, as I had been on other occasions when a similar situation had occurred, that Haldeman sent a message back to the president that he was meeting with me and would be over shortly to report. I was surprised that my reporting on Segretti would take precedent over Haldeman's responding to an immediate request of the president. On November 15th, I arranged to meet with Mr. Haldeman and Mr. Ehrlichman at Camp David on another subject, which I'll discuss later. During the first part of the meeting, however, the subject of Chapin's remaining at the White House came up, and I learned that the president had made a decision based on the information that had been imparted to Haldeman and Ehrlichman in Florida that Mr. Chapin would have to leave the White House staff. Before going to Camp David, I was aware of the subject being under discussion, and Mr. Moore and I had talked about it. Moore felt that the president should merely issue a letter of censure to Chapin and let it go at that, but Moore was unaware of the contents of the tape and had never heard it. Pursuant to the request of Moore, however, I did raise his suggestion with Ehrlichman and Haldeman. Haldeman said that he was personally too close to Chapin to make a judgment on such a thing, and that if it was to be done, if it was going to be re-raised with the president, it would have to be done by Ehrlichman. Ehrlichman said that he did not think that it was possible to re-raise the matter, and subsequently Chapin resigned from the White House staff. As the press accounts of Segretti's activities lingered on after the election, as well as the continuing Watergate stories, there was serious discussion about putting out the facts. In late November, I recall a conversation with Haldeman in his office. We talked about the facts, and he asked my opinion about what would happen if we put them out. I told him I thought that the then pending trial would be put back in the grand jury, and it was very likely that Mitchell, Magruder, Strawn, Ehrlichman, Haldeman, and Dean could be indicted. He asked me to elaborate. I said I had no idea, nor did I have full knowledge of what had happened before June 17th, but I did know that there was a good possibility that any reconvened grand jury could get into questions of obstruction of justice, which would lead right to us. Haldeman said the president wished that now that the election was over to get rid of the Watergate and related matters by laying them open, but based on what I had just told him, he said, it doesn't seem to be a very viable option. I told him that I was ready at any time to account for myself, and I thought we should continue to examine that option so that the president is not damaged. He then asked me to attempt to write a report that could be made public, a report that would be a written version of the so-called Dean investigation that the president had announced on August 29th, and include a new report on the Segretti matter. I told Haldeman that I thought this could only create additional new problems because it would be just like a peek into the tent without letting anyone in, and it would be very difficult to write, but I would do my best. I did not tell Haldeman that I was also opposed to writing a report under my name, which I felt would come back to haunt me someday. Accordingly, to follow his instructions, I decided that I would draft a series of carefully worded interrogatories or affidavits for each individual whose name had come up in the press regarding political sabotage and espionage. Then, based on the affidavits, I would write a summary report and attach the affidavits. I thought that I would merely waltz over the Watergate matter by referring to the fact that other governmental investigations, the FBI, the grand jury, had cleared anyone in the Watergate from involvement. After drafting the document, I reluctantly submitted it to Haldeman on December 5th. I have submitted a copy of this document to the committee, exhibit number 23. Haldeman, in turn, gave it to Ehrlichman, who made the editorial changes that appear on the draft. Ehrlichman then gave it to Ziegler. On December 13th, a meeting was scheduled in Haldeman's office to discuss the matter, but was subsequently moved to Ziegler's office. Present at the meeting were Haldeman, Moore, Ziegler, and myself. Ehrlichman had showed up for the earlier meeting in Haldeman's office, but when it had been moved to Ziegler's office, he had never returned to the meeting to the best of my recollection. Nothing was resolved at the meeting, and it was a consensus of the group that the White House should continue, in Dick Moore's word, to hunker down, do nothing, on the general theory that no one would be arrested for what they didn't say. Turning now to the handling of demands for White House money. I have previously discussed Mr. Kalmbach's raising money for the first pressures for support money for silence. These pressures were continuous, and following the election, there were increasing pressures from Hunt for money for himself and the other indicted defendants as a means of assuring their silence. While this pressure had begun well before the election, it steadily grew after the election until the demands were being made directly to the White House for financial assistance. Before getting into the details of these pressures and how they were handled, I believe it might be helpful to explain the situation at the White House regarding the handling of and availability of cash. In early 1971, I was asked by Haldeman to assist in establishing the re-election committee, and that they had no lawyer of their own. My activities resulted in my learning that there were large sums of cash that had been left over from the 1968 Nixon primaries, and some funds had been left from the 1970 congressional fundraising efforts. These monies, which were referred to as surplus monies, were held by Kalmbach and controlled by Haldeman Ehrlichman. I have submitted to the committee, exhibit number 24, a memorandum prepared by Strawn of a meeting that was attended by Haldeman, Strawn, and myself on the 18th of May, 1971, which reflects the tight controls Haldeman exercised over the surplus monies held by Kalmbach. I've also submitted documents, exhibit 25, evidencing that it was necessary to have Haldeman's approval based on a full explanation of the reasons for even the smallest disbursement by Kalmbach of surplus money. In this instance, I'm referring to an expenditure of $813. It was sometime prior to April 7th, 1972, that I learned that cash was being sent to the White House. I was not told the amount, but I was asked by Strawn if I could suggest someone outside the government who might be willing to hold a large amount of cash in a safety deposit box. I told him I'd have to think about it, but later told him I couldn't think of anyone. It was in late June or early July that I learned that $350,000 of the surplus money had been delivered to the White House prior to April 7th, 1972. I was informed that the money came from the 1968 primaries, and that the delivery was made before April 7th to ensure that it did not become part of the 1972 campaign funds. The $350,000 fund, as I have indicated, was held by Strawn, but I do not know where he held it. It was shortly before Mr. Sloan was being called to testify in July that discussions commenced on how to make the $350,000 fund whole and get it out of the White House. There was no easy answer because there was no place to send it out without reporting requirements. The concern was that Mr. Sloan would testify that he was aware of the dispersal of the $350,000 to the White House. This, in turn, would have created two problems. The White House would have been accused of having a secret slush fund if this became public, and secondly, a $6,800 expenditure out of a $22,000 authorization which had been made presented a potential Campaign Act violation for Haldeman, Colson, and Richard Howard. I had numerous discussions about how to handle this problem with Mr. Stans and Mr. Parkinson, but there was no easy answer. I also discussed this matter with Mr. Haldeman, telling him that there was no easy answer. Finally, after the elections, Stans indicated that he had cash available, and it was decided that Stans should provide $22,000 to Strawn to make the funds whole, and then they could be removed from the White House and, if necessary, reported. This plan was approved by Haldeman, and Stans was so informed. On the morning of November 28th, Stans called to request that Strawn come to his office to receive the money that he had available. I do not know the source of the money, or whether it was campaign money, or any of the details about the $22,000 that Stans had made available. I could not locate Strawn, and Stans indicated that it should be picked up immediately, but I cannot recall at this time the reason he called for the immediacy. Accordingly, I asked Mr. Fielding to pick up a package from Stans and give it to Strawn as soon as he could. I informed Stans that Fielding would be over to pick up the package, but he would not know what he was picking up, and when I later learned that Stans had informed Fielding, I was somewhat annoyed because I felt that was unfair to Fielding. The money was then given by Fielding to Strawn, but no final decision had been made regarding how to dispose of the $350,000. Having explained the status of the cash at the White House, I must now return to the pressures that were being placed on the White House for the use of these funds, which I have just described, for payments to the 7 indicted individuals. The pressure began long before Election Day, and that Paul O'Brien was receiving messages from William Bittman, Hunt's lawyer, that Hunt and others expected to have more support money and attorney's fees in exchange for their continued silence. The initial payments by Kalmbach had not been sufficient. O'Brien reported this frequently to Mitchell, Mardian, LaRue, and myself. I, in turn, was reporting to Haldeman and Ehrlichman. There were discussions in late July, August, and September of using the funds at the White House for these payments. I informed Haldeman of these discussions, but they were still in the discussion stage and no action was taken. After the election, the pressure was greatly increased when Colson received a call from Mr. Hunt, which Colson recorded. Colson brought the recorded call to me, and I in turn transcribed it onto a cassette tape. I have been informed by committee counsel that the committee has in its possession a transcript of the conversation between Colson and Hunt, in which Hunt makes demands for money. On November 15th, I arranged a meeting with Haldeman and Ehrlichman so that they could hear the tape of the conversation Colson had had with Hunt, and also to inform them of the increasing and now threatening demands that were being transmitted through Hunt's lawyer to Mr. O'Brien, and in turn on to the White House. Haldeman and Ehrlichman were at Camp David at that time, developing plans for the reorganization of the executive branch for the second term of the Nixon administration. I departed on the morning of November 15th for Camp David with Mr. Walter Minnick, who was going to Camp David to discuss the reorganization plans with Ehrlichman. Minnick had been doing virtually all of the legal work at that time for Ehrlichman on the reorganization plan, and was a member of Ehrlichman's staff. In fact, I was somewhat surprised that the counsel's office had not been more involved or involved at all prior to that time in the reorganization plans. After arriving at Camp David, Ehrlichman, Haldeman, and I went into the President's office in Laurel Lodge, which was empty. I have referred earlier to the fact that in this meeting the matter of Dwight Chapin's remaining at the White House was discussed. It was after that discussion that I told them of the telephone conversation between Hunt and Colson and played the tape for them, and also told them of the increasing demands being made for money. I told them I was going to New York that afternoon because Mitchell had requested that I come to visit him regarding the demands being made, and told them I also would play the tape for him. My instructions from this meeting were to tell Mitchell to take care of all these problems. When we came out of the private meeting, Ehrlichman told Mr. Minnick, who had been waiting to meet with him, that we had been talking about reorganization matters. This position was taken because Minnick was at Camp David for that purpose, and it would seem a very logical thing that I might be discussing with Haldeman and Ehrlichman. In fact, in our private meeting, there was no discussion of the reorganization at all. After a brief discussion about the reorganization matters, I departed Camp David and returned to Washington, and then flew to New York with Mr. Stans. Stans had told me some days earlier that he was going to meet with Mr. Mitchell to discuss a number of matters about winding down the re-election committee, and asked me to join him.
I'll stay here and proceed with the committee and ask them to hold a vote till I get over and somebody's hurry back so they can take charge so I can go and vote. Go ahead.
Thank you. Stans had arranged the meeting with Mitchell to take place at the Metropolitan Club in New York City, because Stans was anxious to return to Washington as soon as the meeting was over, did not want to go down to Wall Street and get tied up in traffic. After the first part of the meeting, where Stans and Mitchell discussed their problems, Stans departed, and I played the tape for Mitchell. I recall that he had only one reaction to the tape, and it was to the effect that it was certainly a self-serving tape for Colson, and he wondered what in the hell Hunt was talking about with regard to Mitchell's having perjured himself. I informed Mitchell that Ehrlichman and Haldeman had heard the tape and requested that he do what he could to solve the problem. I received no instructions or really any indication at all at that time from Mitchell regarding the matter that Hunt had raised in the conversation with Colson. To the best of my recollection, it was the first week of December that Mitchell called me and said that we would have to use some of the $350,000 fund to take care of the demands that were being made by Hunt and others for money. He indicated that the money that was taken out would be returned in order that the fund could be made whole again. He asked me to get Haldeman's approval. Prior to Mitchell's call, I had been informed by Colson's secretary that Mrs. Hunt had called her at home on a number of occasions to discuss this problem with her in order that she might pass it on to Colson and get something done about the problem. Colson had sent his secretary, Miss Joan Hall, to me with these messages indicating that he did not want to talk to her about it, but that she should pass the message on to me. I told Miss Hall not to talk to Mrs. Hunt, and if necessary, get an unlisted telephone. After the phone call from Mitchell, I called Haldeman, and I described the situation in full to him, and that I had told Mitchell that I was very reluctant to see the White House money used, but he indicated that it would be returned as soon as they could raise some additional money. I told Haldeman I didn't think it was a good idea to further involve the White House in raising money for these men, but frankly I had no answer. Haldeman said he did not like it either, but since we had the assurance that the money would be returned, I should inform Strawn that he could make the delivery of the money to the committee. Following my conversation with Haldeman, I called Strawn. I told him he should speak with Fred LaRue and make a delivery to LaRue pursuant to LaRue's instructions. I also informed Strawn that he should anticipate the fact that we would get this money back in the near future. I do not recall how much money was delivered by Strawn, but I believe it was either $40,000 or $70,000. This delivery did not satisfy the demands, and they continued to be relayed by Mr. Bittman to Mr. O'Brien, and in turn would relay them to Mitchell, LaRue, and myself. I, in turn, would tell Haldeman and Ehrlichman of the demands. I can recall that LaRue and O'Brien coming to my office to discuss these demands, and I told them that there could be no further use of the White House money, and in fact, to the contrary, Haldeman was expecting that the money which had been provided earlier was to be returned in full. To the best of my recollection, it was sometime shortly before the trial when the demands reached the crescendo point once again. O'Brien and LaRue came to my office and told me of the seriousness of the problem. Subsequently, Mitchell called me and told me that once again I should ask Haldeman to make available the necessary funds. I called Haldeman and told him of Mitchell's request and the situation, and told him that I thought it was time to get the entire money out of the White House rather than continue, as it were, every few weeks, further bites being taken out of the apple. After we discussed the matter, Haldeman said, "Send the entire damn bundle to them, but make sure we get a receipt for the $350,000. After receiving my instructions from Haldeman, I called Strawn and told him that he was to deliver the remainder of the money to LaRue, but he was to make certain that he got a receipt for $350,000. Strawn later told me that LaRue had refused to give him a receipt. With each of these deliveries, I am only aware of the fact that the money was delivered to LaRue by Strawn. I have no knowledge of how LaRue in turn delivered it to those who were making demands upon the committee, nor do I know how much, in fact, was paid. After Mrs. Hunt was tragically killed on December 8, 1972, Paul O'Brien informed me that he had learned from William Bittman that Hunt was in very bad shape. He had become extremely depressed and grieved over the death of his wife. I also recall that the funeral of Mrs. Hunt created a serious dilemma for Mr. Colson, who had known the Hunts personally, was very fond of them both, but was concerned about in any way publicly identifying himself with Mr. Hunt. Accordingly, he came to ask me if he should attend Mrs. Hunt's funeral, and I told him that I thought he ought to do whatever he felt in his heart that certainly attending her funeral could not in any way be deemed to show that he was in any way involved with Hunt in the Watergate. Colson initially told me he was going to attend the funeral, but subsequently decided to send his secretary with a letter to Hunt expressing deep sympathy over the situation. It was also after the death of Mrs. Hunt that I learned from O'Brien that Hunt's lawyer did not think that Mr. Hunt was capable of standing trial in his then psychological situation, and that he had been examined by a psychiatrist who had reached that conclusion. O'Brien had discussed this matter with Mitchell because Mitchell and I had a conversation in which he told me that Bittman thought that the government might be of some assistance in resolving Hunt's problems temporarily by finding a sympathetic psychiatrist to examine Hunt who would concur in the findings of the psychiatrist who had already examined him and found him not fit to stand trial. Mitchell asked me to discuss this with Peterson, and I said I would. I had a brief conversation with Peterson about this, and he said that if there was anything that could be done, it would, but he did not think anything could be done regarding this matter. After the government psychiatrist determined that Mr. Hunt was capable of standing trial, I had a report back from O'Brien that Hunt was outraged that no one at the White House was doing anything to take care of him, and in fact he thought the White House and his friends had turned against him. He was not asking anyone to fix his case, but merely asking for someone to give him time to recover from the tragedy of his wife's death. I can recall telling Colson about this when I reported to him generally that Hunt was in rather bad shape and was thinking about pleading guilty rather than going through the rigors of a trial in his present situation. I also told Colson that I had been informed that Hunt wanted to talk with him, but since Hunt knew that would put Colson in an awkward position, that he wanted Colson to talk to his lawyers. I shall now turn to the matter of executive clemency for Hunt and the others. I was out of my office from roughly December 22nd until the morning of January 3rd.
Would you like to take a little recess right now?
I think my throat would enjoy that very much, Mr. Chairman.
Let's suppose we'll give the witness a recess and go and vote.
John Dean has been interrupted just as he was about to explain how executive powers would be used to promote the Watergate cover-up. The committee paused at this time for a floor vote. Dean's story and public television's complete coverage of the hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As the hearing resumes, John Dean is explaining further how the White House was involved in the Watergate cover-up.
As I was commencing before the break on page 135 in dealing with the subject of executive clemency for Mr. Hunt and others, I was out of my office from roughly December 22nd until the morning of January 3rd. The latter part of this time, I was in California with other members of the White House staff and their families on a short vacation. I received a call on the morning of January 2nd while awaiting takeoff from California in the President's new Air Force One. The call was from Paul O'Brien, who told me that there were some serious problems and I should speak with him as soon as I returned to Washington. He told me that Mr. Hunt was off the reservation. I was traveling with Haldeman and told him about the call. When I arrived in Washington that evening, I called O'Brien, and he told me that Hunt was quite upset and wished to plead guilty, but before he did so, he wanted some assurances from the White House that he would receive executive clemency. O'Brien told me that Hunt would only take the assurances from Colson and that Bittman had been trying to reach Colson. I told O'Brien that I doubted if Colson would be willing to give any such assurances because he was staying more than an arm's length from Hunt. I told O'Brien that I would have to talk to him about it in the morning. On the morning of January 3rd, I received another call from Mr. O'Brien saying that the matter had to be resolved immediately because he had talked to Bittman and they had been trying to get hold of Colson without any success. Colson called me to tell me that Bittman was trying to reach him and asked me if I had seen the letter that Hunt had sent him. I've submitted a copy of the letter to the committee, exhibit number 26. I told Colson that I had not seen the letter. I just returned to my office, and that while we were talking, I found in my mail a memorandum from Colson with a letter attached from Hunt in which he was desperately pleading to have Colson meet with his attorney, Mr. Bittman. I told Colson that I was aware of the fact that Bittman wanted to discuss the matter of executive clemency for Hunt, and that Hunt would only take assurances from him, Colson. As I recall, Colson said that he did not want to meet Mr. Bittman, but would do whatever I suggested. I told him I would have to get back in touch with him. I next met with Ehrlichman and told him about the situation, and he thought that Colson should meet with Bittman. I do not believe Colson was present when I first discussed this with Ehrlichman. I informed Colson that Ehrlichman thought he should meet with Bittman. In trying to reconstruct as best I can as I recall what occurred, there was a meeting in Ehrlichman's office on January 3rd after Colson had had a conversation with Bittman about Hunt's potential for executive clemency. I recall that when Colson came to the meeting with Ehrlichman, he was extremely shaken, which was unlike Colson. He was not specific in his arguments to Ehrlichman, but he said that he felt it was imperative that Hunt be given some assurances of executive clemency. The meeting in Ehrlichman's office did not last long, and Ehrlichman said that he would have to speak with the President. Ehrlichman told Colson that he should not talk with the President about this. On January 4th, I learned from Ehrlichman that he had given Colson an affirmative regarding clemency for Hunt, and that Colson had talked with Bittman about the matter. There was another meeting on this subject on January 5th in Ehrlichman's office, in which Colson explained exactly what he had told Bittman regarding clemency. He said that he had told Bittman that he could not give a specific commitment, but he gave him a general assurance. He also said that he told him that clemency generally came up around Christmas, and a year was a long time. It was as this meeting was ending, I said to Ehrlichman that this will obviously affect all the others involved, as the word will spread, and can I assume that the same commitment extends to all? He said that no one could be given a specific commitment, but obviously if Hunt was going to get an assurance for clemency, the others could understand that it applied to all. After the meeting in Ehrlichman's office, Colson told me that although Ehrlichman had told him that he, Colson, should not discuss this matter with the President, that he, in fact, thought it was so important that he had taken it up with the President himself. I also learned shortly thereafter, as a result of a telephone call from O'Brien, that Bittman had informed O'Brien that Hunt was satisfied with Colson's assurances. As I shall state later, the President himself raised this subject on 2 occasions with me and told me that he had discussed the matter of executive clemency for Hunt with both Ehrlichman and Colson. The President raised this with me on March 13th, 1973 and April 15th, 1973. While I was in California during late December, early January, that I just referred to a moment ago, I also received a call from Mr. Fielding, who told me that Jack Caulfield had received a letter from McCord. Fielding was not explicit regarding the contents of the letter and said that he had taken down the letter and that I could read it when I returned the next day or so to the office. I have submitted a copy of the letter transcribed by Fielding to the committee, exhibit number 27. Within 2 or 3 days of my return to the office, that is between the 3rd and 5th of January, Mr. Caulfield came to my office with the original letter. I do not know what I did with the original, but I believe I gave it to Paul O'Brien. I know that O'Brien and I discussed the matter because he told me that McCord was not cooperating with his lawyer, Mr. Ulch. O'Brien also told me that Bittman had planned a CIA defense to the case, but McCord, who initially had been willing to go along, later refused. O'Brien subsequently talked with Mitchell about the matter, because Mitchell called me and informed me that he had discussed the matter with O'Brien, and Mitchell asked me to request that Jack Caulfield talk with McCord to find out what he was going to do. I told Mitchell I would ask Caulfield to speak with McCord. When I later tried to reach Caulfield, he had gone to California for a drug conference. I later informed Mitchell that Caulfield was out of town. It was on January 10th that I received calls from both O'Brien and Mitchell indicating that since Hunt had been given assurances of clemency and that those assurances were being passed by Hunt to others, that Caulfield should give the same assurances to McCord, who was becoming an increasing problem. And again, I was told that McCord's lawyer was having problems with him. Both O'Brien and Mitchell felt that McCord might be responsive to an assurance from Caulfield because Hunt, Bittman, and his lawyer, Ulch, had lost rapport with him. I told Mitchell I would do so. Based on the earlier conversation I'd had with Ehrlichman on the 5th of January that clemency assurances that had been given to Hunt would also apply to the others, and Colson's description of how he had given Bittman a general assurance without being specific as to the commitment, I called Caulfield later that day to request that he get in touch with McCord. Caulfield told me that it would be very difficult because he was going to be in California for several more days. Caulfield indicated it would be easier for Mr. Ulasewicz rather than himself to talk with McCord because he was tied up with a lot of people at the drug conference. I said fine, and then gave him a clemency message similar to the message that Colson had transmitted to Hunt via Bittman. Caulfield wrote down the gist of the message. He repeated his notes back, and I said that was fine, and told him I thought McCord would be expecting to hear from him as soon as possible. Caulfield said he would have the message delivered right away. On January 11th, I received a call from O'Brien, who asked me if the message had been delivered by Caulfield. I told him that it had. O'Brien told me that McCord wanted to speak with Caulfield personally and asked me when Caulfield could meet with McCord. I told him I would try to arrange it. O'Brien told me that he was going to be out of town, but I could reach him if there were any problems. He told me he was keeping Mitchell posted and requested that I keep him posted. O'Brien said that we needed a first-hand report or first-hand reading on McCord from someone he will talk with, because he's not talking openly with his lawyer about what he plans to do. I told O'Brien I would call him as soon as I had learned anything. I called Caulfield on January 11th and told him that McCord wanted to meet with him and asked him if he would do so and take McCord's pulse as to what he planned to do. He told me he would meet with McCord as soon as he returned to Washington. On Friday, June 12th, Mitchell called me for a report. I told him that I thought I would hear from Caulfield after he talked to McCord. Caulfield called me at home Friday night to inform me that he had met with McCord and suggested we meet at my office in the morning so that he could give me a report. That was a Saturday morning. I said fine, and on Saturday morning we met and he gave me a report. The sum and substance of the report was that McCord had not decided what he was going to do, but he wanted his freedom. Caulfield reported that McCord was very annoyed at Magruder. He had seen a picture of Magruder in the paper, which had piqued his annoyance. He also told Caulfield that he had a plan that would enable him to get his case dismissed, but his lawyers had not helped him with the matter, and the government had lied to him. He explained that he had made calls to certain foreign embassies, and that these calls had been recorded, but the government would not admit it. During this meeting with Caulfield, I received a call from either John Mitchell or Paul O'Brien requesting a report on the meeting. I told the caller I was getting a report from Caulfield and would excuse me, and would call back. Caulfield told me that McCord was very adamant about his plans to gain his freedom through the phone calls that he had made to the foreign embassies. I told Caulfield I really did not understand why McCord thought he could get his case dismissed by reason of the wiretaps, but I would give the matter some thought. Caulfield told me it was his assessment that McCord would only respond to a direct request from the President. I told Caulfield that I could not make such a statement because I had no such request from the President, but suggested he meet again with McCord and keep him happy by telling him we were checking out the matter and of his conversations with the embassies. Later that afternoon, Caulfield reported again to me that McCord was only interested in his theory about the calls to the embassies. I told Caulfield to keep in touch with McCord, but I couldn't promise anything about his calling the embassies. I told Caulfield to have McCord give him a memo on why he thought that his calls to the embassies would result in dismissal of his case. I called O'Brien and told him what had transpired. On Monday morning, I reported to Mitchell what Caulfield had reported. It was sometime during this period that as a result of my reports of Caulfield's meetings with McCord, that O'Brien, Mitchell, and Mr. Alch discussed having F. Lee Bailey, Alch's partner, meet with McCord and inform him that he would personally handle his case on appeal. Mitchell was to talk to Mr. Bailey about this. I don't know what happened regarding this proposed plan. On January 19th or 20th, Mr. Caulfield brought me copies of McCord's memos regarding his intercepted conversations to the embassies. I have submitted these documents to the committee, Exhibit number 28. I never did anything with these documents other than to inform Mitchell that I had received them, and I showed them to Mr. O'Brien in my office. I do not recall ever talking with anyone at the Department of Justice regarding McCord's proposal. At this time, I concluded that McCord was going to do what he thought best for himself. On January 4th, Gordon Liddy called Mr. Bud Krogh. Krogh's secretary received the call, and Liddy said that he had received a letter from an investigator for the Senate Commerce Committee about his relationship with Krogh. This letter was part of an investigation being conducted by the committee staff, the Commerce Committee staff, in connection with Krogh's nomination hearing for Undersecretary of Transportation post, should be. Liddy wished to speak to Krogh, but the call was not put through to Krogh. Krogh came to my office and asked what he should do. He said he wanted to be able to testify at his confirmation hearing that he had not spoken with Liddy since long before the Watergate incident. I told Krogh that his secretary should return the call. We then worked out a response which Krogh wrote down for his secretary, and she returned the call. I have submitted to the committee the document prepared by Mr. Krogh's secretary after the call was returned to Mr. Liddy, Exhibit number 29, and I might note that that was not in the exhibits when I assembled them last night, but I do know where it is on the table at home. On Friday, after...
Take it you'll supply that document later in your testimony.
Yes, Senator, I will.
Thank you very much.
On Friday afternoon, January 5th, I received a report from O'Brien that Liddy had been rather miffed and annoyed that Krogh had been unwilling to speak with him. I reported this to Krogh, who asked if I would personally see what I could do because Krogh felt sorry for Liddy, but just couldn't talk with him. I agreed I would do something and on Saturday, January 6th, I called Liddy from my house at his home. It was a brief call, which I told him the reason Krogh had not called and told him that Krogh had a great sympathy for his plight. Liddy said he understood. The only thing I can recall Liddy saying to me was that he hoped that there would be some money forthcoming for his lawyers. I said I would pass that message along. I also expressed sympathy over his situation, and the call ended. I later reported to Krogh that Liddy understood why he did not speak with him personally, and Krogh appreciated it. Now I'm going to turn to the retrieving of certain CIA materials from the Department of Justice in connection with the investigation. As a result of a conversation I had had with Ehrlichman, I was asked to attempt to have the CIA retrieve from the Department of Justice information relating to Hunt's dealings with the CIA. To understand Ehrlichman's request, I must provide some background. During the course of the Watergate investigation, the prosecutors had requested material from the CIA, and because of the fact that this material related to the White House, the CIA had informed the White House of the request. The first incident, when this came up, was regarding the fact of who had made the initial request to the CIA to assist Hunt. General Cushman had been the deputy director of the CIA at the time that the matter occurred, and when he was asked, he reported that he had been requested from John Ehrlichman. When Ehrlichman was informed of this, I believe by General Cushman, he denied the fact that he had ever made such a request and requested that Cushman this is incorrect in the text here, and told Cushman that he had never asked for such assistance. Subsequently, General Cushman prepared a memorandum that indicated that the request had come from either Ehrlichman, Colson, or myself. Ehrlichman forwarded a copy of this document to me and asked if I would get the matter taken care of. I told him I thought it was somewhat strange that my name was on the memorandum from Cushman, and I had never spoken with Cushman in my life. He then asked me if I did not think it would be better that Cushman mention no one, since he couldn't remember who it was. I remember suspecting at this time, as I do today, that Ehrlichman had had my name inserted in the memorandum as a means of getting me to make sure that Cushman would have no names in the memorandum at all. I remember calling General Cushman and telling him that I had received from Ehrlichman a copy of his memorandum, and that I was somewhat surprised to find my name in it, because this was the first time I had ever spoken with him. He agreed that we had never talked, and I said that Ehrlichman had suggested to me that if he could not remember who it was, that he, Cushman, probably should not mention anyone. A short time later, another memorandum on this subject of who had asked for Hunt to have the assistance of the CIA came forward from General Cushman, and this time no names were mentioned at all. It was after this episode, in getting the Cushman statement corrected, that I had occasion to discuss this with Colson. Colson told me that he had been present when Ehrlichman had made the call to Cushman. The other CIA material relating to Hunt's dealings with the CIA emanated from a series of questions that had been asked by the Watergate prosecutors. I recall a discussion with CIA Director Helms and one of his deputies in Ehrlichman's office when they went over the types of materials that they would be providing to the Department of Justice. I subsequently had occasion, while at the Department of Justice, to talk with Henry Peterson about the CIA material, and he showed me a copy of the information the CIA had provided him. And he told me Mr. Gray had the same material. I remember that the documents had attached to it a number of photographs which had come from a camera. The pictures, again, our text has gotten confused here, come from a camera. The pictures which had been processed by the CIA, let me explain this, come from a camera which had been returned by Hunt to the CIA. It is a camera that had been borrowed by Hunt from the CIA. The pictures which had been processed by the CIA included a picture of Liddy standing in front of Ellsberg's psychiatrist's office. I informed Ehrlichman about this, and that the reason that he subsequently requested that I seek to retrieve the documents before the Senate investigators got a copy of the material. I discussed this with Peterson, but he said that he had received a letter in early January of this year from Senator Mansfield regarding the maintenance of all records relating to the case, that the only thing that he could do would be to extract the document and leave a card to the effect that the document had been returned to the CIA. I reported this to Ehrlichman, and he told me that he thought that the CIA ought to get all of the material back, and that no card should be left in the file, and that national security grounds should be used to withhold release of the information. On February 9, 1973, I spoke with Director Schlesinger of the CIA and asked him if it would be possible to retrieve the material that had been sent to the Department of Justice in connection with the Watergate investigation. I told him that I discussed this with the Department of Justice, and they indicated that they would merely leave a card in their files indicating that the material had been returned to the CIA. I subsequently had a visit from General Walters in late February, at which time he told me that the CIA was opposed to retrieving the material and leaving a card indicating they had so retrieved it, because they also had been requested by the Senate not to destroy any material relating to the case. I told Walters that I did not suggest that the material be destroyed. Rather, I thought that national security grounds might justify withholding release of the information to the Senate investigators. He said it simply could not be done, and I dropped the matter. As I will explain later in a meeting with Bud Krogh, the fact that this material was in the possession of the Department of Justice meant to me that it was inevitable that the burglary of Ellsberg's psychiatrist's office would be discovered. I felt that any investigator worth his salt would certainly be able to look at the pictures in the files of the Department of Justice and immediately determine the location, and from there discover the fact that there had been a burglary of the office that was in the picture. I would now like to turn to the White House plans for dealing with this committee. Even before the Watergate criminal trial in January of this year, there have been press reports and rumors that the Senate planned independent hearings on the Watergate and related matters. The White House Congressional Relations Staff reported that the subject of the Watergate hearings was being discussed in the Senate Democratic Policy Committee, but they did not know the substance of those discussions. I was aware of the interest of Ehrlichman and Haldeman in the prospects of such hearings because they had discussed it with me, and Bill Timmons told me they had discussed it with him. On December 13, 1972, Timmons informed me that Senator Jackson was coming to the White House for a meeting with the President. Timmons said that Senator Jackson was a member of the Senate Democratic Policy Committee and had had an excellent rapport with the President. Timmons asked me what I thought about having the President inquire of Senator Jackson regarding the potential of a Senate inquiry into the Watergate. I responded that I thought it was a good idea, but I would have to check. Timmons said that the meeting with Senator Jackson was going to be without staff present and asked me to draft a memorandum to the President raising the issue. I told him I would check with Haldeman. I prepared a memorandum for the President and went to Haldeman's office, but he was not there. He was in the President's office with Miss Ann Armstrong, who was discussing with the President joining the White House staff. A meeting had been scheduled in Mr. Ehrlichman's office at which Mr. Ehrlichman, Moore, Ziegler, and I were to attend. When Ehrlichman came to Haldeman's office for the meeting, I raised the matter of the President's asking Senator Jackson about the hearings because I did not have authority to send memoranda directly to the President. Ehrlichman thought it was a good idea, so I walked the memorandum down to Alex Butterfield to take to the President before the meeting. I have submitted to the committee, Exhibit Number 30, a copy of the memoranda. When Haldeman returned to his office with Mrs. Armstrong, Ehrlichman and I were there in his office waiting, but he asked us to leave and to proceed with the meeting in Ziegler's office where Moore and Ziegler were waiting. I referred earlier to the substance of the meeting on December 13th in discussing the proposed written Dean report. Ehrlichman returned to his office, and Haldeman later came to the meeting and told me that he had blocked the memorandum regarding the Watergate inquiry from going to the President. He, in fact, had the original memorandum with him and had drawn a line through it. I told him that Timmons had suggested it and that Ehrlichman had also approved it. He said he had not known that. the effect that the document had been returned to the CIA. I reported this to Ehrlichman, and he told me that he thought that the CIA ought to get all of the material back, and that no card should be left in the file, and that national security grounds should be used to withhold release of the information. On February 9, 1973, I spoke with Director Schlesinger of the CIA and asked him if it would be possible to retrieve the material that had been sent to the Department of Justice in connection with the Watergate investigation. I told him that I had discussed this with the Department of Justice, and they indicated that they would merely leave a card in their files indicating that the material had been returned to the CIA. I subsequently had a visit from General Walters in late February, at which time he told me that the CIA was opposed to retrieving the material and leaving a card indicating they had so retrieved it, because they also had been requested by the Senate not to destroy any material relating to the case. I told Walters that I did not suggest that the material be destroyed. Rather, I thought that national security grounds might justify withholding release of the information to the Senate investigators. He said it simply could not be done, and I dropped the matter. As I will explain later in a meeting with Bud Krogh, the fact that this material was in the possession of the Department of Justice meant to me that it was inevitable that the burglary of Ellsberg's psychiatrist's office would be discovered. I felt that any investigator worth his salt would certainly be able to look at the pictures in the files of the Department of Justice and immediately determine the location, and from there discover the fact that there had been a burglary of the office that was in the picture. I would now like to turn to the White House plans for dealing with this committee. Even before the Watergate criminal trial in January of this year, there have been press reports and rumors that the Senate planned independent hearings on the Watergate and related matters. The White House Congressional Relations Staff reported that the subject of the Watergate hearings was being discussed in the Senate Democratic Policy Committee, but they did not know the substance of those discussions. I was aware of the interest of Ehrlichman and Haldeman in the prospects of such hearings because they had discussed it with me, and Bill Timmons told me they had discussed it with him. On December 13, 1972, Timmons informed me that Senator Jackson was coming to the White House for a meeting with the President. Timmons said that Senator Jackson was a member of the Senate Democratic Policy Committee and had had an excellent rapport with the President. Timmons asked me what I thought about having the President inquire of Senator Jackson regarding the potential of a Senate inquiry into the Watergate. I responded that I thought it was a good idea, but I would have to check. Timmons said that the meeting with Senator Jackson was going to be without staff present and asked me to draft a memorandum to the President raising the issue. I told him I would check with Haldeman. I prepared a memorandum for the President and went to Haldeman's office, but he was not there. He was in the President's office with Miss Ann Armstrong, who was discussing with the President joining the White House staff. A meeting had been scheduled in Mr. Ehrlichman's office at which Mr. Ehrlichman, Moore, Ziegler, and I were to attend. When Ehrlichman came to Haldeman's office for the meeting, I raised the matter of the President's asking Senator Jackson about the hearings because I did not have authority to send memoranda directly to the President. Ehrlichman thought it was a good idea, so I walked the memorandum down to Alex Butterfield to take to the President before the meeting. I have submitted to the committee, Exhibit number 30, a copy of the memoranda. When Haldeman returned to his office with Mrs. Armstrong, Ehrlichman and I were there in his office waiting, but he asked us to leave and to proceed with the meeting in Ziegler's office where Moore and Ziegler were waiting. I referred earlier to the substance of the meeting on December 13th in discussing the proposed written Dean report. Ehrlichman returned to his office, and Haldeman later came to the meeting and told me that he had blocked the memorandum regarding the Watergate inquiry from going to the President. He, in fact, had the original memorandum with him and had drawn a line through it. I told him that Timmons had suggested it and that Ehrlichman had also approved it. He said he had not known that and made a notation on the memorandum to the President and immediately sent it back to Butterfield to give to the President. I learned that day from Timmons, who later met with Senator Jackson, that the Senator did not know what the Senate Democratic Policy Committee was going to do about the Watergate. I do not know if the President discussed this subject with Senator Jackson. Timmons continued to report to Haldeman and me that there were rumblings on the Hill that the Senate was going to proceed with hearings. Senator Kennedy's subcommittee on administrative practices and procedures had been conducting an investigation for several months, but it was uncertain as to whether they would proceed. It was learned in late December, early January, that Senator Mansfield was pushing hard for Watergate hearings, but there was a debate as to who should handle the hearings. On January 5th or 6th, it was reported in the press that Senator Mansfield had sent a letter to Senator Eastland and Senator Ervin regarding the holding of hearings. Before that letter became public, however, both Wally Johnson and Fred LaRue had informed me that they had talked with Senator Eastland. The White House wanted Senator Eastland to hold such hearings because they felt that Senator Eastland would be friendly and that the White House had more friends on the Judiciary Committee than on Senator Ervin's Government Operations Committee. I was told that the White House Congressional Relations staff was doing what it could to get the hearings before Senator Eastland's committee. On January 11th of this year, the Senate Democrats formally voted that Senator Ervin would head the inquiry into the Watergate incident and related matters, and I must add, much to the displeasure of the White House. On February 5th, 1973, the chairman introduced his resolution to create this committee. An advance copy of that resolution was forwarded to me by Timmons, and I was subsequently requested to attend a luncheon meeting with Ehrlichman, Timmons, and Johnson to discuss the resolution. Ehrlichman was tied up in another meeting and never attended. I was asked what I thought about the resolution and did I have any suggested amendments that the Republicans might offer. I had not had an opportunity to study the resolution closely, so I reread it and offered a few suggestions off the top of my head. That it be broadened to cover other elections in the 1972 presidential campaign, that the minority members have adequate staff, that it be a bipartisan with equal representation of the Republicans and the Democrats, and that the minority members have the power to call for an executive session when they believed it necessary. Wally Johnson indicated that he would get someone at the Department of Justice to draft the amendments and that he and Timmons would peddle them to friendly Republicans. I later had discussions with Haldeman and Ehrlichman about the Senate hearings, and they felt it was time to develop a strategy for dealing with the Senate situation. I received what I interpreted as mild criticism that I wasn't getting the White House prepared for the forthcoming hearings, and it was recognized that we were fast moving into an uncontrollable, if not hostile, forum. We had made it through the trial without any problems, but the Senate hearings were a new and possibly larger problem. Accordingly, I suggested that there be a meeting called where these matters could be discussed. I also suggested that we call on Mr. Bryce Harlow. Ehrlichman, Haldeman, and Mitchell all agreed that Harlow's counsel would be most helpful. Accordingly, I had my secretary schedule a meeting in Ehrlichman's office on February 6, 1973. I recall that it was at some hardship that Mr. Harlow attended and that he was to fly to Arizona that day, but I explained to him that my superiors were anxious to focus on the problem and wanted his advice. Prior to this meeting, but after my meeting with the President in September, when he had mentioned to me that Mr. Hoover had told him that he, the President, had been bugged during his 1968 campaign, the thought of getting this information had been discussed. I recall discussing it with Ehrlichman and Haldeman and in turn discussing it with Mitchell. Haldeman and Ehrlichman wanted Mitchell to get information from DeLoach. I so informed Mitchell. Mr. Mitchell informed me that he was trying to get the facts regarding the bugging from Mr. DeLoach, whom he believed would have known if it had in fact happened. Mitchell had talked to DeLoach prior to the February 6th meeting and had received some information, but not much. The meeting assembled in Ehrlichman's office. Mitchell was late in arriving because of delayed flight from New York. Those present were Ehrlichman, Haldeman, finally Mitchell, Harlow, Moore, and myself. When Mitchell arrived, he reported that there had been some surveillance by the Johnson administration, but DeLoach was unaware of a bugging or wiretap. I remember that I told Harlow that I thought he had been recorded when he was traveling with the Vice President in 1968. I based this on a conversation I'd had with Mitchell earlier. The surveillance that Deloach reported to Mitchell was related to Mrs. Anna Chenault and a foreign embassy. Also, the telephone toll records from the vice presidential candidate Agnew's airplane when he had stopped in Albuquerque, New Mexico, had been checked by the FBI. The meeting then turned to a general discussion of the proposed amendments, and Timmons was called from the congressional leadership meeting that was then in session in the cabinet room. Timmons reported that the Senate was going to begin debate on Senator Ervin's resolution that afternoon. Timmons was instructed to request Senator Scott to come to his office after the leadership meeting, and I was instructed to go to Mr. Timmons' office to explain the amendments to the resolution to Senator Scott. I was also told that I should tell Senator Scott, to raise the 1968 bugging incident as a reason to expand the scope of the resolution prior to the presidential elections. Resolution with reference to prior presidential elections. I left to brief Senator Scott with the feeling that the meeting had accomplished nothing. I went to Timmons' office, had a brief meeting with Senator Scott, and as I was returning to my office, I ran into Dick Moore, who told me that he felt that the meeting had been useless. I agreed. On February 7th, Timmons informed me that the White House amendments had been virtually rejected out of hand, and the resolution adopted 77-0. Timmons told me that he had discussed with Haldeman the possibilities of suggesting names for the Republican side of the Select Committee with Senator Scott, and Scott seemed receptive. On February 8th, the members of this committee were named, and as I recall, Timmons telling me that Haldeman had chewed him out, but Timmons told me that Scott had never given him a chance to make any recommendations. On February 9th, I had planned to go to Florida for a week to 10 days. The President had departed for San Clemente, and it appeared that everyone could relax for a while. In mid-afternoon, however, my plans were changed when I received a call from Ehrlichman in San Clemente telling me that he wanted Mr. Moore and me to come to California that night so that we could discuss in full detail the problems of how to deal with the forthcoming Senate hearings. Ehrlichman indicated that he and Haldeman were going to have some available time over the weekend, so we should come immediately. I contacted Mr. Moore, who was about to take a train trip to Southern Virginia with his young son and wife. Moore said that since he was packed, he would merely fly west instead of training south. My wife and I and the Moores all flew to San Diego on the evening of the 9th of February. Everyone was staying at the La Costa Resort Hotel south of San Clemente. The meetings with Haldeman and Ehrlichman, Moore and myself, ran for 2 days, and I would estimate they involved between 12 to 14 hours of discussion. The meetings began on Saturday morning, February 10th, at San Clemente, but the discussions did not begin to take any focus until Saturday afternoon and Sunday when we met at Haldeman's villa at La Costa. Based on the notes I took during the meeting, I will attempt to reconstruct what transpired. I should also point out that before I departed San Clemente to return to La Costa, I was given several memoranda which I have submitted to the committee, Exhibit number 31, which directly relate to what occurred at La Costa. I did not look at these memorandum until several days after the meeting and was rather surprised that Haldeman would state in writing specific instructions to me regarding his thoughts on perpetuating the Watergate tactics or the cover-up by a counteroffensive against the forthcoming Senate hearings. What had happened by this point in time was that the cover-up had become a way of life in the White House, and having made it to this point, those involved were becoming careless and more open about it. Also, the Senate was different than the courts, the grand jury, the FBI, and the like that had been dealt with earlier. Before turning to the substance of the La Costa meeting, I would like to note that Mr. Moore and I had talked on many occasions about the Watergate affair and the damage it was doing. Mr. Moore is the only person, other than Mr. O'Brien on a few occasions, to whom I ever expressed my deep concern about the matter, particularly to the cover-up. While Moore did not know all the facts, he knew a great deal and was becoming increasingly aware of the dimensions of the problem. I talked to Moore far differently than anyone else. I talked to him about how we could end this matter once and for all. I expressed my concern to him often about how to end the matter before it ruined the second term of the president. I was concerned that it was not going to simply go away, and I had learned that the press was becoming aware of other illegal activities at the White House. I never discussed these other matters with Moore, but I told him that the cover-up was bigger than the Watergate incident per se. The more that we talked about it, the less we could find a solution, so the cover-up proceeded. As I have indicated, the purpose of what I call the La Costa meetings was how to deal with this committee's investigation of the Watergate. The Watergate trial was over, and that problem appeared to be over. The next major problem was the Senate hearings. It was realized it was going to take an all-out effort by the White House to deal with the Senate inquiry because of the scope of the resolution, the composition of the committee, the investigative powers of the committee, and the general feeling that the Senate was a hostile world for the White House. Haldeman and Ehrlichman were disappointed that the efforts to influence the Senate resolution creating the Select Committee had failed, as well as the White House efforts to recommend members to the Select Committee. Thus, the focus of the discussion was how to deal with the committee henceforth. It was during the morning meeting in Ehrlichman's office at San Clemente that there was a discussion of the members of this committee. Ehrlichman said that the White House could not look for any help from the Democrats. I recall that when we were discussing the Democratic members of this committee, and I read from the Congressional Directory the data on Senator Anoia, Ehrlichman said that his name is pronounced "ain't no way." And I said, indeed, and then said, indeed, there ain't no way he's going to give us anything but problems. The Republican members of this committee were also discussed in that morning meeting. It was Ehrlichman who was doing most of the assessing, but occasionally Haldeman would also add a comment. Senator Weicker was an independent who would give the White House problems. Senator Gurney would help the White House and would not have to be told to do so. I recall that Ehrlichman said that Senator Gurney needs the White House because former Congressman Kramer may take him on in the next primary. Senator Gurney was considered a sure friend and a protector of the president's interest. Senator Baker was an unknown, and neither Haldeman nor Ehrlichman knew which way he might go.
Please, the audience will please refrain from demonstrating in respect to testimony in the committee, too.
I might add that in subsequent discussions I had with the President, he also reached a similar conclusion regarding the Republicans. He thought that Senator Baker might help, but he was not sure. He was confident, however, that Senator Gurney would protect the White House and would do so out of political instinct and not have to be persuaded to do so. The long and short of this morning discussion was that the White House had one friend, Senator Gurney, and the possibility of wooing and winning another. Later, after the meeting had reconvened at La Costa, the discussion turned to a general approach about how to deal with the Select Committee. Ehrlichman suggested that it should be publicly analogized to the ITT hearings. That is, the hearings were a waste of time to the Senate. They were very partisan and ultimately repudiated by the Senate when Klein East was confirmed. After a general discussion, Ehrlichman and Haldeman concluded that the theory for dealing with this committee should be as follows. The White House will take a public posture of full cooperation, but privately will attempt to restrain the investigation and make it as difficult as possible to get information and witnesses. A behind-the-scenes media effort would be made to make the Senate inquiry appear very partisan. The ultimate goal would be to discredit the hearings and reduce their impact by attempting to show that the Democrats have engaged in the same types of activities. During the meeting on Saturday afternoon, February 11th, Ehrlichman instructed me to call Wally Johnson and tell Johnson that he was going to visit with Senator Baker during the then congressional recess to find out how the senator planned to operate. That is, was he going to be friend or foe? And to ask Senator Baker how the White House could aid him, particularly regarding the selection of the minority counsel. Prior to making the call, I asked Ehrlichman if I should arranged to give Johnson some kind of briefing before he went to see Senator Baker so that he would know fact from fiction when talking to the senator about the Watergate. Ehrlichman said that was not necessary. I called Mr. Johnson while the discussions proceeded and passed the message to him. He said he would proceed immediately. At one point in the meeting, Ehrlichman raised the question of whether or not the Select Committee was going to be able to obtain the grand jury minutes and other investigative reports from the FBI and the U.S. Attorney's Office. I said I did not know, and then a discussion of the possible legal options ensued. No one really knew what the law might be regarding this matter, but Ehrlichman stated that the Attorney General will have to be told that the Justice Department should resist turning over such records, and that I should get word back to the attorneys for the defendants that they should fight the release of these investigative records to the Senate on the grounds that it would have an adverse impact on their appeals. When discussing how to handle the press coverage of the Senate hearings, Haldeman suggested that Pat Buchanan be used as a watchdog of the press. Mr. Buchanan could prepare speeches on the biased press coverage. He could write op-ed articles and actually attend the hearings and be a White House spokesman to take the pressure off of Ziegler's daily briefings. It was decided by Haldeman and Ehrlichman that Mr. Baruti's White House Attack Group, a group of media-oriented White House aides who meet virtually every morning to determine how to counter adverse news or push White House programs, should not be involved. There was also discussion during the LaCosta meeting of the role of the Re-election Committee, the role they would play during the Senate hearings. It was decided that the Re-election Committee should have a new titular head. Several names were suggested and rejected, and the matter was left unresolved. However, it was decided that the Re-election Committee should beef up its legal and public relations staff. Paul O'Brien and Ken Parkinson should be given additional legal staff, they wished, as they would be responsible for handling witnesses from the committee who would be called to the Hill to testify. Mr. Van Shumway, who had been handling press relations for the Re-election Committee, would be asked to remain on and provided with any additional staff he needed. Mr. Moore would have general oversight over Mr. Shumway's operation. At one point, Haldeman suggested that the Re-election Committee hire private investigators to dig out information about the Democratic campaigns. I raised the wisdom of this because I thought it would be more political surveillance. The matter was left unresolved. There was a lengthy discussion of the importance of the minority counsel. Mr. Moore related back to some episodes during the McCarthy hearings. Both Ehrlichman and Haldeman felt very strongly about having a man as minority counsel who would work with the White House. A number of suggestions were made and discussed. Ehrlichman thought that Mr. Fred Buzzard would be an excellent choice. I was asked to come up with some names for consideration as soon as possible and report back. It was toward the end of the meeting on Sunday afternoon, February 11th, that Ehrlichman raised the bottom line question. Would the 7 Watergate defendants remain silent through the Senate hearings? I say this was the bottom line question because the entire strategy was based on this continued silence. I reported that I could not answer the question because I did not know. I said that I understood that they were still demanding more money, but as we had discussed previously, there was no money available. I told both Haldeman and Ehrlichman that I had carried their messages to Mitchell and that this is something that they would have to take care of. I think our transcript here got confused again. That this was something that he should take care of, he, Mitchell, but that they were aware of Mitchell's feelings that this was something the White House should be concerned about. I said that as far as I was concerned, that they would have to take this up with Mitchell themselves, and that Mitchell felt it was a matter for the White House. At that point, Ehrlichman told Mr. Moore, who was hearing all of this for the first time, that he, Moore, should go to Mitchell and simply lay it out that it was Mitchell's responsibility to raise the necessary funds for these men. It had been decided at the outset of the first day of the meetings that Moore would go to New York and report to Mitchell on what had been resolved regarding the Senate hearings. And now Ehrlichman was telling Moore that an important element of his visit with Mitchell would be for him to get Mitchell to raise the necessary future funds for the 7 Watergate defendants. The meeting concluded on this item, and Moore and I departed together. I told him as we walked back to our rooms that I was very distressed that this had come up in his presence, but he now had some very real idea of the dimensions of the situation. I told him I did not think that he should get involved in carrying such a message to Mitchell. Moore was concerned but felt that he had an obligation to do what Ehrlichman and Haldeman expected of him, but he did not understand why they thought that he could change Mitchell's mind. Shortly after Moore and I departed, I went to Los Angeles to join my wife at her mother's home, and we left for Florida the next morning, February 12th. While in Florida, I received calls from Higbee, Moore, Johnson, and others following up on matters that had been set in motion at the La Costa meeting. On February 13th, I received a call from Wally Johnson, who informed me that he had talked with Senator Baker by telephone. He told me that he had informed Senator Baker that he would serve as the White House liaison to the Select Committee. Johnson reported that Senator Baker had told him that a personal visit was not necessary, that they could talk when he returned to Washington from Tennessee. Johnson said that he had discussed the minority counsel position with Senator Baker, and that the senator said that he did not want any official input from the White House and had already given some thoughts to the qualifications he was seeking in his minority counsel. Johnson reported that the senator had 50 names already under consideration and planned to make his selection within the next few days. Johnson told me that he did not think that Senator Baker had ruled out the White House making some suggestions, but we would have to move quickly. Mr. Johnson also reported that Senator Baker had told him that the White House should be concerned about the President's posture vis-a-vis the Senate inquiry. Finally, he reported that Senator Baker had indicated that he and the chairman would be getting together after the recess and would discuss staffing and procedural matters at that time. I passed this report to Haldeman via Mr. Higbee. On the 14th of February, Paul O'Brien came to visit me in Florida. He arrived in the evening, and we went out to dinner. Nothing of substance was discussed that evening other than some hand-wringing over the general situation. O'Brien came to Florida to get a report from me on what had occurred at the La Costa meeting. He told me that Mitchell wanted him, O'Brien, to get my version of the meeting as well as the report he was getting from Mr. Moore. On February 15th, after a late breakfast, O'Brien and I took about a 2-hour walk down the beach, at which time I told him what had occurred at La Costa. I told him that Moore had been dispatched to New York by Haldeman and Ehrlichman to tell Mitchell it was his responsibility to raise the future money for the convicted defendants. O'Brien's reaction, as he was well aware of Mitchell's feelings that this was Haldeman and Ehrlichman's problem and not his, was that Mitchell would probably go through the roof. After returning from our walk, we talked about the fact that I had been requested to suggest the names for minority counsel. It was during this conversation that I thought of Martin Hoffman, who I knew to be a very capable lawyer and then serving as general counsel of the Atomic Energy Commission, and a person who had worked on the Hill. I called Mr. Hoffman and asked him if he was interested. He said he was, but he didn't know if Senator Baker would be because they had had some differences of opinion over a matter at the Atomic Energy Commission. He said, however, that he had done some work for Senator Baker in the past and liked him very much. I then called Ehrlichman, and he agreed that Mr. Hoffman would be a good choice. Next, I called Haldeman, and he said okay if Ehrlichman says okay. During my conversation with Haldeman, he told me that he had learned that the chief counsel's job had been offered to Mr. Kenneth Keating, and Mr. Keating had sent a feeler to the White House as to whether he should be interested. Haldeman asked me to think about it. After talking with Ehrlichman and Haldeman about Mr. Hoffman, I called Timmons and Johnson and asked them to float Mr. Hoffman's name to Senator Baker. Mr. Timmons called me back later and said that it wouldn't float because the senator had indicated he still had some problems with Mr. Hoffman, or he had had some problems with Mr. Hoffman and Chairman Schlesinger over an AEC matter. He liked Hoffman, but said he was still miffed at him. Later that day, I called Mr. Moore, but learned that he had gone to New York to see Mitchell. I'd talked with Moore earlier that week, but had forgotten he was going to New York on the 15th. Paul O'Brien called Mitchell in the mid-afternoon to report our conversation. I was in and out of the room while he was on the telephone talking to Mitchell, as I didn't feel it was my business listening to his conversation. I talked briefly with Mitchell at the end of the conversation he had had with O'Brien. We talked about the possibility of Mr. Keating as chief counsel. Mr. Mitchell seemed intrigued by the idea, but doubted if Mr. Keating would accept. After I hung up, O'Brien reported that Mr. Moore had brought up the money-raising matter, but Mitchell just didn't discuss it at any length with Moore. O'Brien departed from Florida late that afternoon, and my wife and I got away from the telephone for the next 3 days. I returned to the office on Monday, February 19th, and spoke with Haldeman on either the 19th or the 20th. He requested I draw up an agenda for a meeting with the President regarding matters which the President should reflect on as a result of the La Costa meeting and subsequent matters which had come up. Mr. Haldeman and I went over the high points of what should be raised, including the items that had not come up at La Costa, such as Magruder's desire to return to the White House staff and sending Mr. Stans to the Senate for a confirmable post as a tactic to counter the Watergate hearings. I prepared the agenda. I thought that I was going to attend the meeting with the President, but Haldeman called for the agenda and not me. I have submitted to the committee a copy of the agenda, exhibit number 32. You will see that the agenda deals with five items to be discussed and resolved with the President. 1, Senator Baker's requested meeting with the President. 2, submitting Secretary Stan's name for a confirmable position. 3, what to do with Mr. Magruder. 4, using Mr. Buchanan during the Senate hearings. And 5, getting the Attorney General back in touch with the White House. Subsequent to Haldeman's meeting with the President, he informed me that the President would meet with Senator Baker. I should discuss with Stans his interest in a confirmable position. Magruder could not return to the White House staff. Buchanan could not be used at the Senate hearings, and the President would meet with the Attorney General. I have not explained at this point the details of this rather significant document, but I believe the document is rather self-explanatory of the continuing cover-up, and I will, of course, answer any questions about it. I was not present when the President and Haldeman discussed these matters, but I had discussed them with Haldeman before he went to see the President, and he informed me of the President's decisions after the meeting. Thus, I assumed the agenda that I had prepared was the basis of their discussions. On February 20th or 21st, Mr. Timmons told me that he arranged for the President to have an off-the-record private meeting with Senator Baker. As you will note from the agenda I referred to just a moment ago, Mr. Timmons had reported that Senator had told Timmons that he wanted guidance, and Timmons' interpretation was that the Senator wished to help the White House. Haldeman told me to prepare a briefing paper for the President and to bring it directly to him rather than routing it through normal channels. I have submitted to the committee, exhibit number 33, a copy of the agenda I prepared for the President's meeting with Senator Baker. After the President met with Senator Baker, I was informed by Haldeman that the Senator had appeared to be very interested in being cooperative. The President had the impression he might be helpful. This, of course, was the White House hope, but nothing that was reported from the meeting made these any more than a hope. Also, Senator Baker had told the President that he wanted his contact point to be Mr. Kleindienst rather than someone on the White House staff. Haldeman told me that Senator Baker had urged the President to waive executive privilege and send members of the White House staff to the hearings as quickly as possible. But the President had told Senator Baker that he was going to hold the line of written interrogatories. Finally, I was told that both the President and Senator Baker had discussed that there should be an effort to get the hearings over as quickly as possible. This report of the meeting, which Haldeman gave me, was later confirmed in discussions I had with the President myself in early March of this year. On February 22nd, Mr. Haldeman requested that I prepare a briefing paper for the President's meeting that day with the Attorney General. Throughout the Watergate investigation, Haldeman, and particularly Ehrlichman, had complained about Kleindienst's passive role in the investigation and the prosecution. Haldeman and Ehrlichman were both aware of the strained relationship between Kleindienst and the White House. I knew that Ehrlichman was riding hard on the Justice Department in an effort to undermine Kleindienst. I also knew from conversations with Kleindienst that he had little affection for Mr. Ehrlichman. The Senate Watergate hearings presented a real possibility of the Justice Department having to make further criminal investigations that would lead back to the White House. Accordingly, the President was the only one who could bring Mr. Kleindienst back into the family to protect the White House, and this meeting was designed to do just that. As a result of Senator Baker's request that Kleindienst be his contact point, the President had a perfect vehicle to solicit Kleindienst's assistance during the hearings, and if anything should develop during the hearings, to not let all hell break loose in the subsequent investigation. I have submitted to the committee, Exhibit number 34, a copy of the briefing paper I was requested to prepare. I know that this document went to the President because just before the meeting was to occur, I realized that the President might not understand the reference to the fact that Kleindienst was considering one particularly attractive offer from a law firm that he was likely to accept. I called Haldeman to explain this, but Haldeman said the paper had gone in and the President would understand that this was a reference to Governor Connolly's law firm because Governor Connolly had discussed this with the President. The President subsequently discussed this meeting with me in early March. He told me that he would continue to call Mr. Kleindienst from time to time, but I should also make certain that Kleindienst was working closely with Senator Baker in preparation for the Select Committee hearings. As I have mentioned earlier, I had also been informed that the President had made a decision that Magruder could not return to the White House. Magruder had been working at the inaugural committee, and even before the inauguration he told me that he had called Mr. Higbee requesting a meeting with Haldeman to discuss his future. After the inauguration, Magruder told me that he had to decide what he was going to do. Prior to that meeting, I had informed Haldeman that Mr. O'Brien had had some discussion with Magruder, and that Magruder had indicated that Haldeman and Colson were very much involved in the planning and approval of Liddy's operation. After Magruder met with Haldeman in late January 1973, I had occasion to see him in the hall of the Executive Office Building. He told me that he was talking with Haldeman and Mitchell about running for office in California and was planning a trip to California to test the water. He said now was the time because he felt he could get good financial backing. I felt Magruder was in for some serious problems both before the grand jury and the Senate hearings. But without saying this to him, I tried to dissuade him from running for office until this entire matter had been resolved. Shortly after this conversation with Magruder, I phoned Haldeman and told him that I thought Magruder was making a mistake going to California in pursuit of elective office. Haldeman agreed and said that he was going to call Bob Finch and suggest that when Magruder met with him, Finch, that he be dissuaded. He asked me to call Kalmbach and make a similar suggestion, which I did, and Kalmbach said he would do. After Magruder returned from California, he decided that he wanted to stay in Washington. He was pushing hard to return to the White House staff and work on the bicentennial program. No one had the heart to tell Magruder that the President had said that he could not return to the White House staff. It was during this period of time, which I believe was mid-February, Magruder had a conversation with Mr. O'Brien in which he told O'Brien that he had received his final authorization for Liddy's activities from Gordon Strachan, and that Strachan had reported that Haldeman had cleared the matter with the President. I reported this to Haldeman, who expressed concern over Magruder's statement. After I reported this information, the White House efforts to find a job for Magruder became intense, and Haldeman assigned Mr. Higbee to the task. Higbee called me to discuss the general type of job that I thought would satisfy Magruder, and then Higbee instructed Mr. Jerry Jones, the head of the White House personnel operation at that time, to find an available, high-level, non-confirmable position for Mr. Magruder. During the time when Mr. Jones was reviewing all of the potential jobs for Magruder, I recall that Magruder dropped by my office and told me he had discussed his potential problems in full with both Higbee and Haldeman. He asked me for my assistance and support in finding him a job. I assured Magruder I would help. He also indicated that Mitchell was trying to help him get a job, or get the job matter resolved. On February 28th, Mr. Jones submitted a memorandum to Higbee and myself, a copy of which I have submitted to the committee, Exhibit 34A. After Haldeman reviewed the memorandum, a meeting was scheduled for Magruder to meet with Haldeman, and I was asked to attend. This meeting occurred during the first week of March, and Magruder explained to Haldeman at the meeting that he did not want to leave Washington. Haldeman told Magruder that his working at the Bicentennial was not realistic, but to consider the position at the Department of Commerce as an assistant to the Secretary for Policy Development. Magruder said he was interested, but wanted some assurances from Haldeman that if he made it through the Senate hearing, as he had the grand jury in trial, that he could have a better job later. Haldeman said that he could not make a firm promise, but that he would do all he personally could to assist. This was good enough for Magruder. Haldeman said that Mr. Jones would be told to proceed with Secretary Dent to get the position at Commerce Department finalized. On March 5th, I received a call from Secretary Dent regarding his hiring Mr. Magruder. I did not want to tell Secretary Dent that Magruder was totally free from future problems, so I was evasive with him, but hinted that Magruder might have some problems. Because I regretted misleading him, I prepared a memorandum for my files, something I seldom do, because I felt Magruder was, in fact, going to have his problems. In fact, I thought everyone was going to have problems. I have submitted a copy of this memorandum reflecting this conversation with Secretary Dent to the committee, exhibit number 35. I would now like to turn to the meetings I had with the President in February and March of this year. I have described to the committee several matters that followed the La Costa meeting which directly involve presidential decision-making and presidential involvement. I would now like to turn to my direct dealings with the President, which began in late February of 1973 with regard to the Watergate and related matters. I feel I can best set forth what transpired at these meetings by discussing what occurred at each meeting. The meeting of February 27th. This was the first meeting I had had with the President since my September 15th, 1972 meeting, which related to the Watergate. It was at this meeting that the President directed that I report directly to him regarding all Watergate matters. He told me that this matter was taking too much time from Haldeman and Ehrlichman's normal duties, and also told me that they were principals in the matter, and I therefore could be more objective than they. The President then told me of his meetings with Senator Baker and the Attorney General. He told me that Senator Baker had requested that the Attorney General be his contact point, and that I should keep in contact with the Attorney General to make sure that the Attorney General and Senator Baker were working together. He asked me to follow up immediately to determine if the Attorney General and Baker had met. I informed him that I had earlier discussed this with the Attorney General, and the Attorney General was planning to meet with Senator Baker and Senator Ervin to discuss turning over FBI data regarding the Watergate investigation. A brief discussion followed in which the President recounted what had already been reported to me by Haldeman, that he had told Senator Baker that he would not permit the White House staff to appear before the Select Committee. Rather, he would only permit the taking of written interrogatories. He asked me if I agreed with this, and I said that written interrogatories were something that could be handled, whereas appearances might create serious problems. He told me he would never let Haldeman and Ehrlichman go to the Hill. He also told me that Senator Gurney would be very friendly to the White House, and it would be not necessary to contact him because the President said that Senator Gurney would know what to do on his own. On the way out of his office, he told me I had done an excellent job of dealing with this matter during the campaign, that it had been the only issue that McGovern had, and the Democrats had tried to make something out of it, but to no avail. I told him that as we were walking together out of the office, that I had only managed to contain the matter during the campaign, but I was not sure it could be contained indefinitely. He then told me that we would have to fight back, and he was confident that I could do the job. The meeting on February 28th with the President. I had received word before I arrived at my office that the President wanted to see me. He asked me if I had talked to the Attorney General regarding Senator Baker. I told him that the Attorney General was seeking to meet with both Senator Ervin and Senator Baker, but a meeting date had not yet been firmed up. I told him that I knew it was the Attorney General's wish to turn over the FBI investigation, and the President said that he didn't think we should, but asked me what I thought of the idea. I told him that I did not think there was much damaging information in the FBI investigation, although there could be some bad public relations from it. He told me to think about this matter. He also said that he had read in the morning paper about the Vesco case and had asked me what part, if any, his brother Ed had had in the matter. I told him what I knew of his brother's involvement, which was that he was an innocent agent in the contribution transaction. We then discussed the leak to Time magazine of the fact that the White House had placed wiretaps on newsmen and White House staff people. The President asked me if I knew how this had leaked. I told him that I did not, that I knew several people were aware of it, but I didn't know any who had leaked it. He asked me who knew about it. I told him that Mr. Sullivan, Mr. Mark Felt, and Mr. Mardian were aware of it. I told him that Sullivan had told me that he thought that Director Hoover had told somebody about it shortly after it happened because Hoover was against it, and that Sullivan said that he had heard that this information had gone to Governor Rockefeller and in turn come back from Governor Rockefeller to Dr. Kissinger. We then talked about the executive privilege statement, and the President expressed his desire to get the statement out well in advance of the Watergate hearings so that it did not appear to be in response to the Watergate hearings. We also discussed Mr. Mollenhoff's interest in the Fitzgerald case, and he asked me to look into the matter for Mr. Mollenhoff. Before departing his office, he again raised the matter that I should report directly to him and not through Haldeman and Ehrlichman. I told him that I thought he should know that I was also involved in the post-June 17th activities regarding the Watergate. I briefly described to him why I thought I had legal problems, and that I had been a conduit for many of the decisions that were made, and therefore could be involved in an obstruction of justice. He would not accept my analysis and did not want me to get into it in any detail other than what I have just related. He reassured me not to worry, that I had no legal problems. I raised this on another occasion with the President when Dick Moore was present. Meeting on March 1st. The first meeting on this date and the afternoon meetings which occurred on March 1st related to preparing the President for his forthcoming press conference. The President asked me a number of questions about the Gray nomination hearings and facts that had come out during the hearings. In particular, I can recall his stating that there should be no problem with the fact that I had received the FBI reports. He said that I was conducting an investigation for him and that it would be perfectly proper for the counsel to the President to have looked at these reports. I did not tell the President that I had not conducted an investigation for him because I assumed he was well aware of this fact and that the so-called Dean investigation was a public relations matter, and that frequently the President made references in press conferences to things that never had, in fact, occurred. I was also aware that often, in answering Watergate questions, that he had made references to my report, and I did not feel that I could tell the President that he could not use my name. There had been considerable adverse publicity stemming from the Gray hearings, and the fact that the Gray was turning over FBI information to the Senate Judiciary Committee, which caused the President to tell me at this morning meeting that Gray must be pulled up short. He told me that he had talked with the Attorney General to tell him to read a chapter in his book, 6 Crises, dealing with the Hiss case regarding the lack of cooperation which Truman and the FBI had given to his investigation. He also told me that the FBI Watergate materials should not be turned over by Gray. I informed him that I had a meeting several days prior with Mr. Sullivan, who had been at the FBI for many years, and Sullivan had alluded to the fact that the FBI had been used for political purposes by past administrations. I cited a few examples that Mr. Sullivan had given me. The President told me to get this information from Sullivan. The President told me that he was reading a book at that time called The 13 Mistakes of Kennedy, and he told me that I should read the chapter regarding Kennedy's use of the FBI. He also told me that I should gather any materials I could gather regarding the uses and abuses of the FBI by past administrations so that we could show that we had not abused the FBI for political purposes. The President told me that he was convinced that he had been wiretapped in 1968, and the fact that DeLoach had not been forthcoming indicated to the President that DeLoach was probably lying. He told me that I should call Don Kendall, DeLoach's employer, and tell him that Deloach had better start telling the truth because the boys are coming out of the woodwork. He said that this ploy may smoke Deloach out. I might add at this point, I never did call Mr. Kendall. He also asked me who else might know about the bugging of his 1968 campaign, and I suggested that Mr. Tolson, Hoover's former assistant, might have some knowledge of it. He told me that he probably ought to call Mr. Tolson and wish him happy birthday or good health and possibly get some information from him when he was talking to him. The discussion then turned back to the Hiss case, and I reminded the President of the strong statement he had made in 1950 regarding Truman's refusal to provide his committee with information, and that speech might be raised at his press conference. He asked me to get a copy of the speech. I returned to his office shortly with a copy of the speech, and he asked me to discuss with him how it could be differentiated from the present situation. During the March 1st afternoon meeting, the President also asked me some questions about executive privilege and the timing of the release of the executive privilege statement, which he had discussed in his press conference on January 31st. I told him that the statement, as far as I was concerned, was ready for release and merely would require the sign-off of a handful of other people. I told him I thought it could be out within a week. It was during the days after this series of March 1st meetings with the President that the name Dean became coming increasingly to the forefront of the Gray confirmation hearings. And the rumblings were that there was going to be a situation where Dean would be called to the committee to testify, and a number of senators were anxious to use me as a vehicle to test executive privilege. On March 4th or 5th, I had a conversation with Ehrlichman, which I might add occurred in the hall of the West Wing, in which he told me that I thought it would be very difficult to maintain a court test on executive privilege over me when in fact I had only met with the President infrequently and had had very few conversations with him that would be protected. It was following this conversation with Ehrlichman that I began meeting and talking with the President at his request with ever-increasing frequency. The presidential meeting of March 16th or 6th.
That's a vote, and as they've put the votes on such a 10-minute basis, I expect the committee better go and vote and hurry back. We'll come back and we'll finish this statement this afternoon.
We're going to finish it this afternoon?
Yeah.
Thus, as John Dean reveals more details of the White House strategy in dealing with the Senate Watergate Committee, the committee has recessed for another floor vote. When they return, Dean will continue to chronicle his conversations with the President. Public television's coverage of the Senate hearings will resume after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
If you've stayed up this long, you'll probably find the hour that follows now the most interesting and rewarding of the whole evening. John Dean is about to resume his version of the cover-up activities, including his talks with President Nixon.
Committee will resume. Have another vote?
But we ought to proceed. Something. One senator being here.
Trouble of it is, it's good to say short time on a vote, you know, you're going to miss it.
One senator started.
Shall we go back? If you want to
We have so much to go.
ahead, I can hear. Okay, fine.
All right. I said what? Mr. Dean, you can proceed. Senator Weicker is here making up the forum or the quorum as required by our rules.
Thank you. The meeting with the President on March 6th. This meeting was brief and a general discussion of the status of the Gray hearings, and the President reminded me again that I should report directly to him and not involve Haldeman and Ehrlichman with regard to Watergate matters. The meeting on March 7th. The President was very unhappy with Gray's performance before the Senate Judiciary Committee. In my meeting with him on this date, he made a reference to the fact that Gray's comment regarding my sitting in on the investigations by the FBI was absurd. He felt it was perfectly proper that I was present at those interviews, and said that Gray's attitude that he, quote, jolly well, end quote, went forward because he had no alternative was absurd. I also discussed with the President the fact that Ziegler was considering endorsing the ACLU letter to the Judiciary Committee regarding the turning over of FBI materials. The President thought that that was a good idea. At the end of the meeting, the President instructed me to tell the Attorney General to cut off Gray from turning over any further Watergate reports to the Senate Judiciary Committee. He said this just had to cease. The meeting of March 8th. I had a very brief meeting with the President on this date, during which he asked me if something had been done to stop Gray from turning over the FBI materials to the Senate Judiciary Committee. I told him that I thought the matter had been taken care of by the Attorney General. Phone conversation of March 10th. The President called me to tell me that he felt we should get the executive privilege statement out immediately, that this should be done before I was called before the Senate Judiciary Committee in connection with the Gray hearings, so that it would not appear that the statement on executive privilege was in response to the action by the Senate Committee. Meeting on March 13th. This was a rather lengthy meeting, the bulk of which was taken up by a discussion about the Gray hearings and the fact that the Senate Judiciary Committee had voted to invite me to appear in connection with Gray's nomination. It was at this time we discussed the potential of litigating the matter of executive privilege and thereby preventing anybody from going before any Senate committee until the matter was resolved. The President liked the idea very much, particularly when I mentioned to him that it might be possible that he could also claim attorney-client privilege on me, so that the strongest potential case on executive privilege would probably rest on the counsel of the President. I told him that obviously this area would have to be researched. He told me he did not want Haldeman and Ehrlichman to go before the Irvin hearings, and that if we were litigating the matter on Dean, that no one would have to appear. Toward the end of the conversation, we got into a discussion of Watergate matters specifically. I told the President about the fact that there were money demands being made by the 7 convicted defendants, and that the sentencing of these individuals was not far off. It was during this conversation that Haldeman came into the office. After this brief interruption by Haldeman's coming in, but while he was still there, I told the President about the fact that there was no money to pay these individuals to meet their demands. He asked me how much it would cost. I told him I could only make an estimate that it might be as high as $1 million or more. He told me that that was no problem. He also looked over at Haldeman and repeated the same statement. He then asked me who was demanding this money, and I told him it was principally coming from Hunt through his attorney. The President then referred to the fact that Hunt had been promised executive clemency. He said that he had discussed this matter with Ehrlichman, and contrary to instructions that Ehrlichman had given Colson not to talk to the President about it, that Colson had also discussed it with him later. He expressed some annoyance at the fact that Colson had also discussed this matter with him. The conversation then turned back to a question from the President regarding the money that was being paid the defendants. He asked me how this was done. I told him I didn't know much about it, other than the fact that the money was laundered so it could not be traced, and then there were secret deliveries. I told him I was learning about things I had never known before, but the next time I would certainly be more knowledgeable. This comment got a laugh out of Haldeman. The meeting ended on this note, and there was no further discussion of the matter, and it was left hanging just as I have described it. The meeting on March 14th. The meetings which occurred on this day principally involved preparing the President for a forthcoming press conference. I recall talking about executive privilege and making Dean a test case in the courts on executive privilege. The President said that if he would like very much to do this, and if the opportunity came up in the press conference, he would probably so respond. I also recall that during the meetings which occurred on this day, that the President was going to try to find an answer that would get Ziegler off the hook of the frequent questions asked him regarding the Watergate. He said that he was going to say that he would take no further questions on the Watergate until the completion of the Irvin hearings, and that Ziegler, in turn, could repeat the same statement and avoid further interrogation by the press on the subject. Meeting on March 15th. It was late in the afternoon, after the President's press conference, that he asked Dick Moore and I to come over to visit with him. He was in a very relaxed mood and entered into a general discussion about the press conference. The President was amazed and distressed that the press had paid so little attention to the fact that he had made a historic announcement about Ambassador Bruce opening up the liaison office in Peking. He said he was amazed when the first question following that announcement was regarding whether or not Dean would appear before the Senate Judiciary Committee in connection with the Gray hearings. The conversation then rambled into a discussion of the Hiss case, and Mr. Moore discussed his memory of the President's handling of the case. Meeting on March 16th. This meeting was a discussion with Ziegler on how to follow up on a number of matters that had arisen in the press conference the preceding day. Meeting on March 17th. This was St. Patrick's Day, and the President was in a very good mood and very relaxed, and we engaged in a rambling conversation with only some brief references to the Gray hearings and the problems that were then confronting the White House regarding the President's statement on executive privilege and his willingness to go to court on the matter. He opined that he did not think the Senate would be dumb enough to go for the bait that he had given them, but he was hopeful that they might. Meeting on March 19th. As best I recall this meeting, it was a rather rambling discussion regarding media problems in connection with the Gray hearings. As the discussion proceeded, I suggested that Mr. Moore might like to engage in this conversation with us. There was some discussion of Senator Irvin's appearance the preceding Sunday on Face the Nation, and whether or not it would be appropriate for me to respond to some of the points that were being made regarding my requested appearance before the Senate Judiciary Committee. I told the President that I would work with Dick Moore in preparing a draft response. Meetings on March 20th. The President had called me earlier that morning to tell me that I should work up a draft letter of response as a result of the discussions we'd had the preceding evening with Moore. I told him I was drafting a letter, and he told me, as soon as I had the letter prepared, that I should arrange to meet with him. Shortly after lunch, I took over a draft copy of the letter, which I had developed with Mr. Moore, and submitted a copy of that draft letter to the made by the 7 convicted defendants, and that the sentencing of these individuals was not far off. It was during this conversation that Haldeman came into the office. After this brief interruption by Haldeman's coming in, but while he was still there, I told the President about the fact that there was no money to pay these individuals to meet their demands. He asked me how much it would cost. I told him I could only make an estimate that it might be as high as $1 million or more. He told me that that was no problem. He also looked over at Haldeman and repeated the same statement. He then asked me who was demanding this money, and I told him it was principally coming from Hunt through his attorney. The President then referred to the fact that Hunt had been promised executive clemency. He said that he had discussed this matter with Ehrlichman, and contrary to instructions that Ehrlichman had given Colson not to talk to the President about it, that Colson had also discussed it with him later. He expressed some annoyance at the fact that Colson had also discussed this matter with him. The conversation then turned back to a question from the President regarding the money that was being paid the defendants. He asked me how this was done. I told him I didn't know much about it, other than the fact that the money was laundered so it could not be traced, and then there were secret deliveries. I told him I was learning about things I had never known before, but the next time I would certainly be more knowledgeable. This comment got a laugh out of Haldeman. The meeting ended on this note, and there was no further discussion of the matter, and it was left hanging just as I have described it. The meeting on March 14th. The meetings which occurred on this day principally involved preparing the President for a forthcoming press conference. I recall talking about executive privilege and making Dean a test case in the courts on executive privilege. The President said that if he would like very much to do this, and if the opportunity came up in the press conference, he would probably so respond. I also recall that during the meetings which occurred on this day, that the President was going to try to find an answer that would get Ziegler off the hook of the frequent questions asked him regarding the Watergate. He said that he was going to say that he would take no further questions on the Watergate until the completion of the Irvin hearings, and that Ziegler, in turn, could repeat the same statement and avoid further interrogation by the press on the subject. Meeting on March 15th. It was late in the afternoon, after the President's press conference, that he asked Dick Moore and I to come over to visit with him. He was in a very relaxed mood and entered into a general discussion about the press conference. The President was amazed and distressed that the press had paid so little attention to the fact that he had made a historic announcement about Ambassador Bruce opening up the liaison office in Peking. He said he was amazed when the first question following that announcement was regarding whether or not Dean would appear before the Senate Judiciary Committee in connection with the Gray hearings. The conversation then rambled into a discussion of the Hiss case, and Mr. Moore discussed his memory of the President's handling of the case. Meeting on March 16th. This meeting was a discussion with Ziegler on how to follow up on a number of matters that had arisen in the press conference the preceding day. Meeting on March 17th. This was St. Patrick's Day, and the President was in a very good mood and very relaxed, and we engaged in a rambling conversation with only some brief references to the Gray hearings and the problems that were then confronting the White House regarding the President's statement on executive privilege and his willingness to go to court on the matter. He opined that he did not think the Senate would be dumb enough to go for the bait that he had given them, but he was hopeful that they might. Meeting on March 19th. As best I recall this meeting, it was a rather rambling discussion regarding media problems in connection with the Gray hearings. As the discussion proceeded, I suggested that Mr. Moore might like to engage in this conversation with us. There was some discussion of Senator Ervin's appearance the preceding Sunday on Face the Nation, and whether or not it would be appropriate for me to respond to some of the points that were being made regarding my requested appearance before the Senate Judiciary Committee. I told the President that I would work with Dick Moore in preparing a draft response. Meetings on March 20th. The President had called me earlier that morning to tell me that I should work up a draft letter of response as a result of the discussions we'd had the preceding evening with Moore. I told him I was drafting a letter, and he told me, as soon as I had the letter prepared, that I should arrange to meet with him. Shortly after lunch, I took over a draft copy of the letter, which I had developed with Mr. Moore, and submitted a copy of that draft letter to the committee. The President read the draft, and we discussed it. There was no resolution of the problem. He told me to talk with Ziegler. I told him that if I did this as a sworn statement, that I was going to obviously redraft very carefully before I signed any affidavit on the letter. It was during the afternoon of March 20th that I talked again with Dick Moore about the entire cover-up. I told Moore that there were new and more threatening demands for support money. I told him that Hunt had sent a message to me through Paul O'Brien that he wanted $72,000 for living expenses and $50,000 for attorney's fees, and if he did not receive it that week, he would reconsider his options and have a lot to say about the seamy things he had done for Ehrlichman while at the White House. I told Moore that I had about reached the end of the line and was now in a position to deal with the President to end the cover-up. I did not discuss with Moore the fact that I had discussed money and clemency with the President earlier, but I told him that I really didn't think the President understood all of the facts involved in Watergate, and particularly the implications of those facts. I told him that the matter was continually compounding itself, and I felt that I had to lay the facts out for the President as well as the implication of those facts. Moore encouraged me to do so. Phone conversation from the President on March 20th. When the President called me and we had a rather rambling discussion, I told him at the conclusion of the conversation that evening that I wanted to talk with him as soon as possible about the Watergate matter because I did not think he fully realized all the facts and the implications of those facts for the people at the White House as well as himself. He said that I should meet with him the next morning about 10 o'clock. Before going to tell the President some of these things, I decided I should call Haldeman because I knew that his name would come up in the matter. I called Haldeman and told him what I was going to do, and Haldeman agreed that I should proceed to so inform the President of the situation. Meeting of March 21st. As I have indicated, my purpose in requesting this meeting, particularly with the President, was that I felt it necessary that I give him a full report of all the facts that I knew and explain to him what I believed to be the implications of those facts. It was my particular concern with the fact that the President did not seem to understand the implications of what was going on. For example, when I had earlier told him that I thought I was involved in an obstruction of justice situation, he had argued with me to the contrary after I'd explained it to him. Also, when the matter of money demands had come up, previously he had very nonchalantly told me that that was no problem. I did not know if he realized that he himself could be getting involved in an obstruction of justice by having promised clemency to Hunt. What I had hoped to do in this conversation was to have the President tell me we had to end the matter now. Accordingly, I gave considerable thought to how I would present this situation to the President and try to make as dramatic a presentation as I could to tell him how serious I thought the situation was that the cover-up continue. I began by telling the President that there was a cancer growing on the presidency, and if the cancer was not removed, the President himself would be killed by it. I also told him that it was important that this cancer be removed immediately because it was growing more deadly every day. I then gave him what I told him would be a broad overview of the situation, and I would come back and fill in details and answer any questions he might have about the matter. I proceeded to tell him how the matter had commenced in late January, early February, but that I did not know how the plans had been finally approved. I told him that I had informed Haldeman what was occurring, and Haldeman told me that I should have nothing to do with it. I told him that I had learned that there had been pressure from Colson on Magruder, but I did not have all the facts as to the degree of the pressure. I told him I did not know if Mitchell had approved the plans, but I had been told that Mitchell had been a recipient of wiretap information and that Haldeman had also received some information through Strawn. I then proceeded to tell him some of the highlights that had occurred during the cover-up. I told him that Kalmbach had been used to raise funds to pay these 7 individuals for their silence at the instructions of Ehrlichman, Haldeman, Mitchell, and I had been the conveyor of this instruction to Kalmbach. I told him that after the decision had been made that Magruder was to remain at the re-election committee, I had assisted Magruder in preparing his false story for presentation to the grand jury. I told him that cash that had been at the White House had been funneled back to the Re-Election Committee for the purpose of paying the 7 individuals to remain silent. I then proceeded to tell him that perjury had been committed, and for this cover-up to continue would require more perjury and more money. I told him that the demands of the convicted individuals continually increasing, and that with sentencing imminent, the demands had become specific. I told him that on Monday, the 19th, I had received a message from one of the Re-Election Committee lawyers who had spoken directly with Hunt, and that Hunt had sent a message to me demanding money. I then explained to him that the message that Hunt had told O'Brien the preceding Friday to be passed on to me. I told the President I'd ask O'Brien why to Dean, and O'Brien had asked Hunt the same question. But Hunt had merely said, "You just passed this message on to Dean." The message was that Hunt wanted $72,000 for living expenses and $50,000 for attorney's fees, and if he did not get the money and get it quickly, that he would have a lot of seamy things to say about what he'd done for John Ehrlichman while he was at the White House. If he did not receive the money, he would have to reconsider his options. I informed the President that I had passed this message to both Haldeman and Ehrlichman. Ehrlichman asked me if I had discussed the matter with Mitchell. I had told Ehrlichman that I had not done so, and Ehrlichman asked me to do so. I told the President I had called Mitchell pursuant to Ehrlichman's request, but I had no idea of what was happening regarding the request. I then told the President that this was just typical of the type of blackmail that the White House would continue to be subjected to, and I did not know how to deal with it. I also told the President that I thought that I would, as a result of my name coming out during the Gray hearings, be called before the grand jury, and if I was called to testify before the grand jury or the Senate committee, I would have to tell the facts the way I knew them. I said I did not know if executive privilege would be applicable to any appearances I might have before the grand jury. I concluded by saying that this is going to take continued perjury and continued support of these individuals to perpetuate the cover-up, and that I did not believe it was possible to so continue it. Rather, I thought it was time for surgery of the cancer itself, and that all of those involved must stand up and account for themselves, and that the President himself get out in front of this matter. I told the President that I did not believe that all 7 defendants would maintain their silence forever. In fact, I thought that one or more would very likely break rank. After I finished, I realized I had not really made the President understand, because he asked me a few questions, and he discussed that it would be an excellent idea if I gave some sort of briefing to the Cabinet, and that he was very impressed with my knowledge of the circumstances, but not seemed particularly concerned with their implications. It was after my presentation to the President, and during our subsequent conversation, the President called Haldeman into the office, and the President suggested that we have a meeting with Mitchell, Haldeman, and Ehrlichman to discuss how to deal with the situation. What emerged from that discussion after Haldeman came into the office was that John Mitchell should account for himself for the pre-June 17th activities, and the President did not seem concerned about the activities which had occurred after June 17th. After I departed the President's office, I subsequently went to a meeting with Haldeman and Ehrlichman to discuss the matter further. The sum and substance of that discussion was the way to handle this now was for Mitchell to step forward, and if Mitchell were to step forward, we might not be confronted with the activities of those involved in the White House in the cover-up. Accordingly, Haldeman, as I recall, called Mitchell and asked him to come down the next day for a meeting with the President on the Watergate matter. In the late afternoon of March 21st, Haldeman and Ehrlichman and I had a second meeting with the President. Before entering this meeting, I had a brief discussion in the President's outer office of the Executive Office Building Suite with Haldeman, in which I told him that we now had 2 options. One is that this thing goes all the way and deals with both pre- and post activities, or the second alternative, if the cover-up was to proceed, we would have to draw the wagons around in a circle around the White House, and the White House protect itself. I told Haldeman that it had been the White House assistance to the Re-Election Committee that had gotten us into much of this problem, and now the only hope would be to protect ourselves from further involvement. The meeting with the President that afternoon with Haldeman, Ehrlichman, and myself was a tremendous disappointment to me, because it was quite clear that the cover-up, as far as the White House was concerned, was going to continue. I recall that while Haldeman, Ehrlichman, and I were sitting at a small table in front of the President in his executive office building office, that I, for the first time, said in front of the President that I thought that Haldeman, Ehrlichman, and Dean were all indictable for obstruction of justice. And that was the reason I was disagreeing with all that was being discussed at that point in time. I could tell that both Haldeman and particularly Ehrlichman were very unhappy with my comment. I had let them very clearly know that I was not going to participate in the matter any further, and I thought it was time that everybody start thinking about telling the truth. I again repeated to them that I did not think it was possible to perpetuate the cover-up, and the important thing now was to get the President out in front. Meeting on March 22nd. The arrangements had been made to have a meeting after lunch with the President with Ehrlichman, Haldeman, Mitchell, and myself. Mr. Mitchell came to Washington that morning for a meeting in Haldeman's office in which Ehrlichman, Mitchell, Haldeman, and myself were present. I recall that one of the first things that Ehrlichman asked Mitchell was whether Hunt's money problem had been taken care of. Mitchell said that he didn't think it was a problem any further. There then followed a general discussion of the status of the Senate hearings, and the discussion never got down to specifics. It had been my impression that Haldeman and Ehrlichman were going to try to get Mitchell to come forward and explain his involvement in the matter. This did not occur. Mitchell said that he thought that everything was going along very well with the exception of the posture of the President on executive privilege. He said that he felt that the President was going to have to back down somewhat, or it would appear he was preventing information from coming out of the White House. I recall that Ehrlichman left the meeting before it had terminated because he was going to meet Secretary Schultz, who was coming in from out of the country. I also recall I was also called out of the meeting about noontime when a message was sent to me by Mr. Ziegler that it was important he see me immediately. This had to do with a statement that was running on the wires that Gray had said that I had probably lied, and Ziegler wanted to know how to handle it. Accordingly, I departed the meeting and went to a meeting with Ziegler and Moore to discuss Gray's comment. I returned to Haldeman's office where Mitchell, Haldeman, and I had lunch. During lunch, there was some continued conversation about the general problems. Mr. Mitchell raised the fact that F. Lee Bailey, who had been very helpful in dealing with McCord, had a problem that he would like to bring up. He said that Mr. Bailey had a client who had an enormous amount of gold in his possession, who would like to make an arrangement with the government whereby the gold could be turned over to the government without the individual being prosecuted for holding the gold. Mitchell was addressing his request for assistance to Haldeman, but Haldeman was non-responsive and the matter was dropped. I again departed Mr. Haldeman's office to have further dealings with Mr. Moore and Mr. Ziegler, and Haldeman told me that there would be a meeting in the President's Executive Office building office about 1:30, and I should come directly from Ziegler's office when I got my problem worked out regarding Gray's statement. I arrived about 1:30 in the President's office, but the President was not ready to hold the meeting yet. The meeting with the President, Ehrlichman, Haldeman, and Mitchell, and me was again a general discussion of the Senate Watergate hearing situation and did not accomplish anything. Rather, it was a further indication that there would be no effort to stop the cover-up from continuing. I recall that Mitchell told the President that he felt that the only problem he now had was the fact that he was taking a public beating on his posture on executive privilege, that the statement on executive privilege was too broad and probably something should be done to change his posture on the matter. Mitchell was not suggesting that members of the White House staff go to the Hill to testify, rather that some more cooperative position be developed to avoid adverse publicity. It was at this time that the President said that Kleindienst was supposed to be working these things out with Senator Baker, and he apparently had not been doing so. The President said that Timmons had told him that a member of Senator Baker's staff was very desirous of a meeting to get guidance. It was at this point that the President called the Attorney General and told him that he should get up to meet with Senator Baker as soon as possible and get some of these problems regarding the executive privilege and the turning of documents over resolved with the committee immediately. After the conversation with the Attorney General, there was a continuing discussion on how to deal with the Irvin Committee. I asked the President to excuse me from the meeting for a moment because I was working with Ziegler on a response to the statement that Gray had made. The President asked me what that was about, and I then explained to him about Gray's statement. I told him what Gray had said and also told him what the facts were. He excused me to use the telephone in his office and said I should get that resolved as quickly as possible. When I returned to the conversation with the President, Mitchell, Haldeman, and Ehrlichman, they were still talking about dealing with the Irvin Committee. The President told me that the White House should start directly dealing with the committee and that I should go up and commence discussions with Senator Irvin as to the parameters of executive privilege. I told the President I did not think it would be wise because I was very much a party in issue with regard to the Judiciary Committee hearings. It would be very unwise for me to go to the Hill and negotiate my own situation. The President agreed, and Ehrlichman said that he would commence discussions. The meeting was almost exclusively on the subject of how the White House should posture itself vis-a-vis the Irvin Committee hearings. There was absolutely no indication of any changed attitude, and it was like one of many, many meetings I had been in before, in which the talk was of strategies for dealing with the hearings rather than any effort to get the truth out as to what had happened before June 17th and after June 17th. Following this meeting with the President, it was apparent to me that I had failed in turning the President around on this subject, but Ehrlichman and Haldeman began taking over with regard to dealing with a new problem, which had become John Dean, as they were aware of the fact that I was very unhappy about the situation. On Friday morning, March 23rd, my house was surrounded by camera crews as a result of Gray's statement the day before that I had probably lied. Accordingly, I decided to wait until the camera crews departed before going to the office. It was mid-morning when Paul O'Brien called to tell me about Judge Sirica's reading McCord's letter in open court. O'Brien gave me the high points of the letter, as they had been reported to him by someone from the courthouse. He also told me that McCord had only hearsay knowledge. I then called Ehrlichman to tell him about it. He said he had a copy of the letter and read it to me. I asked him how he'd received a copy of the letter so quickly. He responded, "It just came floating into my office." He asked me what I thought about it, and I told him that I wasn't surprised at all, and repeated to him what O'Brien had told me, that McCord probably had only hearsay knowledge. He asked me if I was in my office, and I informed him that I was a prisoner of the press and would be in shortly. After my conversation with Ehrlichman, the President called. Referring to our meeting on March 21st and the McCord letter, he said, "Well, John, you were right in your prediction." He then suggested I go up to Camp David and analyze the situation. He did not instruct me to write a report. Rather, he said, "Go to Camp David, take your wife, and get some relaxation." He then alluded to the fact that he'd been under... All right.
Desist, because I got just about less than 5 minutes to get over there. This is good training for...
The committee has been working against the clock to get Dean's prepared testimony completed today. The problem this afternoon has been roll call votes on the Senate floor. Senator Irvin left a vote at this point, confusing Dean, who thought a recess was called. However, other senators continued to run the hearing.
Here he is.
Mr. Dean, we're not trying to hurry you along, but I stayed on the floor of the Senate until this roll call began because in the last short roll call votes, Senator Weicker, I believe, missed a vote, I missed a vote, and one or two others did. So we're trying to interchange. In the interest of time, if you don't mind, you might continue now.
Thank you, Senator. He then alluded to the fact that I'd been under some rather intense public pressure lately, but that he'd been through this all of his life, and you can't let it get to you. He said that he was able to do his best thinking at Camp David, and I should get some rest and then assess where we are and where we go from here and report back to him. I told him I would go. My wife and I arrived at Camp David in mid-afternoon. As we entered the cabin in which we were staying, the phone was ringing. The operator said it was the President calling, but Haldeman came on the phone. Haldeman said that while I was there, I should spend some time writing a report on everything I knew about the Watergate. I said I would do so. I asked him if it was for internal use or public use. He said that would be decided later. I spent the rest of the day and the next day thinking about this entire matter. I reached the conclusion, based on earlier conversations I'd had with Ehrlichman, that he would never admit to his involvement in the cover-up. I didn't know about Haldeman, but I assumed that he would not because he would believe a higher duty to protect the president. The more I thought about it, the more I realized I should step forward because there was no way this situation was going to get better, rather it could only get worse. My most difficult problem was how to end this mess without mortally wounding the president. I had no answer because I felt that once I came forward, the matter would be for the American people to decide and not for me to decide. I finally concluded that I would have to think of some way for the president to get out in front of this matter despite what happened to everybody else. I called Mr. Moore and talked with him about it. We talked about a presidential speech where the president would really lay the facts out. We talked about immunity for everyone involved. We talked about a special Warren-type commission that would put the facts out. We talked about some half measures that might satisfy the public interest. But we both realized that nothing less than the truth would sell. As I mentioned earlier, Moore and I had talked about some of these concepts on previous occasions, but we still did not have an answer that would bring the full truth out because of the criminal implications of the behavior of those involved. On Saturday, I began reconstructing all I knew and began writing a report. I spent Saturday afternoon and evening, Sunday and Monday reconstructing and writing. On Monday, I asked my secretary to come to Camp David, bring certain documents that I had requested, and commence typing. I did not realize how difficult it would be to reconstruct my knowledge from memory. I had not kept a diary or even a calendar of all my activities. Thus, I have been reconstructing my knowledge of this matter since March 23rd to this day. On Sunday evening, March 25th, I was informed that the LA Times and the Washington Post were going to print a story that Magruder and I had prior knowledge of the June 17th bugging of the Democratic National Committee. I considered the story libelous then, as I do today. Upon learning that the story was going to be printed, I contacted an attorney, Mr. Tom Hogan, who was familiar with libel law. We discussed the matter. He then decided to put the newspapers on notice to preserve a libel suit in the event they printed the story. I also told Mr. Hogan that when I returned from Camp David, that I wanted to talk with him about the entire matter and ask him to think about someone who was a good criminal lawyer because I was planning to take certain steps in the near future. I might add that it was my thinking at that time that I would explain all the facts to a knowledgeable criminal lawyer to determine the potential problems of everyone involved, from the president on down, to get independent advice on what I should do. On Monday morning, March 26th, I had a conversation with Haldeman about the story in the LA Times. I told him I was prepared to file a libel suit and had retained a lawyer to put the newspapers on notice. I told him that he knew that I had not known of the June 17th Watergate break-in in advance, that my knowledge of the entire matter ended with the second meeting in Mitchell's office. I told Haldeman that Magruder knew that I had no prior knowledge, but I didn't know if he would admit it public. Haldeman concurred in the fact that I had no prior knowledge and suggested I call Magruder and tape his conversation. I did call Magruder, and by using a dictaphone held to the receiver, I recorded the call. I have submitted a transcript of this conversation to the committee, exhibit number 36. The long and short of the conversation was that Magruder acknowledged that newspaper accounts were a bum rap for me because I had not had prior knowledge of the break-in. My secretary arrived at Camp David on Monday afternoon and began typing the report. On Monday night, I had given additional thought to how the president might get out in front of this matter and how we could get everyone involved to speak the truth. I called Moore, who is fairly conservative in his solution to problems, and told him of my idea, which I said was so far out that I thought it might solve the awful problem. I have submitted to the committee, exhibit number 37, a copy of my notes outlining my concept. In brief, the president would create an independent panel that would be investigator, prosecutor, judge, and jury for everyone involved. It would have the power to remove officials from office, levy fines, and impose criminal sanctions. It was designed to give every man a fair and full hearing and proceed in a manner where people would not be tried publicly. Finally, after all the facts were in, the panel would render its judgment on the individuals involved and report to the public. I might note that if the special prosecutor and this committee were merged, made independent, and proceeded in camera, He'll be very close to the concept I had proposed back on March 26th. Moore liked the idea and suggested I call Haldeman, which I did. He was intrigued but not overwhelmed. It was becoming increasingly clear that no one involved was willing to stand up and account for themselves. After I had read the newspaper on Tuesday, March 27th, that the President had called me on Monday morning, March 26th, which he hadn't, and expressed great confidence in me and the fact that I had not had prior knowledge of the break-in at the Democratic National Committee, I decided to attempt to contact Mr. Liddy, who was the one man who could document the fact that we had never talked about his plans following the February 4th meeting in Mitchell's office. I called Paul O'Brien and asked him how I could get in contact with Mr. Maroulis, Mr. Liddy's attorney. O'Brien gave me Maroulis' phone number, but told me I could not reach him until late in the afternoon. I called Mr. Maroulis about 5:30 and asked him if I might get some sort of sworn statement from Liddy regarding my lack of prior knowledge of the break-in at the Democratic National Committee. I told him of the two meetings in Mitchell's office and that Mr. Liddy and I had never talked about his plans after the second meeting. To this day, I'm convinced that if and when Mr. Liddy ever talks, he will tell the truth as he knows it. I was hopeful that he would give me some sort of affidavit attesting to the facts, but his lawyer was concerned about his Fifth Amendment problems. Mr. Maroulis called me back on March 29th, after I had returned from Camp David, after he had talked with Mr. Liddy. I requested O'Brien make a memorandum of the call, as he was with Mr. Maroulis when he made the call. I have submitted to the committee a copy of this document, Exhibit Number 38, in which Maroulis advised me his client could not make such a statement because it might result in a waiver of his Fifth Amendment privileges, that to give such a statement could be detrimental to others, but that Liddy did wish to convey that his reason for not providing such a statement was not because he disagreed with the facts, but because of the advice of counsel. It was the day before I had received this call, March 28th, that Haldeman had called me at Camp David and requested that I return to Washington. He told me that there was a meeting that he was meeting with Mitchell and Magruder, and that they wished to meet with me. I told Haldeman that I really did not wish to meet with Mitchell and Magruder, but he was insistent that I return and meet with them. I returned from Camp David about 3:30 and went directly to Haldeman's office. He told me that Mitchell and Magruder were waiting in another office for me. I asked him why they wanted to talk to me, and he said that they wanted to talk to me about my knowledge of the meetings in Mitchell's office. I told Haldeman that they were both aware of the situation, and I wasn't going to lie if asked about those meetings. Haldeman said that he didn't want to get into it, but I should go in and work it out with Mitchell and Magruder. Before discussing the meeting with Mitchell and Magruder, I feel I should comment on my reaction to the discussion I had just had with Mr. Haldeman. Knowing how freely and openly we had discussed these matters in the past, I could tell that he was backpedaling fast, that he was now in the process of uninvolving himself but keeping others involved. This was a clear sign to me that Mr. Haldeman was not going to come forward and help end this problem. Rather, he was beginning to protect his flanks. It was my reaction to this meeting with Mr. Haldeman and the evident changed attitude and my earlier dealings with Ehrlichman, where he had told me how I should handle various areas of my testimony should I be called before the grand jury, that made me decide not to turn over to them the report I had written at Camp David. I have submitted to the committee a copy of the Camp David report, Exhibit 39, part of which was typed by my secretary at Camp David, and the remainder in longhand, which I had not put in final narrative form because I was called back to Washington. After departing Mr. Haldeman's office, I went to meet Mitchell and Magruder. After an exchange of pleasantries, they told me they wished to talk to me about how I would handle any testimonial appearances regarding the January 27th and February 4th meetings, which had occurred in Mitchell's office. I told them that we had been through this before, and they knew well my understanding of the facts as they had occurred at the time. Mitchell indicated that if I so testified, it could cause problems. Magruder then raised the fact that I had previously agreed in an earlier meeting that I would follow the testimonial approach that they had taken before the grand jury. I told them I recalled the meeting. Magruder then said it had been I who had suggested that the meetings be treated as dealing exclusively with election laws, and that explained my presence. At this point in time, I decided I did not wish to get into a debate regarding that meeting. They both repeated to me that if I testified other than they had, it would only cause problems. I said I understood that. I told them that there was no certainty that I would be called before the grand jury or the Senate committee, and if I were called, I might invoke executive privilege, so the question of my testimony was still moot. I did not want to discuss the subject further, so I tried to move them off of it. They were obviously both disappointed that I was being reluctant in agreeing to continue to perpetuate their earlier testimony. The only other matter of substance that came up during that meeting was when I made the point that I had never asked Mitchell about his involvement in the matter, and I had no intention of asking him at that time. I said to this day, I do not fully understand how the Liddy plan got into operation, can only speculate based on the tidbits of information I know. I then offered my hypothesis of what had happened. That is, that at some point after the second meeting in Mitchell's office, there had been pressure put on to get the plan approved that had been approved without anyone really understanding its full import. Mitchell said something to the effect that my theory was not far from wrong, only they thought it would be 3 or 4 times removed from the committee. The meeting terminated shortly thereafter. It was not a lengthy meeting, and as far as Magruder and Mitchell were concerned, it was certainly less than satisfactory for them. On either March 28th or 29th, Mr. Krogh came to my office because he happened to be in the executive office building. He said he had come to express sympathy for me as a result of the adverse publicity I had received during the Gray hearings. He then began telling me that he had not himself had a good day since his own confirmation hearings, and that he had been haunted by his experiences at the White House. I told Krogh that I thought that there was a very likely possibility that the Senate Watergate Committee could stumble into the Ellsberg burglary. I told him that there were documents in the possession of the Justice Department which had been provided by the CIA in connection with the Watergate investigation, which contained pictures of Liddy standing in front of Ellsberg's doctor's office in California. I told him that I had learned from the CIA that the pictures had been left in a camera returned by Hunt to the CIA, and the CIA had developed the pictures. I said I did not believe that the Justice Department knew what the pictures were all about, but that any investigator worth his salt would probably track down the incident as a result of the pictures. I told him that Ehrlichman had requested that I retrieve the documents from the Justice Department and get them back to the CIA where they might be withheld from the committee investigators, but the CIA had been unwilling to do so. Krogh was very distressed to hear this news, but said that maybe it was best in that he had been personally haunted by the incident for so long that he would like to get it out in the open. We then entered into a discussion about the incident, and I asked him if he had received his authorization to proceed with the burglary from Ehrlichman, knowing well that Krogh would not undertake such a mission himself. Krogh responded that no, he said. Krogh responded that no, he did not believe that Ehrlichman had been aware of the incident until shortly after it had occurred. Rather, he had received his orders right out of the Oval Office. I was so surprised to hear that, I said, "You must be kidding." He repeated again that he received his instructions out of the Oval Office. Mr. Krogh also indicated to me that he thought that he might have perjured himself during the confirmation hearings and was very bothered by that. He said that he thought that he had been asked some questions about the Cubans that he probably could have answered, but was afraid to open up the whole area of the plumber's operation, so he did not properly answer the question. He had never really studied his transcript to determine if he had or had not perjured himself, but was concerned about it. I told him there might be a possible solution to his problem if there was some way we could get him immunized on national security basis and get the matter out in the open on that basis, or some sort of procedure that would remedy his plight. I said I did not have anything specific in mind, but it was something that we might talk to Henry Peterson about sometime in the future. Shortly after Krogh left my office, I had a call from Ehrlichman, who told me that Krogh had been in to see him about the matters we had just talked about. He said he was convinced that Krogh had not perjured himself, but he requested that I call Peterson to explore how we might deal with Krogh's situation. I told Ehrlichman that I did not think it was an appropriate time to call right now, but that maybe we could call in the near future, before the Senate committee came across the documents in the Justice Department, at the Justice Department that would unravel the entire matter. I never called Peterson on this matter. Following my meeting with Mitchell and Magruder on March 28th, I realized that I was under pressure from both within the White House and without to either not testify or falsely testify. I had earlier discussed with Ehrlichman that if I was called upon to testify, that I would probably be asked questions about the Dean investigations, my dealings with the FBI, the handlings of the material in Hunt's safe, and the like. I recall testing Ehrlichman's reaction to my testimony and got the result I expected. He asked me, for example, of a problem area. I then told him that I would probably have to explain the delay of turning over materials to the FBI from Hunt's office. I said that the reason that I had delayed was because of his instruction that I deep six and shred the evidence. Ehrlichman told me that he didn't think that I would have to explain the delay that way. Rather, I could say that I was making an inventory. I told him that I had not made an inventory, and he said, well, I'm sure you can think of something. I have mentioned that I received what I considered an indication from Haldeman when I had met with him regarding Magruder and Mitchell's meeting on the 28th, and that he was protecting himself. I also realized that when Ehrlichman called me after the conversation with Krogh, that he was trying to tell me that what Krogh had early told me might not be correct, and I felt that he was somewhat unhappy that Krogh had given me the information he had. By March 29th, Ehrlichman and Haldeman fully realized that I was not playing ball, and in fact could present a serious problem to them. It was also evident to me that they were doing everything they could to protect themselves against my knowledge. I had been in continuous contact since March 25th with my attorney, Thomas Hogan, regarding whom he felt was the best available man in the criminal law field that I might discuss this entire matter with. We had talked on several occasions about Charles Schaffer, whom I met several years ago and regarded highly as a criminal lawyer. On March 28th and 29th, however, I made several other calls to friends to ask them for suggested names of knowledgeable criminal lawyers, but decided on March 30th that I would retain Mr. Schaffer if he were available. Mr. Hogan informed me that he was, and we arranged to meet with him. The President, along with Haldeman and Ehrlichman, were going to be in California for a week or more in connection with President II's, or the meeting, along with the President's meeting with President II of South Vietnam, and I felt that this would give me an opportunity to decide how best I could come forward and end this matter. I decided that I was going to inform the prosecutors of what the case was all about, but before I did so, I felt I should consult with counsel to determine the scope of my own problems. On March 30th, shortly after lunch, I met Mr. Hogan and Mr. Schaffer. I spent 5 hours telling them everything that I could remember and telling them that I was unwilling to continue the cover-up. Mr. Schaffer advised me to avoid further conversations regarding this subject and said that he would like to talk to me again on Monday morning prior to his seeing the prosecutors. Accordingly, we met on Monday morning, April 2nd, and discussed the matter for several hours more. That afternoon, my attorneys went to the government prosecutors and told them that I was willing to come forward with everything I knew about the case. There then followed a number of meetings between my attorneys and the prosecutors and myself, and the prosecutors and myself and the prosecutors, in which we began to unfold everything I knew about the case. From the outset, I was confronted with the problems of executive privilege, attorney-client privilege, and national security. Thus, it was agreed until these problems were resolved that I would exclude matters involving the President from these conversations. I was also uncertain of many of the dates and details of the facts that I had general knowledge of, so I began reconstructing a chronology of the events. As each session progressed, I was able to provide more information, more leads, and more explanations of the interrelationships within the White House and the relationships of persons who were involved. During the period of April 2nd until April 15th, the meetings I had with the prosecutors were initially focusing on the activities which had led up to the June 17th break-in at the Democratic National Committee and all the knowledge I had regarding the events before June 17th. But as our discussions evolved and I began telling them more and more of the cover-up, their interest began to focus more and more in that area. As I began explaining what I knew what I knew, it was evident that the prosecutors had no conception of how extensive the cover-up was, so I tried to provide them with all the details that I could remember. Also, as the conversations regarding the cover-up began getting into more and more specifics, we moved into areas that came closer and closer to the President. But prior to April 15th, I did not discuss any of the areas of presidential involvement. During the time I was having conferences with the government prosecutors, I was avoiding conversations with Mitchell, Ehrlichman, and Holloman as much as I could. However, on several occasions, I did talk with Ehrlichman while he was in California. At one point, he called me to ask me if I had completed my report that I had been working on at Camp David. I told him it was still incomplete. He said that I should send him whatever I had completed. I told him that a section dealing with Segretti's activities, which had been prepared by Dick Moore, but which I had not reviewed myself, was complete as far as I was concerned, and I would send it to him. He said I should send it to California immediately on the DEX machine. He said that Holloman was interested in getting these facts out now because the timing might be right. I sent the report that had been written by Moore, a copy of which I've submitted to the committee, Exhibit number 40. I also had a conversation with Mitchell about Paul O'Brien going out to visit Haldeman in California. Mitchell told me that he wanted O'Brien to go out and visit with Haldeman and that he had worked out the meeting. I felt like telling Mitchell that I thought that when I learned that the meeting had been switched from Haldeman to Ehrlichman, that O'Brien was being set up, that Ehrlichman would probe him on everything he knew about Mitchell, Dean, and anyone else involved. I did not know if this in fact occurred, but knowing that Ehrlichman and Haldeman were very busy protecting their flanks, I would have to believe that it did occur. I have never talked with O'Brien about what did occur during his meeting with Ehrlichman. Ehrlichman also asked me if I knew when I would be called before the grand jury. I told him I did not, but that my lawyers were discussing the matter with the prosecutors. I did not tell him that I had already met with the prosecutors, but he told me that he wanted to know when I was going to be called because he wanted to talk to me before I appeared. I believe that the President returned from California on Sunday, April 8th. I was scheduled to meet with the prosecutors that afternoon. My attorneys had been discussing my testimony with the prosecutors, and they had worked out an arrangement whereby I could give the prosecutors my knowledge directly, and what I told them would not later be used against me if they should prosecute me. I felt that I should tell Haldeman that I was going to meet with the prosecutors personally, so I called him in California on the morning of April 8th before they departed for Washington. I made the call from Mr. Schaffer's office, and when I told him this, he said that I should not meet with the prosecutors because, as he said, once the toothpaste is out of the tube, it's going to be very hard to get it back in. After this comment, I did not tell Haldeman whether I would or would not meet with them, and in fact the meeting went forward. During the meeting, and while the President was flying east, I received a call from Air Force One from Mr. Higbee, who asked me to be in Wisdom's, Ehrlichman's code name, office at a certain time for a meeting. I believe the meeting was set for 4 or 5 o'clock. I departed from the meeting with the prosecutors to go into the White House. I went to Ehrlichman's office. There, I found Ehrlichman and Haldeman, who had just arrived from Andrews Air Force Base, and we chatted for a brief moment about their trip. I raised the fact that I had read in the paper that morning that Colson had taken a lie detector test. I said that I hoped everyone is willing to take such a lie detector test because it will probably be necessary now that Colson has taken a test. They asked me if I had met yet with the prosecutors or knew when I would be called before the grand jury. I avoided a direct answer to the question by saying that my lawyers were still having discussions with the prosecutors about my appearance before the grand jury. I was then asked some questions about testimonial areas, but I gave them evasive answers. Even these evasive answers, which raised matters which related to them, brought forth responses that they did not remember it quite as I did. During the week of April 9th to April 14th, I had several conversations with Ehrlichman and Haldeman, but tried to avoid them as much as possible. I recall some discussions, however, regarding getting Mitchell to step forward. The theory that had been discussed before they went to California was becoming the policy. If Mitchell takes the rap, the public will have a high-level person and be satisfied, and the matter will finally end. I felt during each encounter I had with them that I was very much a problem for them, but they did not want me to know that they felt so. However, after having been involved with them for months on end in this matter, it was very easy for me to recognize the changed attitude, and on occasion they were almost patronizing in dealing with me. On Monday, April 9th, Mitchell called me and told me he was coming to Washington and wanted to meet with me. I informed Ehrlichman and Haldeman of Mitchell's request, and they both wanted me to meet with him. I also discussed this with counsel, and there was some discussion with the government about the meeting. The prosecutors were interested in my taping the conversation, but I told them I thought that was most unfair to do to Mitchell and that I would not go in and set him up. After discussing this further with my attorney and rejecting the suggestion that I record the conversation, I agreed to meet with Mitchell, but I had been instructed by counsel to prepare a memorandum of the meeting as soon as the meeting was over. I agreed to do this, and I have submitted a copy of the memorandum to the committee, Exhibit number 41. The sum and substance of the meeting was that if and when I were called to testify, I would testify fully and honestly. Mitchell said that he understood and did not suggest that I do otherwise. He did, however, believe that my testimony would be very harmful to the President and said that he felt that I should not testify if at all possible. I reported my meeting with Mitchell to Haldeman and Ehrlichman later. There were other discussions that week in which Haldeman and Ehrlichman talked about pinning the entire matter on Mitchell. I listened with some interest because I did not feel that they would succeed at this, and I felt that also they would have to be thinking about how to handle the cover-up activities, and felt that I would undoubtedly be a target for them to pin everything with regard to the cover-up on. As Haldeman and Ehrlichman began to discuss more and more about getting Mitchell to take the blame for authorizing this plan in the first instance, I began to increase my conversations with the prosecutors about the cover-up. The more I told the prosecutors about the cover-up, the more interested they became in it. At this time, Haldeman and Ehrlichman were still unaware of my direct dealings with the prosecutors. On Friday, April 13th, Fred LaRue came to my office to see me. Before he arrived in my office, I again contacted my attorney to advise him that LaRue wanted to see me and asked me what I should do. And I asked him what I should do. He again said that he thought I ought to meet with LaRue, not to get into testimonial areas, but to make a memorandum of the meeting. I have submitted a copy of that memorandum to the committee, Exhibit number 42. When LaRue and I met, LaRue told me he thought he was going to be called before the grand jury shortly, and he wanted to know what I was going to do if I was called. I told him I was going to tell the truth. I told him I did not believe we should talk about testimony because we could be asked that very question in and of itself before the grand jury. LaRue said, "Let me just ask one question." He asked me if I had made any decisions on the money, and I told him that I had not, but I had merely passed messages along and returned messages. He said that he had assumed that to be the case and asked me how I was going to handle the persons above me who were involved. I told him again that I was going to withhold nothing from the grand jury, and if asked, I would respond. Mr. LaRue also said that he needed some legal advice, and I suggested that rather than getting it from me, that he ought to get independent counsel. I liked Fred LaRue very much and felt very sorry for him, realizing that this was probably the last conversation we'd have for some time, and he was in the middle of the matter, not necessarily by his own choice, but by the circumstances he found himself in at the time. The strategy that was now developing was a partial uncovering of the cover-up, that is, to get Mitchell to step forward. On Friday, April 13th, I went to Ehrlichman's office, where Ehrlichman and Haldeman were present and discussing a meeting they had just had with Colson and his attorney, Mr. Shapiro. They informed me that Colson had developed a plan to deal with the matter and that Mitchell should be smoked out. Ehrlichman said that Colson had concluded that obviously Mitchell had signed off on this matter and that he should take the responsibility for it to end this thing. Ehrlichman also said that Colson had some other ideas, including the fact that the Gray hearings had been very damaging to me publicly, and I certainly should not take any position out in front dealing with the Irvin Committee hearings because of this. I might add that Ehrlichman and Haldeman were most cynical about Colson's suggestion and said to me that he was really scrambling to protect himself. After discussing the Colson plan, they told me that Mitchell would be coming down to talk about this entire matter. There was some discussion as to how to smoke Mitchell out. By the week's end, it had been decided that the President would meet with Mitchell and ask him about his knowledge, and hopefully the President would be able to get Mitchell to come forward. I told them I doubted very seriously if Mitchell would say anything to anyone about this matter. While these discussions were going on, the President called Ehrlichman, and they had a brief discussion about the matter. I also recall that at one point in the conversation, Ehrlichman said that he's right here, referring to me. On Saturday, April 14th, I requested my attorney, Mr. Schaffer, to come to my office. I told him that Mitchell was coming down to meet with the President and that there was going to be an effort to smoke him out. I asked him if he had any ideas, as Ehrlichman and Holloman had asked me if I had any ideas. Mr. Schaffer gave me a former prosecutor's answer that what Mitchell needs is a good cross-examination. I told him I did not think it was possible by the President because the President was not the cross-examining type. He also made a couple of other suggestions which would have resulted in the President having to appear before the grand jury if he got any admissions from Mitchell. I passed these suggestions along subsequently to Ehrlichman and Holloman, but they were not viable suggestions. Mr. Schaffer and I then sat down and began reviewing all of the facts that I had related to him. I told him I wanted his opinion based on conversations with the prosecutors and his own knowledge of the criminal law as to who had problems and who could be indicted and who were targets of the grand jury. Mr. Schaffer and I discussed this for a while, and then I prepared a list of who was likely to be indicted as the investigation proceeded. I had guests for lunch, and it was after lunch that I met with Dick Moore. I had a list in front of me and thought that I would see what Moore's reaction to it was because I was planning to take it to Ehrlichman and Holloman later. I showed the list to Dick Moore and told him that it had been prepared based on conversations with my attorney and his knowledge of the involvement of various persons. I told him I felt that everybody on the list was a potential subject of an indictment. When I showed Moore the list, he was quite upset. He said that if indeed that occurred, it would be a tremendous tragedy to this country. He was shaken by the list and the seriousness with which I discussed it with him. But I was very serious in my desire to stop the cover-up with Ehrlichman and Holloman, so I appreciated Moore's reaction. I have submitted a copy of the document I referred to this committee, Exhibit 43. Later that afternoon, I went to Ehrlichman's office where Ehrlichman and Holloman were discussing Mitchell's visit. I learned that Mitchell had met briefly with Ehrlichman, but not with the President. Ehrlichman said that Mitchell was not talking, and certainly that did not surprise me. And I certainly was not surprised that he would not talk with Ehrlichman either. I then pulled the list I had prepared out of my pocket and told them that I had discussed everyone's problem with my lawyers, and my lawyers had had conversations with the prosecutors as well, and I thought that the following persons would be indicted. I then read them the list. I told them that my attorney had learned from the prosecutor, from his discussions with the prosecutors, that not only was Dean a target of the grand jury, but Ehrlichman and Holloman were also very much targets of the grand jury. Ehrlichman said that he had just talked with Kleindienst a few days earlier about the grand jury, and that he had no knowledge, he had no such report from Kleindienst. I said that my lawyer appears to know more than the Attorney General does because I believe he's probably more informed in that he has had direct conversations with the prosecutors. I did not tell them at that point that I had had private meetings with the prosecutors or that I had told the prosecutors of the extent of the involvement of Holloman and Ehrlichman. When this meeting ended, I was quite confident that I had gotten the message through to Ehrlichman and Holloman that they had a serious problem themselves, and I had put them on final notice that I wasn't playing the cover-up game any longer. It was late that night that I realized that indeed my message had gotten through. About 1 o'clock on Saturday night or Sunday morning, I received a call from Mr. Schaffer. He said that the prosecutors had called him and that they were going to have to breach the agreement that they had made regarding keeping all my conversations with them private. The prosecutors had reported to Mr. Schaffer that the Attorney General had called Mr. Peterson and then wanted a full report on everything that was going on before the grand jury and where the grand jury was headed. The meeting with the Attorney General was to occur about 2 o'clock or about 2 a.m. at the Attorney General's home. The prosecutors also reported that the reason they felt they had to breach the agreement was because the Attorney General was being summoned to the President's office the next morning to discuss the entire matter. I told Mr. Schaffer that I had hoped to tell the President personally that I had gone to the prosecutors several weeks ago, but that I had understood why this was occurring, and obviously there was nothing we could do about it now. I told Schaffer that we certainly had gotten the message through to Ehrlichman and Haldeman that they have problems, and that the cover-up may now begin to unravel at last. On Sunday, April 15th, I went to Mr. Schaffer's office for an all-day meeting. I learned during the day that Ehrlichman had been trying to reach me during the better part of the day, but I decided not to return his call. When I returned home about 7:30, the White House operator called me again and said that Ehrlichman had been trying to reach me. I then returned his call. He told me that he was going back to his office to do some work that night, would be in about 8 o'clock, and would like to meet with me very much. I told him I would meet with him. I was quite aware of the reason that Ehrlichman wanted to meet with me was because I was sure that he had learned from the President what was going on as a result of the President's meeting with Kleindienst and Peterson, and the fact that I had been to the prosecutors and had obviously come out. As I had noted earlier, I had not at any time discussed presidential involvement with the prosecutors, so the discussions that Peterson and Kleindienst had with the President obviously focused on the involvement of Haldeman, Ehrlichman, Dean, Mitchell, Magruder, Strawn, and others that I had discussed. After Ehrlichman's call, I called Mr. Schaffer and we discussed the wisdom of the meeting. I told him I did not want to meet with Ehrlichman, and he agreed. Subsequently, I tried to reach Ehrlichman to turn the meeting off, but learned he was already en route to the office. I called Mr. Schaffer back and told him that I thought I ought to meet with the President, and I should call Rosemary Woods and have her give a message to the President. He said that he saw no problem with my talking with the President to tell him why I had gone to the prosecutors. I attempted to reach Rosemary Woods, but she was out of the city. I then wrote out a message for the President and phoned Mr. Higbee and requested that Higbee relate the matter to Haldeman, Ehrlichman, and on to the President. I have submitted a copy to the committee of the message I sent the President at 8:15 Sunday, April 15th, exhibit number 44. In short, I told the President I hoped that he did not interpret my going to the prosecutors as an act of disloyalty, that I did not wish to speak with Ehrlichman at this time, that I would meet with him if he wished to discuss the matter with me, and that I thought that he should get his legal advice from Henry Peterson. Within 45 minutes of sending the message, I had a call from the White House operator informing me that the President wished to meet with me at 9 o'clock. It was shortly after 9 when I arrived at the President's EOB office. As I was driving into the White House, I wondered to myself if the meeting was a setup. By a setup, I mean, was the President going to try to smoke out of me what Ehrlichman and Haldeman had obviously been trying to do and been unable to do, and knowing the fact that I would not play games with the President, that the information would come out. I decided I couldn't worry about that, and I had a duty to explain to the President why I was doing what I had done. The meeting with the President on April 15th. The President was very cordial when we met. I was somewhat shaken when I went in to meet with him because I knew I had taken it upon myself to end the cover-up, and what I had started was going to cause serious problems for the President. I shall attempt to recall the highlights of the conversation that transpired on the meeting which occurred about 9 o'clock on April 15th. I told the President that I had gone to the prosecutors and that I did not believe that this was an act of disloyalty, but rather in the end would be an act of loyalty. I told him I felt this matter had to end. I informed the President that I had told the prosecutors of my own involvement and the involvement of others. At one point in the conversation, I recall the President asking me about Haldeman's knowledge of Liddy's plans. He asked me if I had told him earlier about the fact that I had met with Haldeman after the second meeting in Mitchell's office and told Haldeman what was going on and my reaction to what was going on. I told the President I had reported this fact to him earlier. The President then made some reference to Henry Peterson, asking about why Haldeman had not turned it off at that point and told me to testify that I had told Haldeman about the meeting in Mitchell's office. The President almost from the outset began asking me a number of leading questions, which was somewhat unlike his normal conversational relationships I'd had with him, which made me think that the conversation was being taped and a record was being made to protect himself. Although I became aware of this because of the nature of the conversation, I decided I did not know it for a fact and that I had to believe that the President would not tape such a conversation. Some question came up by the President as to whether I had immunity. As best I can recall, I told him my lawyers had discussed this with the prosecutors, but certainly I had no deal with the government. He told me that he did not want to do anything to hurt my negotiations with the government. I do not recall commenting on his comment regarding that. I also recall that the conversation turned to the matter of Liddy not talking. He said something about Liddy is waiting for a signal, and I told him that possibly he was waiting for a signal from the President. I discussed with him the fact that maybe if Liddy's lawyer met with him, that Liddy would begin to open up, and I said that I thought that it would be very helpful if Liddy did talk. It was during this part of the conversation that the President picked up the telephone and called Henry Peterson and pretended with Peterson that I was not in the room, but that the matter of Liddy's coming forward and talking had arisen during our conversation. The President relayed to Peterson that if Liddy's lawyer wanted to see him to get a signal from the President was willing to do this. The President also asked me about Peterson, and I told him that if anyone could give him good advice, Henry Peterson could. The President also asked me if I remembered what day it was in March that I had reported to him on some of the details of the Watergate matter. He said that he thought it was the 21st, but wasn't certain. I said that I could not recall for certain without checking. At another point in the conversation, the matter of the degree of discussions that I had had with the prosecutors came up, and I informed the President that I had had no discussions with the prosecutors relating to conversations I'd had with him or anything in the area of national security. The President told me that I could not talk about national security areas and I should not talk about conversations I had had with him because they were privileged conversations. Toward the end of the conversation, the President recalled the fact that at one point we had discussed the difficulty in raising money, and that he said that $1 million was nothing to raise to pay to maintain the silence for the defendants. He said that he had, of course, only been joking when he made that comment. As the conversation went on, and it is impossible for me to recall anything other than the high points of it, I became more convinced that the President was seeking to elicit testimony from me and put his perspective on the record and get me to agree to it. The most interesting thing that happened during the conversation was very near the end. He got up out of his chair, went behind the chair to the corner of the executive office building office, and in a nearly audible tone said to me, he was probably foolish to have discussed Hunt's clemency with Colson. I do not recall that I responded. The conversation ended shortly thereafter. As I was on my way out of the office after exchanging parting pleasantries, I told the President that I hoped that my going to the prosecutors and telling the truth would not result in impeachment of the President. He jokingly said, "I certainly hope so also." And he said that it would be handled properly. Meeting with the President on the 16th. I received word on Monday morning, April 16th, that the President had requested I come to the Oval Office. I arrived at his office at 9:45, and rather than going to the reception entrance normally used by other members of the staff and myself, I went into Mr. Steve Bull's office. Mr. Bull is the one who had informed me that the President had wanted to see me, so I went into his office. Mr. Bull told me I would have to wait a few minutes because the President was in another meeting. A few minutes later, Haldeman and Ehrlichman emerged laughing from the President's office, and when they saw me in Mr. Bull's office, their faces dropped. I said hello. They put on a serious look, or they said hello, put on a serious look, and departed. I went into the President's office. The President told me that he'd been thinking about this entire matter and thought it might be good if he had in his drawer a letter from me requesting my resignation, that he accept my resignation, or in the alternative, an indefinite leave of absence. He said that he had prepared 2 letters for my signature and would not do anything with them at this time, but thought it would be good if he had them. He then passed me a manila folder with 2 letters in them. The President said that he had prepared the letters himself and that no one would know I had signed them. I read the letters and was amazed at what I was being asked to sign. I have submitted to the committee copies of the letters, exhibit number 45, but since they are very brief, I'll read them. The first letter, dated April 16th, read, "Dear Mr. President, in view of my increasing involvement in the Watergate matter, my impending appearance before the grand jury and the probability of its actions, I request immediate and indefinite leave of absence from my position on your staff." The second letter, which was even more incriminating, read, "Dear Mr. President, as a result of my involvement in the Watergate matter, which we discussed last night and today, I tender you my resignation effective at once." After reading the letters, I looked the President squarely in the eyes and told him I could not sign the letters. He was annoyed with me and somewhat at a loss for words. He said that maybe I would like to draft my own letter. I told him that the letters that he had asked me to sign were virtual confessions of anything regarding the Watergate. I also asked him if Ehrlichman and Haldeman had signed letters of resignation. I recall that he was somewhat surprised at my asking this and said that no, he said that they had not, but they had given him verbal assurances to the same effect. He then elaborated that Haldeman and Ehrlichman had said that if they were called before the grand jury, they would seek an indefinite leave of absence. They had given him their verbal assurance. I then told the President that he had my verbal assurance to the same effect. It was a very tense conversation, but I was not going to sign a letter under any circumstances. As I sat there talking with the President, I had very much on my mind the laughter in Ehrlichman and Haldeman's voices when they walked out of the office before they realized that I was waiting outside to see the President. To break the impasse, the President said that he would like me to draft my own letter and report back to him later. He said that he was working on a statement regarding the Watergate and the recent developments that had come to his attention as a result of his meetings with Kleindienst and Peterson, and would appreciate my thoughts. He said that he would also like a suggested draft letter for Haldeman and Ehrlichman, or maybe a form letter that everyone could sign. I told him I would draft a letter and would report back. The President called me to come to his executive building office about 4 o'clock that afternoon. He asked me if I had drafted a letter. I said I had, as well as I had prepared some thoughts for his statement. He asked to see the letter, a copy of which I've submitted to the committee, exhibit number 46, but again shall read because it's very brief. Dear Mr. President, you have informed me that Bob Haldeman and John Ehrlichman have verbally tendered their request to be given an immediate and indefinite leave of absence from your staff. By this letter, I also wish to confirm my request that I be given such a leave of absence from your staff. After the President read the letter, he handed it back to me and said that it wasn't what he wanted. I then told him...
Audience, to please refrain from laughter.
I then told him that I would not resign unless Haldeman and Ehrlichman resigned. I told him that I was not willing to be the White House scapegoat for the Watergate. He said that he understood my position and he wasn't asking me to be a scapegoat. I then gave him my recommendations of a draft statement. Before he read the draft statement, he said that he had checked his records, and it had been on March 21st that I had met with him and given him the report on the problems of the Watergate and its cover-up. I have submitted to the committee, exhibit number 47, a copy of the draft statement I prepared for the President. The gist of the statement was twofold. First, the President had learned of new facts in the case over the weekend as a result of this information coming to his staff, and had directed Henry Peterson to take charge and leave no stone unturned. Secondly, that he had accepted requests from Haldeman, Ehrlichman, and Dean to be placed on leave of absence. The President said virtually nothing about the statement, and after reading it, told me to talk to Len Garment, who he said was also preparing a draft statement. After departing from the President's office, I called Mr. Garment and told him that the President had requested I give him my input on a draft he was developing. Mr. Garment said he would come by my office, which he did. I gave him a copy of the draft statement, and he told me that he and I were thinking along similar lines, that is, that Haldeman, Ehrlichman, and Dean had to resign. I told him I was ready and willing, but only if Haldeman and Ehrlichman resigned as well. The next time I heard anything about the draft statement was on April 17th, when the President called and informed me that he had decided not to request any resignations until after the grand jury took action, and he would issue a statement very shortly. That statement on April 17th is a matter of public record. I would only like to point out one or two items about the statement. The President said on March 21st, as a result of serious charges which came to his attention, some of which were publicly reported, he began an intense new inquiry into the whole matter. I would merely refer the committee's attention back to my earlier statement as to what the President did after my report to him on March 21st as to the White House's deep involvement in the cover-up. In short, the President commenced no investigation at all. Rather, the President, Haldeman, and Ehrlichman commenced to protect themselves against unraveling the cover-up. Secondly, I would also like to raise the paragraph that had been put in the statement that no one in a position of major importance in the administration should be given immunity from prosecution. While the statement went virtually unnoticed in the public, it was very evident to me what the President was saying. Dean will not be a witness against anyone, so the government might as well stop dealing with him. On Monday night, April 16th, I learned that the President had informed the government that he allegedly had taped a conversation in which I had told him I was seeking immunity from the government in exchange for testimony on Haldeman and Ehrlichman. I have no recollection of ever telling the President that. I was so negotiating with the government, and the President told me very specifically that he did not want to do anything to interfere with any negotiations I was having with the government. When I learned this from my attorney, I suggested that he request that the government call for the tape and listen to the tape, because I told him it must be a reference to a meeting I'd had with the President on April 15th. And if the conversation were taped, the government would have a pretty good idea of the dimensions of the case it was dealing with. I was referring to the fact that the President had mentioned the $1 million conversation and the fact that he had talked to Colson about clemency for Hunt. I do not, in fact, know if such a tape exists, but if it does exist and has not been tampered with and is a complete transcript of the entire conversation that took place in the President's office, I think this committee should have that tape, because I believe it would corroborate many of the things that this committee has asked me to testify about. When the President issued his statement on April 17th, in which he was quite obviously trying to affect any decisions I was having with the government regarding my testimony by inserting the phrase there regarding no immunity, and combined with the fact that he had requested that I sign a virtual confession on Monday of that week, I decided that indeed I was being set up, and it was time that I let the word out that I would not be a scapegoat. Accordingly, on April 19th, I issued a statement to that effect. After my statement of April 19th, I had virtually no contact with the members of the White House staff. I did have occasion to speak with Mr. Leonard Garment. I recall asking him who had placed the no immunity paragraph in the President's statement. Garment said that while he did not know for certain, he believed that Ehrlichman had placed it in the draft because it had not been there in earlier drafts, but in the draft that emerged from Ehrlichman's consideration when Ehrlichman went over the final statement with the President. On April 22nd, Easter Sunday, the President called me to wish me happy Easter. It was what they referred to at the White House as a stroking call. On April 30th, while out of the city, I had a call from my secretary in which she informed me that the wire services were carrying a story that my resignation had been requested and accepted, and that Haldeman and Ehrlichman were also resigning. Mr. Chairman, this concludes my rather lengthy statement. I apologize again for its length, but I've sought to comply with the committee's request to provide the committee with the broad overview of my knowledge of this matter.
Without objection on the part of any member of the committee, the chairman at this time will admit into evidence all of the exhibits identified by the witness in the course of his testimony, except exhibits 5, 6, 7, and 8, which will be whose admissibility will be considered later by the committee. I guess it's no use for them. Tomorrow, I think, what we should have it identified. papers that he turned over to Judge Sarica and just to identify them without putting them in the mailbox. That's a good idea.
You gotta go to town tomorrow.
Yeah. I don't know what I think we might as well recess now till 10 o'clock. The committee will stand in recess till 10 o'clock in the morning.
Well, it's good we finished it.
Well, that is how the longest day of the hearings yet came to an end. The committee will probably spend many more hours questioning John Dean. All the leaked bombshells about presidential involvement in the Watergate cover-up were there as predicted. And there were a number of sidelights that may be temporarily lost as the committee concentrates on White House involvement. There is the charge that the judge hearing the civil cases against the Nixon campaign apparatus cooperated with the White House to prevent anything major from happening before the election. The judge has issued a blanket denial. There was an explanation of how top White House aides were spared the embarrassment of appearing directly themselves before the grand jury, and how one witness was handled very gingerly before that grand jury by the federal prosecutor, but spilled the beans when questioned by a curious member of the grand jury. And there were also the recollections of how the White House tried to influence the Senate Watergate Committee, including ranking minority member Howard Baker, who says Dean's recollections were generally accurate.
Of course, there are two parts to that. The White House's perception of that, and then Mr. Dean's account of the conversation that actually transpired. I think, by and large, Mr. Dean's recollection of that account is essentially correct in all its material details. The account of Mr. Wally Johnson of the White House staff calling me when I was in Tennessee and asking if the White House could have a say-so in the selection of minority counsel. I told them they could not. That accords with my understanding. Mr. Dean's recollection of my brief meeting with the President shortly before a reception that I was attending, at which time I recommended the President against the claim of executive privilege, is essentially correct. I do not recall the President indicating that he would rely instead only on written interrogatories, but that isn't a major point. Now, beyond that, I think that Mr. Dean has pretty generally stated the situation as I recall.
Senator, let me read a memo from, Let me read a memo from H.R. Haldeman to John Dean on a portion of it. He says it was written February 9th, and it pertains specifically. He says, obviously the key on the Irvin Committee is the minority staff and, more importantly, the minority counsel. We've got to be sure we get a real tiger, not an old man or a soft head. And although we let the committee membership slip out of our grasp, we've got to find a way to be sure we get the best man we can for counsel. Does that pretty well jibe also with your recollection of their putting pressure on you to get a counsel?
No, they didn't put any pressure on it. It was a simple request by Wally Johnson on the telephone. He said that he wanted to come to Tennessee to talk to me about it, and I said, Wally, that's not necessary. You don't need to come to Tennessee. He said, well, can we have some input into the hiring of counsel? And I said, no. And obviously your memorandum goes much further than that, but I have an idea that ended the conversation as far as they were concerned, so that's the end of my personal knowledge.
Do you think they got a real tiger or an old man?
No. They got a bright young man who's formerly in the U.S. Attorney's Office in Nashville, who was a trial lawyer, who I knew personally, and they never heard of. Evidence the fact that the President asked me that same day, who is Fred Thompson? And I explained to him he was a big, tall, tough Tennessean who was going to do a good job.
All right, watching the story unfold with us today were former White House aides Stephen Hess and John Kramer at the Georgetown University Law Center. And we're curious, of course, about their reactions to what John Dean said. First, Mr. Kramer, from a legal standpoint, what did Dean's testimony do to President Nixon?
For any kind of criminal conviction, there must be proof of a criminal act and a criminal intent. In this case, the particular crime, I think, at stake is obstruction of criminal investigation. And there you have to show a willful endeavor by means of bribery or misrepresentation to prevent the communication of information relating to a violation of a statute. Here, as far as the criminal act is concerned, I think you have several factors that John Dean pointed to, if you believe his testimony. First of all, the President was apparently involved in two discussions with Mr. Ehrlichman and Mr. Colson about the grant of executive clemency to Mr. Hunt. There was also the question of the payment of cover-up money up to $1 million, which the President said could easily be done. And there are indeed other suggestions that perhaps the president was not very open about precisely when he learned about, from John Dean, learned about the cover-up. At one point in a resignation letter that he gives Mr. Dean, he refers to an April date. Other times he refers to a March 21st date. But that is only the criminal act. The criminal intent, the willful endeavor, is very significant. And it seems to me that Mr. Dean's testimony points up some questions about the president's intent. For example, the president tries to indicate that the $1 million reference was a joke, and that the discussions about clemency were foolish, that he wasn't, therefore, intending to obstruct criminal justice. And that raises some questions about his intent.
Mr. Hess, legal culpability aside, what about the American public and the president now?
Well, Mr. Nixon has to do something, I would think now, in response to very serious charges that Mr. Dean made. He may choose, on the other hand, to think that the time is on his side, that the best thing to do is to keep a low profile as it regards to Watergate. After all, we did see last week with the Brezhnev summit visit that there are tremendous recuperative powers of the presidency. He may choose to take a legalistic approach, as he did in his May 22nd statement of 4,000 words in which he talked about national security, where he attempts in writing to rebut Mr. Dean point by point. He may choose a counterattack strategy. There were hints of it in Mr. Dean's testimony today, the talk about Mr. Nixon's campaign being bugged in 1968. He might choose a mea culpa feeling. There was some of that tone in his May 22nd statement when he talked about how he should have listened more to the danger signs and less to the reassurances. But I hope that what he does is respond personally and forthrightly to the American people.
Mr. Kramer, you said if you believe his testimony, how does Dean stack up on the credibility scale compared with other witnesses?
Well, all we really have to go on at this point is what's come before us. And I would say that at least the early part of his testimony jibes almost completely with what we heard last week, or a week before last, from Mr. Magruder. So on that score, we have some corroboration. It's going to take the rest of the hearings, really, to corroborate piece by piece every other meeting that he describes. Although I guess critical there certainly is that tape, if it exists, of that meeting with the president.
It seemed to me with McCord there was some
Yes.
quite a lot with the McCord testimony.
In fact, I don't really see any significant inconsistencies yet with Mr. Dean. Those may develop as the days go on.
How do you feel about the credibility issue, Mr. Hess?
Well, I think Mr. Dean was an attractive witness. He spoke for 6 hours today in a very low, almost a monotone voice. He's an attractive man, appears to be personally. I think that it'll be very hard to paint him as some sort of villain or demon, at least based on his own presentation.
Well, what would you think of tomorrow's hearings in terms of tomorrow's session? Who would really go after him as a political observer? He kind of threw down the gauntlet to Senator Gurney. Do you think anybody will really go after him tomorrow, and who would you guess it would be?
Well, I don't think he's in for an easy time for any of the members of the committee. They've all developed a different style of attack. But it's been a very useful sort of committee with very interesting regional contrasts and differences in ways of getting at it. Mr. Baker has opened up questions of the morality involved, and so I think we're not going to see any surprises in the avenue of attack from the 7 persons on the committee.
All right, gentlemen, thank you very much. All right, the question, of course, is what more is there to say at this point? Regardless of the time zone where you live, it's very late, and the testimony of John W. Dean III has been very hot, despite the several gallons of water he consumed while reading that lengthy and very historical document of his. Tomorrow the questions begin. Now let's talk about that March 15th meeting with the president, some senator will say, and on it will go. And even more details, if that's possible, will come out. John Dean's memory will be tested and retested and challenged and worked over like a piece of putty. And when it's all over tomorrow or the next day, a lot of people in this country, including all of us and all of you, and most importantly, the President of the United States, will digest and judge what John W. Dean III had to say, and we'll all decide whether or not to believe him. Right now, maybe the best thing for all of us to do is to go on to bed so we'll be fresh for tomorrow. And until then, for Robert McNeil and Peter Kay, I'm Jim Lara. Thank you and good night.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.